I'm okay. So, yes. Attention of the court is drawn. The fact that the writ petition was disposed of by an order dated June 12, 2024. So, however, through inadvertence, the matter appeared in the list and an order was passed on 4th of April 2025. So, in view thereof, the order dated 4th of April 2025 stands recorded.
Your Lordship, I'm appearing on behalf of the respondent in item number 1.
Item number 1, it has been withdrawn. It has been disposed of because relief has already been granted to the petitioner.
Oh,
So, your
I have-
presence will be recorded. You are
Yes,
for the
yes, yes.
CGST authority.
Yeah,
You are for
Yes.
CGST authority.
as well as the DGGI. All the respondent.
All the respondents. Mr.
Ratan Bonik for all the respondent.
Ratan Bonik for the respondent. Item number 1. Yes, call the next matter.
Grateful, my lord.
The name of the councils are not mentioned in the order, madam.
You did not appear, what can be done?
I appeared, my lord.
You appeared.
Yes, my lord. The
You said
cancellation
your name was
of,
not
yes,
recorded.
cancellation of the registration, my lord.
You only appeared or you are?
I along with Pritam Dash.
It has been submitted by the learned advocate for the petitioner that the name of the petitioner, that the name of the advocates representing the state
Yes, ma'am.
was not recorded in the order dated 7th of April 2025.
My lord.
So it is recorded that the following learned advocates represented the state on when the matter was taken up for hearing on 7th of April 2025. So, let the order be rectified. The other portions of the order shall remain unaltered. This order shall form part of the order dated 7th of April 2025.
My lord, I'm sorry. For item 2, my lord, it was already disposed of by
Justice. It was disposed of, that is,
Great,
through
great.
inadvertence an order was recorded. Yes. Or
In my understanding, no correction needs to be done to this order.
no correction is to be done.
No, I don't know why it was mentioned. I've been informed it was mentioned on behalf of the National Highway Authorities of India for correction,
Yes.
but no such correction is required. If I can have my words for a moment on the petition,
Where is the learned advocate for the?
missing used to appear for National Highways.
Can you inform him because I do not know.
I will inform her. I will ask my junior.
ওনার নাম কি রেকর্ড হয়েছে দেখুন
Supriya Singh.
সুপ্রিয়া সিং নামটা রেকর্ড হয়েছে
হ্যাঁ।
অলরাইট আই এম পাসিং ইট ওভার ইউ ক্যান ব্রিং হার ইয়েস yes call the next matter.
Lord, I am for the petitioner.
Lordship, I'm for the respondent. I'm led by Senior Counsel Mr. Shomo Mujumdar, who's appearing.
But I think I
What
appear
is
for the
instruction?
university.
My lord, I am for the petitioners led by learned senior Mr. Saurabh Ganguly. My lord, he is appearing before the Honorable Division Bench of Justice Boshak. So upon his instruction, my lord, I am submitting.
You will submit, all right. Yes. Where is the college?
It's the Shiliguri.
Yes, who is the learned, where is Mr. Pal Chaudhary? Yes, what is their instruction?
My lord, I'm for the petitions, my lord. My lord, actually, on the last date, my lord, yesterday, it appears that the time limit is very short. Because our submission was that, my lord, the results of the 6th semester which needs to be published immediately. And thereafter, we should be allowed for the 7th semester examination so that I can be regularized with the 8th semester examination with my batch. Now, my lord, the submission was made by the university and the college that the time limit is very short and it is not possible for them. Now, my lord, at this juncture, I would like to refer just one notification of a government service. My lord, this is a notification issued by Hindustan Aeronautics Limited, a government enterprise, my lord. Kindly see the qualification at the bottom, my lord. Graduate technical qualification, regular 4 years. And this notification issued on 4th April 2025, my lord. Now, my lord, if I have to wait for another year that the college and university is submitting that I have to sit in December 2025 for the examination, then I shall not be a regular candidate, my lord. And by this,
Mr. Mojumdar says that he will be regular. Mr. Mojumdar, if he is allowed to sit in the which semester?
seventh semester,
Seventh semester in December 2025.
they were submitting, my lord.
In December 2025, shall they be treated to be regular 4 years?
Yes,
Or-
yes, because we want to protect the interest of the students. There was a dispute between the college and the students, but we shall treat him as a regular student.
Mr. Mojumdar.
Otherwise, what the writ petitioner proposes is he wants to complete 4 semesters in 1 calendar year, which will irregularize him.
Mr.
This will
Mojumdar,
create an
then,
irregularity.
so, yes, he say, what Mr. Mojumdar says is that if you appear in December, you will be treated to be regular. But if you are directed or if you are allowed to appear previously on any other time, you will not be treated to be regular. That is his.
Because this will lead to, I shall try to explain why. This will lead to the petitioners having appeared in 4 semesters during 1 calendar year.
That is the difficulty.
Actually, my lord,
Please, you take instructions. If you do not want to be treated as regular, because university says if you are permitted, then you will not be treated to be a regular. And I can direct the university to file an affidavit stating that in case you are allowed to sit in the 8th semester in December 2025, or as Mr. Mojumdar submits, that you will be
Yes.
treated to be regular. Mr.
Yes,
Mojumdar, to that effect, you have to file
Yes, of course.
an affidavit merely
Yes, my lord.
because on the basis of submissions, it cannot be done.
No.
Because,
I don't want to.
subsequently, the university may
Yes,
say,
yes, no.
the advocate was not instructed to make this submission.
No. Of course.
My lord,
We shall
then
keep it
short
in mind.
possible. I am just taking instructions from the petitioners. If they are filing that written submission
Yes, that
affidavit.
they have to do.
Yes, my lord.
So, Mr. Mojumdar, when they will be allowed to sit for the 7th semester?
The 7th semester examination is due in December 2025.
Oh, 7th is in December 20, all right. 7th is in December. December 2025 and 8th.
8th is June 26. Before June 26, should be before June 26.
Before June 26. So latest by June 2026.
Yes.
So when the regular 8th semester exams will be taken.
Yes.
Mr. Mojumdar, when the 7th semester is due, it's in December 2025.
December 25.
Why not in June? One semester has to be in June.
Yes, because you can't, what even 6th semester normal is due in July 25. That's the even semester.
But one thing, Mr. Mojumdar, they appeared in the 6th when you appeared.
June 2024.
June 2025.
2024. My lord.
2024.
Sorry,
Pursuant
June
to-
2024. So can
Right.
them not be allowed to sit with the regular 7th semester in the
Yes, my lord.
June?
But I tell you, Lord, I tried to submit, but why they should not be allowed. First of all, the results were not published because of interim order passed by this honorable court. Secondly, for every semester, there has to be certain assessment which is to be made by the college and updated on the portal of the university. This assessment has 4 characters. 1, 4 internal assessments through theoretical examinations and 2 practical examinations. And the academic calendar is given before the commencement of the course. Now, for these students, we have not received from the college the internal assessment as well as the practical.
Yes, Mr. Majumdar, I follow you, but according to the pursuant to the order, the petitioners were allowed to attend the
Seventh.
classes of the seventh semester. So if the
Sixth
college,
semester, sixth semester.
no,
Seventh
six,
semester,
seventh.
Seventh semester.
Seventh they attended. Sixth they appeared in the exam, but the results were withheld. But seventh they have attended the classes.
Internals also given.
Please come to page 56 of the writ petition.
Yes.
Now, that's an order passed by the court note when the writ petitioners approach the court for filing, seeking to appear in the seventh semester.
No,
Now, please-
to participate in the seventh semester exam, yes.
Yes, please come to page 58 straightway.
Yes.
Now, the paragraph beginning with the words examination of 4 papers under 5th semester will be
Yes.
held in the month of January 2025. And in the event that qualify in 4 papers under 5th semester, in that event only, result of 6th semester examination of the petitioner shall be published.
So, but
In
they
view of-
participated, Mr. Mojumdar, this order was passed on December 2024.
Before
When-
December 24.
December 2024. So on that, at that particular time, the petitioners had appeared in the 6th semester. But since some of the papers they could not get the qualifying marks, I think they were required to.
No, That's in the 5th semester.
yes,
That's in the 5th semester.
5th semester exam, 4 papers only, not the classes.
5th semester, they have
only 4
all of them
papers.
have not cleared as yet.
Yes, no, 5th semester, so 6th semester exam they had given, and that results were directed to be withheld, subject to the publication of the 5th semester results.
6th semester was directed to be withheld. 6th semester was directed to be withheld.
Yes, 6th was directed to be withheld, subject to the publication of those 4 papers of the 5th semester. Now the
Yes.
fact remains, 5th semester they have cleared. The results
Published.
All of them they have participated, so they can. There are
Results
backlogs
published,
which they can clear with the 7th
no,
semester.
results, Mr.
Published.
Mojumdar, have been published.
So
So
3
they
or
have cleared, you have cleared.
Qualified.
no,
Milord.
no, all have not
They
cleared. All have
They
not
have
cleared.
qualified.
Qualified. There are
So
submitted.
now,
We have to give backlog papers. 3 have not passed in all the
That can be
subjects
given
of
in
the
the
5th
supplementary
semester.
examination.
no,
Milord.
yes, passed in those 4. Have you passed or you have not passed?
Milord passed,
No,
and
no, no.
there are some backlogs, Milord, that can be
That's
cleared
why.
during supplementary examination.
Another backlogs are also there.
There, that can
Yes,
be given
yes.
in the supplementary, but I'm
No,
qualified
there is
to
no
attend
supplementary.
But
Fifth
Milord,
has to
I'm
be cleared.
qualified to attend in
Backlog
the
in
7th
fifth
semester
has to be
classes
cleared with
and
the 7th.
it in the 7th semester examination as well.
And these backlog papers with.
There
which
is a
exam?
provision for special supplementary exam that
No,
that is
no, no,
taken
no, no.
for the students, and I am ready to give that, Milord.
Backlog has to be cleared with the odd semester of the being the 7th semester.
Yes, so, yes, one minute, Mr. Mojumdar. Yes, did the petitioners attend the 7th semester classes? 7th semester and 8th semester. They have attended all of it. All right, but they have attended. All right. So now, what Mr. Mojumdar says, that there are some internal assessments and other things. What happened to that? Have you made that? Any results have you uploaded in the portal?
Because we didn't upload it to the university portal and because the 6th semester result was we can.
But these assessments were made.
It was done.
Assessments were done.
Done.
Because that was not, uploaded it.
All right. Your case is that these all formalities were completed.
Yes.
They participated and all assessments have been made. But since this was unofficial, those have not been
As because-
uploaded in the portal.
As because the 6th semester result was written.
That was not uploaded in the
Lordship.
portal. So, Mr. Mojumdar, the college says that they have assessments have been done, but because of this, it could not be uploaded. So
No,
that
this
can
is
be
the-
directed to be uploaded.
No, this
You
is
can
this is the
consider that.
this is the problem not which the college is creating. Not I don't know not whether there is some understanding between the petitioners or the college or not. Not the learned advocate on record is there in court. Please, I request her to hand up the academic calendar. This will probably dispel with all doubts. Not there are there is a bunch of papers not which I request my learned friend to hand up to your lordship. Not there is an academic provisional academic calendar which will give an indication of the manner of assessment with the timetable. And not once this is over, no college can upload this on the university portal because there is a time schedule which we have to follow in terms of the UGC guidelines.
No, yes, Mr. Mojumdar, time schedule for this particular petitioners could not be, it
Yes.
is not the case that the college did not follow for others. It's only for the petitioners. For this reason, it could not be published. If the
Not-
assessments have been done, they have attended the requisite number of classes as per the rules, university rules. If they have attended and all, if the assessments as per the guidelines of the university has also been made. So what is the difficulty is only they will be publishing that. You
No,
can
that-
verify that, Mr. Mojumdar,
No, that-
you being the authority, you can verify that.
Yes,
Whether
no,
it's
that's
correct, these assessments were made, you can verify that.
That's the problem, not why the UGC as well as the university felt it necessary to frame this within a time. Not every time. Suppose not as there is a late entrant in the course by a student, and the college and the student they agree that we shall prepare a practical book and hand it over to the university at a later point of time, despite the student not having attended classes. So not it is not possible for the university to monitor the everyday assessment of the attendance of the students.
Mr. Mojumdar, this is not a case of the initial entry into the course.
No. Please
For
have a look
some
at the time.
reasons, court also permitted them to sit for the supplementary exams and other things.
Not supplementary,
Also
the
protect-
semester exam with the corresponding
All right.
backlog. Please see the timetable. This will probably eradicate that doubt. Please see now what is the requirement of submission of assessment. Please see that it is probably handed up to your lordship. दिखे करो ना भाई जे ऐसे जाके. Now, there is a provisional academic calendar for academic session 24-25 for affiliated colleges. Has your lordship got that?
Yes.
At commencement of academic programs, old semester 24-25.
Yes.
3rd, 5th, 7th and 9th. No, this is for the odd semesters.
Yes.
Start date is 15th July 2024.
Yes. So according to you, this calendar has not been followed.
And not only the calendar, please come down to the event semester of 2024-25 and the odd semester of 24-25. There is a series of submission of internal assessment with practical examination.
No, this is to be done before the university or with the college.
The college does this and sends it to the university within time for verification. This is the only way we can supervise and monitor the admission and the continuance of course of by the student.
Done everything, but could not send it to the university as because by virtue of an order, the 6th semester result was withheld.
This had got nothing to do with that.
One thing. And another thing is that what Mr. Mojumdar was submitting, your junior was there, you were not there.
Lordship, I
says-
apologize. I was
No,
in
no,
the
no.
division bench.
I'm not blaming you, please. For the purpose of clarifying what Mr. Mojumdar said, he said two things. One is if if directed, he can file an affidavit to the extent that if the petitioners participates in the 7th as well as 8th, at the time along with the other regular candidates, then he will be treated to be regular candidates. Otherwise, in other cases, you may not be treated to be regular candidates, which may create difficulties in the matter of getting employment.
Lordship has seen that thing.
So that is one thing. For that, you can take instructions. Other thing which Mr. Mojumdar is trying to emphasize is that there is a calendar
Lordship.
as per the
Lordship,
UGC and the
yes, Lordship.
university also. So he says, so all these internal assessments and other things that are to be done, and there's a procedure for uploading also within the time limit. Because he says maybe for some internal arrangement, may not be your case. In other cases, there might be some internal arrangement between the students and the college. They are not actually following that, but it's being uploaded. So for that, in order to protect that, the college may be directed to disclose all these facts, or in order to obviate all these things, if the regular procedure can be started from once, that can be started with effect from some date, then the other subsequent process can be regularized. This is for the benefit of your clients.
Lordship, only one thing.
Otherwise, these
I understand,
litigations and other
I
things,
understand,
this
Lordship.
will
I
continue.
understand, Lordship.
And
I understand, Lordship. Only one thing I would like to place before Lordship for kind consideration, that is the dispute which we are facing at present. cropped up not due to the fault of the students.
I appreciate that.
And on each and every occasion, we had to appear before the court to
Yes,
even
for
sit
that
in the
you are
examination.
suffering. So nobody knows what will happen, because if you are allowed to participate in the 7th semester at a time which is not for the regular, and these internal assessments, these have not been complied with. Nobody knows what
But
has
Lordship,
happened.
in that case, the 4-year course, we have to complete in 5 years. So this problem will be there.
What?
The,
No, that according to Mr. Mojumdar, the university will treat you as a regular 4 year. That certificate, that affidavit that the
Lordship,
university
then,
has to file.
please allow me to take instruction from the client. There's both students.
Yes, yes.
I may come back to
The difficulty would be in 2 months, he will be clearing 3 semesters. He will be
That
trying
is
to
the
clear 3
difficulty.
semesters.
I understand.
That is
I
the
understand.
difficulty. So in 2 months, even if you say, yes, I'm ready to give 8th semester within June, even physically, you may be very academically very sound, you can also perform well. I'm not disputing your capability or your academic performance. But the fact remains, this time frame that will be on record.
And this will
So,
make him irregular. This will make him
So what
irregular.
plays in the back of the mind of the client is that this is a 4 years course, it becoming
So
5
that,
years.
that Mr. Mojumdar, you will
That
file an
happened with us
affidavit that they
also.
will be treated to be,
No,
you have to
that happened with
specify when they
that-
will
that
appear in the
happened with
7th
our-
and 8th. Yes,
that happened with our LLB course also. Not we were 6 years past.
yes, yes.
Lordship, may I return
So,
with the
in the
instruction?
initial, now I think it has been almost regularized.
Almost
Initially, at
regularized.
the starting time, it was
Yes.
5 years LLB, was 6.5 years.
But-
Initial at the time of starting.
But there is a
But
difference.
they are all treated as 5 years.
But
LLB.
there are difference, Lordship. The LLB, they can practice independently, but the
No.
student, engineering
Practice
student
independently is one thing, even if you go for a job.
job. Right.
So you will be treated to be a 5-year
Lordship,
LLB.
may I come back with the instruction?
Please
talking
take
to the student?
instructions, and Mr. Mojumdar, you will have to file an affidavit to that effect, that when
Yes.
they will be allowed to participate, and with the other backlogs, please take concrete instructions.
Yes, yes. No,
Members,
there
when
are
they will be,
July 25 is the 8th semester. No, December 25 is the 7th semester exam for them, and May or June 26 is the 8th semester exam for
in
them.
date is June 26 for the 8th. How many
Yes.
semesters are there? 8 or 10?
8.
So 8 is the
4
last.
years to
So 8th semester is the last one. So till June 2026, that is the last or the
1.5
outer
year.
limit. Outer
If
limit
they
of
wait
the-
for 6 months, their 4 years academic course will be regularized. If they wait for 6 months.
that is.
But this proposition has to be submitted before the court in writing, black and white.
Yes, yes, yes. Has to be on affidavits.
Yes,
That
yes,
has
of
to be
course.
that.
Lordship,
Mr. Mojumdar has agreed to that.
please allow me to return tomorrow with talk with the
Tomorrow at today at 2 p.m.
Today to be. Yes, Lordship, today to be.
Mr. Mojumdar, how are you placed at today at 2 p.m.?
But I shall be before your lordship, virtual.
Yes,
Lordship.
because this is the career of the students.
Yes,
And
yes, of
please
course.
take instructions with regard to this affidavit.
Yes, yes, of course.
Because
But
otherwise,
that's But my learned friend is not appreciating the difficulty that in May 2025, if he sits for 3 examinations,
Mojumdar,
We appreciate-
it's not the question of your learned friend appreciating. It's the clients whom your
Of
learned
course,
friend
of
is
course.
representing.
when I
Because-
say my learned friend, I mean my learned friend's clients. The students are not appreciating.
Because you also will appreciate, because they have
I
6
understand
months
their agony,
more they
of
have
course.
to. That
Their
is the
agony.
6 months tenure is in a
But
career.
But the university wants to advise them through me that if they wait for 6 months, then their 4 years academic pursuit will not be ending in a failure.
The Mojumdar, your university could have done by asking the petitioners to come to them. They could have explained it in a much better way than what you are explaining to the court now.
No communication whatsoever in the.
That these litigations would not have cropped up even.
Should
You
not
being
have,
the guardian of the students of the or the candidates.
should not
It
have, but
been
not,
done by your university.
yes, not had the students come to us on a basis, then we could have certainly explained it to them. But the college is there, not what can be done. We are trying to protect the students because of the default of the college.
But no
Don't
communication.
fight on this. Take instructions.
Lordship,
If
2
it can be
p.m.
regularized
2 p.m.
by 2 p.m.
Grateful, Lordship.
Yes. 2 p.m. Yes, Dr. Paljuni, please come back.
I'm for the petitioner.
All right. Yes,
In this matter,
you
petition,
are for the state, yes.
petitioner is
You are-
praying,
This is, what is the issue?
petitioner is praying for release of pensionary benefits and other benefits. Petitioner is the 88 years old lady, residing
not
with her
releasing
two
pension?
minor grandchild,
Why are you not releasing pension? Already consider his representation, take a decision on this. Who will consider?
The district inspector of school Coach Beer,
Where is the representation address to the?
26,
26. The petitioner states that his son,
namely Tarapada Sarkar, who is a lab assistant in the Goshanimar High School.
who are the petitioners?
Petitioner is the mother of the deceased and to his son, one is son and daughter.
The petitioner number, the petitioner is, petitioners state that the son of the petitioner number 1, namely Tarapada Sarkar, while working as a laboratory assistant in Goshanimari High School, died while in service. He died
While in service.
in harness on May 22, 2023. Leaving behind him surviving is 2 children, 2 minor children. That is the petitioner number 2, petitioner numbers 2 and 3, who are being represented by the petition. The petitioner state that the family pension on account of the service of the deceased son of the petitioner number 1 has not yet been released in favor of the petitioners, in spite of several representations being made in that regard. Paragraph. The learned advocate appearing for the petitioner submits that the petitioner has submitted a representation dated 4th of March 2025 before the District Inspector of Schools within bracket secondary education bracket close, which we are praying for releasing the pension and gratuity in favor of the petitioners. Family pension and gratuity in favor of the petitioner. The honored advocate appealing for the state submits that but till date, no decision on such communication has been communicated to the petitioners. Paragraph. The learned advocate appealing for the state submits that the decision on the representation shall be taken and communicated to the petitioner within the time limit as may be fixed by this. Paragraph. Without entering into the merits of the claim made by the petitioner in the said representation, WPA 706 of 2025 is disposed of by directing the District Inspector of Schools, secondary education, which we are in the third respondent hearing, to consider the representation of the petitioner dated 4th of March 2025 and to dispose of the same by passing a reasoned order after giving an opportunity of hearing to the petitioners, or any other interested parties who may be affected by the said decision or their authorized representatives. Needless to mention that the reasoned order shall be communicated to the respective parties immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order, along with a copy of the representation dated 4th of March 2020.
Extremely grateful, my lord.
Yes, if it is service taken on record. Yes, next.
Number 7, Lordship, service has not been completed yet. I am praying for next update, Lordship.
What is the writ petition for?
Lordship. And conducting advocate is also out of for medical urgency of his wife, but kindly next update.
Since
Milords, item number 7, Milords, I appear for the state. I am assisting Ms. Bose in this matter, Milords. It was just filed yesterday. Milords, returnable date is on 11th. We don't have any instructions, Milord. Kindly post it on Friday, Milords.
Lordship, next circuit is because conducting advocate wife is busy.
an accommodation has been paid for on the ground of the learned advocate on record of the petitioner. The learned advocate appearing, the learned advocate representing the learned advocate on record of the petitioner raised that matter be placed before the next circuit as paid for by the learned advocate for the petitioner. This matter before the next circuit.
Grateful, Milords.
Item number 8, I beg to appear on the.
Look, item number 8, I am appearing on behalf of the respondent number 8, Milord, virtually.
Yes.
Lordship,
Respondent number 7.
Lordship, this petition pertains to the construction of a tower, mobile tower, without getting any permission from the competent authority, Lordship. This has been first of all. My Lord, kindly come to the page number 20. Kindly. 20.
Yes.
My Lord, this is the statutory circular of the government, West Bengal Government Pollution Control Board. That is para number 3. Whereas, may I read, my Lord? And whereas in this regard, West Bengal Pollution Control Board, there will be referred as to the state board interacted with the Ministry of Communication and IT Department, Telecommunication, WPC, SAFC, FA sector, Government of India, wherefrom it has been come into the surface that for the installation of mobile tower, the following norms need to be complied with by the mobile tower companies at the time of installation mobile tower. That is been 1, Roman 1, 2, 3. Roman 1, the site clearance should be obtained from the Ministry of Communication and IT Department, Telecommunication, Government of India. Permission should be obtained from local authorities like municipal corporation, municipalities, Gram Panchayat, etc. This is my Lord. The respondent authority, private respondent number A7 has not got any permission from the local authority as per the guidelines.
It's a very backdated circular you are. Subsequently, a scheme has been framed.
Lordship, that
has been
But
constituted.
in 2023, Milord, the scheme is of 2023. One Windows, Milord.
that is
2010.
2010,
Still
but
window
Lordship,
clear.
that this
Thereafter,
guidelines has
a sea change.
this has been not been changed.
only apply in the portal.
Thereafter, a sea change has been made. An authority has been constituted. Are you aware of those?
Lordship,
You are not aware of
Lordship,
this.
in
You are
this,
annexing a circular of
Lordship,
2010.
in this context, a writ petition has been.
This is my Lord, second round of the petition, my Lord.
Writ
Second
petition-
round.
Sir,
second-
did you
second,
bring
sir.
to the notice of the court?
Yes, Lordship, and
the
that is.
current notification? Show me the current notification.
No.
Show me your
Lordship, kindly allow it that in context, the writ petition and file in that.
Maybe, but did you place the subsequent notification?
Lordship, when at that time, the competent authority has been agreed.
There are series of judgments on this issue as to whether installation of a mobile tower amounts to pollution.
No
Parent
pollution. Lordship.
judgment is of Gujarat High Court.
Gujarat, Lordship, that has been pollution,
So you
but
know all these.
Lordship,
This is pollution, you say.
Lordship,
This is a circular issued by the pollution control.
Pollution Control Board, but the permission has been required because
What
of
is the
the
date of the judgment of the Gujarat High Court?
Lordship, 1990, that has been in the year 2012, I mind. 2012, I think, Your Lordship.
And you are referring to a circular.
Lordship, I am not going into policy, Lordship, but there has been criteria, there mandate that you have to obtain permission, Lordship, and that has been agreed. In a kindly, Lordship.
Yes, sir. Who
Lordship.
is representing the respondent?
Lordship.
number seven?
Respondent number 7, Milord, I am representing Milord, the latest circular which your lordship is referring, Milord, it's the
Lordship.
Department of.
Yes.
Yes, Milord, that single window, Milord, clearance permission is being, Milord, granted in favor of the private respondent number
Where is
7.
that?
So, Milord, the question and Milord, rule 4, Milord, I can share the screen if your lordship, Milord, gives me.
Yes, yes.
Just, yes, Milord, just I am
Mr.
sharing.
Permit to. Screen sharing the permit.
Permission.
Yes, Mr. Mukherjee.
Sharing. If your lordship, just give me a. Milord, your lordship, Milord, if your lordship ask your lordship's officer, Milord, to enable, Milord, so that I can share the screen. Here, Milord, it's showing that host is disabled. Milord, it's showing that disabled. It's showing.
Already you are having the requisite permission.
Yes, Milord. Requisite permission, Milord, from the office of the nodal officer, no objection certificate. This was not obtained, Milord, in a single window system. And your lordship knows, Milord, rule 14 of the 2023 rules, there is a dispute resolution, Milord, mechanism for which, Milord, yes, Milord, in of course, yes. So, Milord, in any event, Milord, now after this 2023 rules, Milord, no writ petition can be entertained by the, Milord, concerned High Court in view of this, Milord, dispute resolution mechanism. He has to approach before, and usually it's the concerned, Milord, district magistrate who takes up, Milord, this.
Lordship,
So,
district
Milord,
magistrate
in any event, if your lordship, Milord, being an officer of the court, if your lordship,
Page number 46. Kindly page 46.
But if your lordship keeps
there
the
is a
matter,
direct-
Milord, for any day, I
46.
can, Milord, by way of, Milord,
46.
report,
And
in the
that
form
the
of
private
an
respondent
affidavit, can submit
can appear at
everything.
that time. And there is a
All right. So the direction was passed without obtaining prior permission. They
Lordship.
say they have permission.
Lordship.
Let them file affidavit.
Let them
Yes, sir.
file-
What is your instruction?
my lord, mobile, my lord. Let the private is not.
All right. What is your instruction?
My lord, the instruction says the same what has been stated by Mr. Otis, my lord. They have the
They have the permission.
yes, my lord, from the
But-
Anumati portal, my lord, by the nodal
Yes,
officer.
yes, that is, Milord, now the local authorities' permission are no more necessary.
And
Yes, yes.
local authority permission is not necessary, my lord.
Lordship,
And
that-
earlier
These are
direction,
Old circulars. That is why.
my lord, in the earlier writ petition also, there was,
they have been admitted that there is no permission. That is been.
no, we have
yes.
not admitted that.
Yes.
Where they have it?
46, page number 46. The
Yes.
learner appearing for as well as the respondent number 6-7. My lord, my learned friend has appeared. This
Permission of the Gram Panchayat, it was.
No.
Where it has been admitted?
Yes, yes, that is no more
It is
necessary.
submitted upon the inquiry. Yeah, last para. It was found that the mobile tower is question is being constructed without obtaining requisite permission. Lordship.
So
They have been-
now what do you want? It has been constructed.
Lordship.
You want removal?
Oh, my lord.
You want removal?
No, Lordship, if they have been got permission, that there be. Let be a affidavit file, and if there are no permission, there is be. So
That is the order, then why have you filed that?
Lordship,
No permission,
yes,
they
yes,
cannot do. If there
Yes,
is
Lordship.
permission, they can do. The petitioner, the grievance of the petitioner is that the private respondent has erected a, sir, you are not using a mobile phone.
Lordship, yes. But
Why, sir?
because
Your
my,
client is also using a
No.
mobile phone.
My lord, may I state-
my
Your
lord,
client is also using
no,
a mobile
that
phone.
is been admitted.
Petitioner is a relative of the
They have been
person.
erected that they have been they are on the place that is not been they have been not granted any permission.
My lord, he is suppressing the main issue.
Who are you? Where are you residing?
I'm the same local.
My lord, he is suppressing the fact.
Yes, I am the adjacent property.
Adjacent property.
Relative of the person on whose property the tower is being erected. He's jealous of him that
No,
tower is,
nothing else.
that's why he has-
There is a representation of every inhabitant of the property
Your
locality.
client, which mobile SIM he is using, so I think this Indus company has not given the SIM of that company.
No, Lordship, that is not.
That might be a risk.
Not Lordship, that is.
Yes,
Milord, to every Milord mobile company.
Get a SIM of your mobile company.
No,
Used to
Lordship,
Milord
that is not.
mobile tower.
But these type of writ petitions were moved earlier. Nowadays,
But my lord, there was an earlier direction also that without prior permission, the respondent.
at that point of time, the issue of pollution, health hazard, these, that, were there. Now everything is gone.
But permission is concerned, Lordship. There will be
Permission by whom?
Local authority is required.
No,
Not required.
no, sir.
Lordship.
And you have not impressed upon the coordinate bench when this order was
No,
passed.
Lordship, even they have been admitted.
They are not the authorities, sir.
They have been admitted because of the Lordship.
What they will say? If they are not the authorities, they will say, we have not given permission.
Lordship, even if private respondent is a party there.
Just saying that whether he has obtained permission from your learned friend, he will say no.
Even private respondent has not been appeared.
The grievance of the petitioner is that the private respondent number 7 has installed a mobile tower without obtaining requisite permission from the competent authorities. First up, the learned advocate appealing for the petitioner draws the attention of the court to an order dated
6th September 2020.
February 14, 2025, passed by a coordinate bench in WPA 224 of 2025, wherein the coordinate bench, wherein it was held that the mobile tower company shall not proceed with the construction of the mobile tower without obtaining prior permission from the competent authority. So, the paragraph, Mr. Mukherjee, learned advocate appearing for the 7th respondent / mobile tower company, submits that the 7th respondent have obtained requisite permission from the nodal authority.
Yes, my lord.
From the nodal authority, Milord, of the Milord single window clearance and permission setup.
What is the name of the rule, Mr. Mukherjee?
Yes, Milord, read. Yes, the rule is, Milord, West Bengal Telecom Infrastructure Guidelines, comma 2023.
Infrastructure guidelines. West Bengal Telecom
2023.
Infrastructure Guidelines 2023.
Yes, I have.
And
Yes, Milord.
you have got that. Please give me that.
Yes.
You are hiding that.
No, my lord. My lord, I have also submission in this regard.
But you have not annexed that. You have annexed the circular of 20.
No. That has been I have been obtained.
Yes, Mr. Mukherjee.
Lordship.
What is which
Aqua.
says permission from the nodal authority?
Lordship, kindly
Yes, Milord.
in the
From the
circular I have
Get
been
off.
submitted, Lord.
Yes, Mr. Mukherjee. Which rule or which paragraph?
window.
You will know.
Lordship, in this case, I am para number 9 is my.
Have obtained requisite clearance and permission for setting up the mobile tower.
Milord, the appropriate authority is being defined. Rule 4 and Rule 14, Milord, these are the two rules.
In terms of the 2023 guidelines. He further submits that the state guidelines provides for where is the grievance redressal? Which, yes,
Milord, Rule 14, Milord. Rule 14.
Paragraph 14 of the state guidelines provides for a dispute resolution mechanism. So, the paragraph third paragraph, the learned advocate for the state. No. The learned advocate appearing for the state submits that the seventh respondent has already obtained the requisite permissions from the competent authority. Gustav, paragraph, this court finds that the 2023 guidelines have
My lord, on behalf of the state, we are filing the report, my lord.
That paragraph 14 of the 2023 guidelines provides for a dispute resolution mechanism. It
Between the
says that
lordship, that is.
any dispute arising between the applicant licensee and
Awarding authority.
permission grant awarding
Permission is not. It is not.
out of disposal regarding an application seeking to establish telecom infrastructure clearance, that is setting up mobile tower or BTS and / or laying of OFS, either permission
Optical fiber cable.
new or renewal shall be redressed by the SLCC within the prescribed time frame. In case if any dispute remains unresolved by the SLCC, then the issue will be heard by the state level appellate authority to be headed by the additional chief secretary / principal secretary / secretary of the Department of Information Technology and Electronics from a government of West Bengal, which shall have the power to amend, cancel or endorse the decisions of SLCC within this established time frame. Gustav, but Mr. Mukherjee, this does not deal with any
With the
dispute.
Private
with the
party.
Third party.
Third party, that is
And
not.
that.
That is not, yes. Lordship, that
My
has
lord,
been.
this is my lord, in
awarding
regard to,
and-
my lord, any establishment, if any dispute arises,
It says any dispute between the licensee and
Licensee
the permission awarding authority,
Awarding,
not with third party.
third party, that is been here.
However, the clause, paragraph 14 of the 2023 guidelines only provides for resolution of dispute between the licensee and the permission awarding authority. Gustav, paragraph, the the seventh respondent is directed to file an affidavit disclosing the permission granted by the competent authority by filing a report in the form of an affidavit.
My
that stuff, let such report in the form of an affidavit be filed within yes, how soon?
my lord, 2 weeks.
Within 3 weeks from there. So this matter, parties will be at liberty to mention this matter for information after expiry of the period.
Everyone reply, Lordship, your opposition.
After expiry of the period is for filing of the report.
Every bit. Lordship.
Yes. I follow state.
My lord, in this present case, my lord, the petitioner, my lord, he has been falsely implicated in a case under the Narcotic Drugs and Psychotropic Substances Act, my lord. My lord, I would refer to one complaint, my lord, I've annexed to my application, my lord. It's appearing at page 25, my lord. My lord, this was a complaint given by the petitioner, my lord, against the respondent numbers 10 and 11, my lord.
Yes.
My lord, the respondent number 10 and 11, my lord, they approached the petitioner and my lord, they tried to forcefully coerce him into becoming an informant, to which the petitioner refused, my lord. My lord, upon his refusal, my lord, he was assaulted by these two persons, my lord, that is the respondent number 10 and 11, and he was threatened on several occasions that he'll be falsely implicated in cases. My lord, I gave this complaint before the commissioner, as well as the inspector in charge of Bhaktinagar police station, my lord. My lord, they are also party respondents to this application. My lord, they received the complaint, my lord, there were no steps taken. My lord, subsequent to this, my lord, I was implicated in the criminal case on 19th of September, my lord. Now, my lord, after the criminal case, my lord, I gave a subsequent representation, my lord. My wife had given the representation. I've annexed the same, my lord. It's appearing at page 27 of my application, my lord. My lord, there are two representations. One is at page 27, and my lord, the other one is at page 29, my lord.
Yes.
My lord, I was arrested, my lord,
falsely implicated, my lord. I'm picked up from one particular place. My vehicle is taken under the
So
custody of
according to
police.
you, no steps have been taken pursuant.
My
to
lord, I
such
had
complaint.
prayed for just preservation of a CCTV footage, my lord. My lord, I've annexed the orders of the learned court below, my lord. It starts from page 41. My lord, on 30th of November, my lord, I prayed for preservation of the CCTV footage and the,
Before,
my lord, this is right after my implication in the criminal case.
so where did preservation of the.
My lord, I
CCTV
prayed before the special judge, my lord, the NDPS.
Before the,
My lord,
what happened before that?
my lord, before,
What happened to your application?
my
Prayer
lord,
has been allowed and no, with regard to your prayer for preservation of CCTV. footage.
my lord, I'm coming to that, my lord. My lord, kindly comes to page 47, my lord, of my application.
Yes.
My lord, this was again last taken up on 17th of March 2025. My lord, kindly notes this down that, my lord, I had made my prayer before the court on November 2024, my lord. My lord, March 2025, my lord, 17/3/2025. This application is brought to the knowledge of the court. It was not heard. My lord, thereafter, my lord, on 21st of March, which is the next page, my lord, page 48. My lord, this is the first time a direction is given, my lord. And my lord, as per instructions, my lord, I have been informed that on 29th, which was the next date fixed, my lord, of March, my lord, they came up with a report stating that we have not preserved it.
Accordingly, a report we called for the
My lord.
complaint and the traffic. What about the availability of the CCTV footage? That order was passed.
Yes, order was passed, my lord.
Yes.
My lord, the entire delay, my lord, from 30th November 2024. My lord, that is the only way I can prove my innocence. My lord, I am being apprehended, taken out of my vehicle, taken across this other side of the road, put into another vehicle which belongs to the police
What
personnel.
order you are seeking from?
My lord, I'm praying for change of investigating agency, my lord. I'm not praying for bail or, my lord, any interim relief otherwise. My lord, I want a fresh investigation to be done, my lord, by a,
So let them file their affidavits.
my lord, my lord.
In petitioner 6, transfer of investigation. From the present investigating agency to an independent investigating agency. So such an issue cannot be decided. Now, such an issue has to be decided after exchange of affidavits. First of let affidavit in opposition be filed within 3 weeks from date, 4 weeks, 4 weeks from date, reply thereto if any be filed within 2 weeks thereafter. The parties will be at liberty to mention this matter for inclusion in the list of hearing. After expiry of the period.
Great.
That is great.
My lords, I beg to appear through VC, my lords, for the petitioner.
Yes.
My lords, the petition is aggrieved by the order dated 13th of December 2024.
Agreed by the order dated?
13th of December 2024, annexure P9, my lords.
Yes, yes.
My lords, the petitioner was not naturally amenable to jurisdiction of the Act, my lords. Due to the improper guidance and an illegal enrichment of the consultant, he ascribed to the scope of the Act. Now, the consultant ensured that I will take care of all the compliances with respect to the ASI Act and its compliances. Now, he passed away in 2019, and thereafter there was no correspondence with the petitioner and the consultant, my lords. And thereafter, these proceedings were initiated against the petitioner under the 45A of the ASI Act, my lords. And the scope of appeal was available to the petitioner. The 60 days time period was there, my lords. But as the petitioner was not at all aware of the compliances, my lords, that's why he could not appeal with respect to the order, my lords. And he got to know about it, and thereafter he's approached this honorable court to condone his ignorance, my lords.
Yes, so there is a provision for extension of the time limit in the
My lords,
act.
my lords, the difficulty is the particular the appeal under 45AA, they don't entail any coordination of application, my lords.
Then it's gone.
My lords, the petition seeking the magnanimity of this court, my lords. I would be constrained to, my lords, the simplicity of the proceedings which under 45AA would be left out, my lords. Where I can adduce my evidences, I can prove my case, my lords.
In accordance with law.
My lords, I am only seeking the magnanimity, my lords.
That cannot be granted, sir. If there is no provision under the act for extension, how can that be
My
granted?
lords, the section 75 provides there's a may provision, my lords, either 45AA or 75. But if you approach the ASI code under 75, my lords, then there are proper evidences, and then there will be restricted process of, my lords.
To apply under the relevant provisions.
Milords, in that case, Milords, until I approach the court on 75, Milords, there should not be any,
Praise for permission to prefer an appeal under section 45 AA capital of the Employees State Insurance Act 1948 against the order dated December 13, 2024, passed by the authorized officer under the said act. First up, if the no permission of the court is necessary, if the petitioner is otherwise entitled to prefer to challenge an order in an appeal under the relevant statute. First up, recording now in view thereof, WPA number 730 of 2025 is disposed of by leaving the petitioner free to work out his remedies in accordance with law. Yes, next. Yes, call the next matter. Yes, 11.
Milord, item number 11, Milord, I appear for the petitioner.
My lord, I beg to appear on behalf of the Madrasa Board. The
Milord,
respondent
by
number
the
4.
previous orders, Milord, a report was directed to be filed by the board. Apparently, the managing committee is completely, Milord, it does not have the requisite permission, and therefore, Milord, Mr. Suleiman, Milord, should take steps for appointment of an administrator.
Oh, yes. Where is the
But
board?
that's as of now, it was the election was held in the year 2022, Your Lordship. But as of now, they have not
Where is
submitted the
your
audit report.
Where is your report?
Lordship, I'm praying for an accommodation for to file the report because the concerned law officer of the department, he has been transferred, and as such, I'm without any instructions. So, if Your Lordship to the
Milord, I think, Milord,
I had a
subject to
communication. I had a communication with the secretary concerned in the morning. He stated that there is no managing approval of the managing committee was granted as of now. Because the audit report has not been submitted.
Milord, if this is the submission, then in that event, Milord, kindly record
Your
this submission and kindly
Lordship may
grant
record
relief
it.
to the petitioner.
Lordship may record the same because there is no such recognition to the managing committee, and the non-functional managing committee, how can they issue a suspension? Suspension, they have issued a suspension.
Sir, file the report stating that fact. It's a one-line report.
Lordship.
Milord, I am without subsistence allowance.
Mr.
I am
Bhattacharya,
without
so
bread
it's
and butter,
be a
without salary.
one-line report. I will. I'm directing them to file that within a
Milord,
week.
he is going to
Because-
make it. He has made his submissions on instructions. Your Lordship may record his submissions. If it comments to your Lordship, of course.
You know the difficulty of
I know.
on the basis of an oral illness.
Milord, then Milord, may the matter be taken up on Friday, Milord, as a special case.
After Friday.
Friday.
No, not after Friday, Milord. Milord, Friday.
As prayed for by the learned advocate.
Lordship, Friday it will be hardship on my part, Your Lordship, because
How much time you want to file report? How much
Fortnight.
time?
This is the fourth
Fortnight.
occasion that the matter is taken up. Fourth occasion.
Yes. How much time you want?
2 weeks, Your Lordship.
Not 2 weeks. 1 day. For the board, time to file the report is extended. List this matter before the next available circuit.
Milord, may a date be fixed, Milord? If it comments, your Lord, Milord, 21st or 22nd, a date be fixed.
Mr. Bhattacharya, that is the difficulty. It will appear in the after 1 week in the list of the next available circuit bench. It will appear.
Milord, only one humble indulgence.
Fixing a date is a problem.
Milord, only one humble indulgence may I seek.
Yes.
Milord, kindly pass an interim order directing, Milord, the authorities to release whatever my salary, my bread and butter. I am out on the street.
The authorities are directed to release the to release the admissible amount to the petitioner in the meantime. Yes, call the next matter.
I'm grateful. Your Honor.
Taking your lordship's leave, my lord.
Yes, Mr. Dutt. Yes.
Milord, item 12, I'm for the petitioner.
I'm for this statement.
Yes.
Milord, on the last day, Milord, the state took time, Milord, to file a report before your lordship, whether, Milord, they have actually acquired my land or not. Because they
Yes,
have given me notice.
My lord, as per the instruction, my lord, the amount which was calculated, they denied to take that amount, asking for enhancement. Now for enhancement, they have
What
to,
steps did you take thereafter?
my lord, they have to, if they are agreed by the
I'm
amount,
asking you what steps you have taken. You have offered to pay, they have refused, but you have some duty as per the statute to perform. What steps have you performed as per the statute?
the amount is still now unrealized, my lord. It is showing in the report, my lord. Nothing else is
For whom
missing.
it is kept, sir?
My lord, this report is incomplete. I have already asked the officer to furnish a fresh report because they have not
Let
gone
them,
through
Milord,
the,
show, let them, Milord, show the notice, Milord, be given to me for collecting the compensation. And that I have refused that.
They have never sent me a notice.
I will, Miller, I am saying, Miller, on instructions that I never received any notice and neither was the any notice issued to me.
then if they have no, they have not made any refusal, they can collect this amount.
Have you given them notice?
I
to
will
collect?
not even know the award that is passed against me.
Have you given them notice to collect the amount?
And I would also get an opportunity of challenging that.
I have to.
Then you
sort
file
for-
a report.
That instruction I have to sort for, my lord.
Ashwin, the petitioner alleges that the property of the petitioner being plot number 849. Being plot number 849.
Yes, 849.
849.
Being plot number 849 within Mouja, Dabri, under police station and district, Alipurduar, was utilized for the purpose of construction of national highway, and a notice under section 3G within bracket 4 has been served upon the petitioner. Paragraph. Mr. Dutt, senior advocate, appearing for the petitioner, submits that no compensation has yet been paid to the petitioner.
Paid or communicated, Miller.
He further submits that no notice. The learned advocate appearing for the petitioner submits that the petitioner was asked to collect the compensation money, but the same was but the petitioner refused to accept the same. Paragraph. Mr. Dutt, learned advocate appearing for the petitioner, senior advocate appearing for the petitioner submits that submits, on instructions, no notice was served asking the petitioner to collect the compensation money.
My lord, one indulgence, my lord. If my lord comes to page 58, annexure P6, they have made a application for enhancement. So if they have not received anything, then how could he make a application?
Already file a report disclosing that since the special land acquisition officer which respondent, have you included a special land acquisition officer?
The respondent number 11, my lord.
No.
No, 11 is the additional district magistrate.
The competent authority is him.
No. Competent authority is the special land acquisition officer.
My lord, that is 9.
Fine. But you have stated as land acquisition collector. The ninth respondent, being the land acquisition collector, Jalpaiguri, is directed to file a report in the form of an affidavit with regard to the
My lord, in slash special land acquisition officer.
/ special land acquisition officer,
My lord, along with all the documents, my lord.
directed to file a report in the form of an affidavit disclosing the relevant documents in support of the case of the state.
My lord, may I be served a copy of that report?
Let the report in the form of an affidavit be filed within
4 weeks.
within 4 weeks from date. Parties will be at liberty to mention the matter for inclusion.
My lord, may I get a copy of the report, my lord? May be served.
Yes, sir. File, let an advance copy of such report be served upon the learned advocate on record of the petition.
Report in the form of affidavit, my lord.
Yes.
My lord, then if he has any junior here in circuit bench.
Yes, his junior is here.
No, he's for a national library.
Oh, he's for national. Yes, we start for.
My lord, I shall get it collected, my lord.
All right, or you can give your email ID, you can share your email ID to the learned advocate for the state so that soft copies can be sent.
My lord, I shall ask my advocate on record to, my lord, contact him.
Let the report in the form of an affidavit, either in physical form or soft copies be served an advance copy. Soft copies in advance be served upon the learned advocate for the
Oblige, my lord.
of the period fixed for filing of such report in the form of. Yes, call the next matter. Yes, Mr. Ghosh.
Miller, this is that matter, Miller, where they were supposed to file a report, Miller, the
Yes,
Provident Fund authorities.
As earlier I have submitted, my lord, the officer actually not available because they haven't transferred.
Old story.
Lordship.
Say some new story before the court.
Lordship, that the case actually, they are for whatever they stated that the dues that does not belong to them because of the dues.
Because for 30 years, Miller, during the relevant 30 years, the entire management and administration of the garden was under 2 special officers appointed by this court. All duties, liabilities had been discharged by them. And then, Miller, several communications. Now, after that, when all these things happened, we again came back in possession after fighting series of litigations up to the Supreme Court. Now, probably, Miller, the liability cannot come upon me because it was never a transfer, Miller.
Lordship,
under the definition of that.
They have the 17B exceptions clear that they are the owner of the property, but they are partnership dispute. They are and as per their dispute, page number 110 P4 to 110. The last part. One Mr. Sabbasachi and Vikas Ranjan Nyogi was appointed special officer. Their property to deal with the day-to-day transaction, lordship, and that has been cancelled in the year 2003. As therefore, they have contention that that period is guided by those special officers. We have no liability. But so far, lordship, 17B is concerned, lordship, they have been guided in any court.
No, this is the order which is under challenge, page 159.
159.
No, Millard, we are saying, Millard, kindly Millard text 159.
Yes.
159, Millard, is all those prosecution cases
Yes.
which has been subsequently lodged against me. I am only,
Subsequently lodged.
Millard, these are all.
How can it be? These are of 1999.
Right. The 99 subsequent to the order passed by this honorable court appointing the special officers. So when the garden was not at all in my possession, neither in my control management, I cannot be said to be the occupier of the property. So how these prosecutions can be lodged against me?
These are for which period?
All 99.
No, the POD is, the cases
this-
were filed in 1999, but that is
For
prior to
what
that.
period?
That is the lordship, that has no, I have not.
For that,
Because-
Milord, this
because
court
of
has
the-
directed him to file a report. That you are trying to impose certain liabilities, disclose how he is responsible.
Yes.
Yeah, lordship, because of the, I have no officer in the, at that, in this, because of.
Close
the
down
lordship.
your office.
Lordship. Lordship.
Close down your office.
Lordship, because of just April.
Close down your office.
No, lordship, lordship.
What function you are carrying?
Now, two persons are there. Now,
What they are carrying?
They
Please
are-
close down your office.
lordship, kindly give me 15 days.
Please close down other functions you are functioning. So we will not proceed against this. Two
Because-
persons cannot do anything.
Because of they are the clerk, not those two
Yes,
officers.
yes. So I will
This
record
response-
that. You will not take any steps against the petitioner in the meantime until all your officers join.
Lordship,
End
kindly,
of the
kindly
matter.
give.
I think
Give
Mr.
it
Bose
two
will be
weeks.
happy with that.
Well, I'm only praying for this.
Yes.
Let them take whatsoever
So
time
you
they
cannot
want.
Function with two officers. Let all the officers, all the staffs be appointed. Till then, you do not proceed against that.
Lordship, we have not preserved. This is a pending before the London CJM co.
No, Milord,
Darjeeling.
Milord,
I have not-
what prompted me?
Darjeeling.
Milord, what prompted me to come before your lordship is?
Proceed in that proceeding.
Because of,
That you are pressing for prosecution.
no, they are pending
I
for
will
a long
record
time.
that you are not proceeding.
No, they're pending for they had not appeared. They have not appeared, they were, somehow warrant has been issued. So for my common knowledge, but I am not confirmed that at that point, because of I have not get the certified copy. That's why lordship kindly give me 15 days time, so I can somehow give the land court can apprise something about the case, lordship.
There are now 35 cases, all Milord they have instituted without citing any name of accused. They have said manager Rangnit Estate. Now every day Milord a warrant is coming against my manager. No one is ready to join the property to run it.
Then you would better to go Kwashi.
Milord Bhajan Lal says, Milord,
Mr. Ghosh.
yes Milord.
Nothing has been stated with regard to this. Only you have been communicated
Yes.
about this pending prosecution case.
Yes.
It's not that the authorities have taken any steps against this. Nothing to show from this.
Yes. Yes.
So-
Now, Milord, I am only praying for this. Milord, even if this is pending, Milord, I have stated, Milord, I am saying, Milord, Milord, record my submission. I am saying this on instructions. Milord, warrant has been issued, which he has also admitted.
By whom?
By the court, on their,
Approach that court.
on
Why
their,
are you not approaching that court?
no, Milord, we will. If required, Milord, we will. But,
Mr.
Milord,
Ghosh,
30
from 2019.
Milord,
This was
30,
communicated to you in 2019. What prompted you to appear, to file this writ petition in 2025?
Milord, 30, Milord, kindly
After
consider
6
this.
years,
Milord, now, Milord,
what you are doing for 6 years?
no, Milord, 35 cases. Milord, kindly understand my agony also.
6 years you could not take steps.
Milord, 6 years we,
All the lists have been provided for.
Milord, until and unless, Milord, there is something coercive against me. Milord,
That is why you are,
that is why, Milord, I am now, Milord, I am,
I'm giving you liberty to approach the
Milord,
competent court.
Milord, let them, Milord, file, Milord, I am only, the scope of writ petition is these proceedings itself are bad in law. Itself are bad in law. And Milord, probably, Milord, going by Bhajan Lal's, Milord, fifth condition in the last paragraph, I did not go under 482. Since these are 35 cases, 226, Milord, is the most efficacious remedy for me. So where the court will take a holistic view whether these proceedings are at all maintainable. I am only to that limited extent.
Not that, only for, you are paying for an interim order.
I'm not, I'm interim order, Milord, this court directed him to file a report. They could not file it. I am saying in the meantime, don't proceed with it. You
But
file
there
a
is
report.
Nothing to show from their end that they have taken any coercive steps. It's by the court where it is pending.
No, Milord, the prosecution is on the, Milord, it's a complaint cases, all by the complainant. It's not a GR case by the state.
Yes.
Milord would consider that. It's on all Milord on complaints, Milord, instituted by them.
And you have not challenged any order of the court.
No, I have not. Milord, I am not. I am on a Milord proposition where these proceedings itself are maintainable. If I get a Milord view from this court, Milord, I will certainly praise that before the Lord Court will.
The learned advocate, Mr. Ghosh, learned advocate for the petition. So, sir, the petitioner has challenged the initiation of the proceedings have challenged the initiation of several proceedings which have been initiated in the year 1999. The details of the prosecution cases pending against the petitioner has been indicated in the memo or letter, in the letter dated July 16, 2019, issued by the Assistant Provident Fund Commissioner, Aru Darji. The learned advocate appearing for the Provident Fund Authority request for extension of time to file the report. The time to file the report is extended for a period of 2 weeks from date as a last chance. So this matter.
Kindly, Miller, let them not proceed with Miller this any further. Miller, let them not take any steps. Miller, kindly takes Miller.
Challenge.
Para 34 Miller have stated.
Some proceedings of 1999 communicated to you in 2029.
That's right. Miller.
Petition filed in 2025. Delay not expected.
Miller, para 34 I have pleaded, Miller. What has prompted me to come before this court now?
But 2019 was your date of knowledge.
That's right. That's right. I am not denying.
Wait for 6 years.
Grateful, Miller.
Yes. Yes.
Lordship, in item number 14, I am seeking for only 1 day's accommodation, Lordship. I am for the state, Lordship.
State. Who is for the petitioner?
Lordship, in this matter, I am for the petitioner. Lordship, in that case, Lordship, tomorrow I have some personal difficulties, so Lordship, make it on next circuit if they don't want to proceed today.
Lordship, I am ready with the matter, but Lordship, there is a small mistake in our report, Lordship, regarding the name. Otherwise, I am ready with this matter, Lordship. If Lordship want to add, then I will proceed, Lordship.
This one has been paid for by the learned advocate for the state to start list this matter before the next available secretary. Yes, next.
My lord,
15 years.
I'm for the petitioner, my lord. But I have produced the documents supplied by them. I make a list of dates. A list of documents.
Oh, this is that matter.
Yes, my
Yes,
lord.
ma-
Yesterday.
That is the learned additional advocate.
He's on.
My lord, subject. Can you take it on the Friday, my lord? I'm coming on the Friday.
Mr. Roy, not possible tomorrow. Anything?
Tomorrow, no, tomorrow I'm not here. Friday in the morning, my lord. I'm coming. No, no, then I'll do
next
it.
circuit.
Then I'll do it. I'll now do it. I'll do it. And
Yes.
your lordship, can you see the documents supplied by them? I made a list of documents. Can you see? My junior has handed over to them. I just press it, my lord. See the documents they have given. I just kindly come to page 4.
Page 4, yes.
My lord,
We have applied for.
Page
Next,
4.
my lord, we have applied for permission for filling of 5
Mr. Rai, give me a minute. Yes, what is your instruction with regard to whether this inquiry was made after giving them notice and other things? What is your instruction on
No.
that?
Nothing, my lord. Nothing. No revocation.
Leader is coming. He's on his way. I just need 1 minute. 1 minute. He's on his way. He's on his way.
Because that is the
No revocation, nothing, my lord. And secondly, my lord, I place your lordship, they say the law incorrectly.
right then 2 p.m. Mr. Rai.
Yes, my lord. Yes.
2 p.m. Yes, 2 p.m. For the next matter.
I'm grateful. Next.
কোথায় চলে ভাই না অদ্ভুত লোকজন নিয়ে না ভাই কোথায় চলে গেছে
16 is our matter.
মামলা চলছে
Lordship, item number 6 are praying for next circuit. Dr. Chaudhary will.
As paid for by the. Yes, next.
My lords, I'm led by Mr. Anvesh Rai on this matter. Item number
I'm for
7.
the respondent.
Yes.
Need some instruction.
Need some instruction. All right, yes, Mr. Rai. Where is Mr. Rai?
Sir.
Not today, next.
My lords may keep it at 2 p.m. because the other matter is also fixed. If it can be taken up. My lords. Very well.
Yes, next. 18. Yes.
Lordship, in item number 18, I have been instructed to appear for the private respondent, Lordship. I am praying for time to file opposition. I am for the
Opposition, let me see. They can.
Nothing, it has started. First, you are praying for filing opposition.
I don't want to waste time.
You don't want to waste time.
Yes, what is your-
Petitioner, my matter is that, my lord, our partnership firm, just the petitioner is a partnership firm, and since 22/8.
Private respondent, and who is for the state? How is that?
For the state.
All right. Yes, yes.
Practically, they have incorporated the partnership firm, and the firm name is there, and we during the time of framing of the firm, constituting our certificate, registration certificate, that is page on 31, and our entire description of the firm is there, page 18
What
to.
is your prayer? What do you want?
My prayer is that we have completed one tender work, and that has been completed 5 years back, and completion certificate has been received, and thereafter we have prayed another, that you please give me the entire monetary benefit to me, as because I have done everything, but it is matter of 5 years. They haven't communicated us. For that reason, without having no other alternative way.
So who are the private respondents? You are the private respondent.
Pradhan.
You are the private respondent.
Not private respondent.
Yes. Where is the completion certificate?
Completion certificate is there, my lord. Page number 41, it is completion certificate. That is on dated 27/2018 in favor of the petitioner. Annexure P3, page number 41.
Yes. Yes.
We have already submitted one representation to them, as because 27/2018 that we got this completion certificate.
Yes. What instructions? This is the completion certificate.
Yes. And excellent performance, it is written there.
Kindly give 1 day time, let's go.
Release this.
Kindly fix tomorrow, let's go. That is fine.
The petitioner alleges that the petitioner completed the work awarded to the firm by issuing a work order dated March 29, 2018. The petitioner claims to have completed the work and the learned advocate appearing for the petitioner refers to the completion certificate issued by the Pradhan of the concerned Gram Panchayat. Now what happened? The Pradhan has changed. That is the.
Pradhan has changed, where it is?
I have to take instructions.
It's 2018, now it's 2025.
Yes.
Must have
Which-
changed in the meantime.
Maybe the same person also. That I
May
can
or
say,
may
but
not
the
be.
post is the same Pradhan.
It's a different
Malat, different Pradhan.
Um, The learned advocate representing the Pradhan seeks a day's accommodation to take instructions as to why the bill of the petitioner has not yet been cleared. This matter.
My lord, just 1 second submission more. That we are pending for last 5 years. As he is to take instruction from Pradhan. So the interest of that amount, 5 years back.
Sir, please don't claim that interest because we have approached the court after how many years?
We have approached the court because
When?
just today I have to say that we are approached the court after 5. We have
2025.
25th.
Yes,
And
in
that is
2025. So why did you wait for this
no,
long years?
no, my lord. I made prayer to them. They gave me prayer and to,
We shall not praise that. Whatever lordship will allow, that will.
I have mentioned it there in my petition also, page number 7.
Sir, if you
That
want
10%.
Want to
No, sir. No,
make your
my
claim
lord.
for interest, you can make your prayer. I will
After,
consider that.
no, after completion. Yes.
Not after completion.
Another round of.
Hearing will be same, not after completion.
That's it,
You
my
can
lord.
make your prayer, I will consider.
As your lordship, please.
Yes, next.
That's it.
Petitioner.
Yes.
This may affidavit of service. Your lordship, the petitioner is the owner of the land. The land has been recorded in her husband name. This is husband's name.
Yes.
The respondent, without any notice or inquiry or any intimation or letter to the petitioner, has constructed electric poles over our land, which is purely agricultural land.
Lordship, in this matter, they have made WBAC PCL a party, but the concerned answering respondent is WBAC PCL.
Who are you representing? Who are you representing?
I am for WBAC DCL, but Lordship,
SCDCL. I will record your, I will direct regularization of your appointment. Yes.
they have to make the amendment.
Yes, that amendment will be made. Yes. Now what have you done after that?
Your lordship, we have made our representation on 21/1/25.
Before whom? 21/1?
25.
Before whom? Who is the authority competent?
DM
No. What no, sir?
District Magistrate Alipurduar.
What no?
My lord, the concerned authority will be West Bengal Transmission Company Limited.
They
Chairman
will
of the.
assess as per the Telegraph Act.
This is not for competence. What competence?
Yes, who can decide that?
Concerned department will decide.
Is it so? Show me the law that the company will decide that. Electricity Act, Telegraph Act. Not shifting. Are you sure? Yes, but you have also not come up with this. So what does section 69 say? Before laying down, the authorities have to approach the authority under the Telegraph Act. And who is the authority under the Telegraph Act? And where is the works of licenses rules? You have not brought those rules. It's the district magistrate. Please consider this representation and take it.
Your Lordship, prayer to stay the operation for the timing.
What operation?
Construction
You have said the construction has been made.
has been going on. I have given the 40
You are
pictures.
entitled to comment.
Report in the meantime, Lordship. A report in the meantime.
Not report, I will direct the DM to consider. Everything removal, everything. Ashok. The petitioner alleges that the West Bengal state electricity achar, একদম উপরে করে দেবেন, as prayed for by the learned advocate for the petitioner. Leave is granted to the learned advocate on record of the petitioner to amend the post title of the writ petition. So let such amendment be carried out, here and now. Paragraph. The petitioner claims to be the owner of, what is your property? Claims to be the owner of LR tag number 1677, 1710 and 1724. And from which, over which property it has gone?
3 plots. For the 3 plots.
Within Mouja, Uttor Madarihat, under police station Madarihat in the district of Alipurduar. The petitioner alleges that the West Bengal State Electricity Transmission Company Limited have erected poles and have drawn overhead transmission lines over the property of the petitioner. The petitioner claims to have made representations before the before various authorities, including the district magistrate Alipurduar, by a letter dated January 21, 2025. So the paragraph, the learned advocate appearing for the petitioner submits that no decision has yet been communicated by the district magistrate with regard to the prayer of the petition. So the learned advocate appearing for the transmission company submits, yes, what is your submission? What is your instruction, sir? Submits that the poles were erected and overhead lines has it been drawn or they are taking steps?
They are taking steps. Construction is going on.
The learned advocate appearing for the West Bengal Transmission State Electricity Transmission Company Limited submits that the licensing company has taken steps after obtaining requisite permission from the competent authority in this regard. First up, without entering into the merits of the claim made, the representation dated January 21, 2025, WPA 610 of 2025 is disposed of by directing the district magistrate Alipurduar, being the court respondent hearing to consider the representation of the petitioner dated 2025 and to dispose of the same by passing a reasoned order after giving an opportunity of hearing the petitioner, the transmission company and or any other interested parties who may be affected by such decision. by passing rescind order to the rescind order shall be communicated to the respective parties immediately thereafter. The entire exercise shall be communicated as expeditious.
Your Lordship,
What is that? Which one you want?
21-1-25.
21-1. 21-1, 2025.
Lordship, time be fixed in the.
As expeditiously as possible, but possibly within a period of 4 weeks from the date of receipt of a server copy of this order, along with the copy of the representation dated 21st of January.
Yes,
Please annex that copy of the representation also, because we have given 2 representations. Yes, next.
Lordships. I am for the petition actual lordships.
Yes.
This matter, your lordships, I am the assistant teacher. I am entitled for benefits, your lordship, from my date of joining. State government filed the instructions, and instructions admitted all the facts and law points. They also admit on the same footings, other teachers, your lordships. So your lordship pass the necessary directions to the commissioner.
Yes, you have filed your instruction from the date of joining. That is your instruction, paragraph 9. Oh, that is with effect from the date of our joining, as per the order. Yes, where is the case of Joya Das?
Lordship, Joya Das Gupta is there.
Where?
Equal
Page?
Lordship, type copy and the orders copy both are annexed.
Page.
P9, your lordships, page start from 42, and thereafter the type copy, your lordships.
But this I have followed in the subsequent decision.
Lordships, in that this petitioner joined in 78.
Which
Now,
petitioner?
This petition.
Yes.
Now, in 1981, your lordships,
Yes.
the school authority appoint 12 teachers. For that,
Which is the order which you are challenging? Show me that. Here.
lordship, this is the memo.
Yes. Are you challenging any order or?
Yes, one memo, your lordship.
Where?
32, piece 57, your lordship. This memo affects us, your lordship.
No. You have made a representation. What decision was taken on that?
Lordship.
Show me that.
Shubhra Shom, lordships, in this case, তারাও সব দেওয়া আছে, তারাও বলতে দাও।
Yes.
Lordships, this P7 issued by the Director of the School Education, West Bengal.
Page?
The 32. Now, subsequently, this memo challenged in the Subra Som's case, your lordships.
Yes.
Now, Honorable Court allow the writ petition and direct us the school authority, Deputy Director of the School Education Department, to pay all the retrial benefit, all the teachers from the date of joining. Now, question is, this memo, why this memo issued? Now, behind the back, your lordships, in 1981, 12 teachers were appointed. Now, 4 teachers were approved by the DI, and rest of the 8 teachers sent to the approval for the School Education Department. Now, in 1988, the School Education Department approved all the teachers subject to their service calculating from the data 1988.
1/1/1988.
88. Subsequently, your lordships, one Jaya Das Gupta challenged the said memo.
This memo.
This memo.
That is
88.
That is the 12th of November 2017.
No, lordship. Jaya Das Gupta challenged 88 memo.
Where is the 88?
Lords, wait, 88 I'm also annexed, your lordships. This memo is page 33, your lordship.
Oh, 88 is page 33.
Page 33.
Page-
Please. Now, your lordship, when this memo was challenged,
What does this memo say?
what is memo, your lordship, for relating to 8 teachers? 12 teachers appointed, 8 teachers for approval. Now,
Yes.
last portion of the order, your lordships. Type copy is also there.
Page,
Type copy start from page 35, your lordship.
yes.
Now, this memo says, page 36, given the above background, the affairs of the Sishumol KG school at Jalpaiguri have been engaging the attention of the state government in the education department for some time past, and after careful consideration of the matter, the government has been pleased to order as a special case and in relaxation of the existing rules that the 8 teachers who have already been appointed in the existing vacancies be given salaries from the government fund with effect from 1988, subject to the following terms and conditions such and such.
Yes.
Now, this memo, after this memo, all the 8 teachers, your lordship, made several representation to the government. Now, subsequently, education department says, okay, you are entitled for the date of joining, but subject to monetary salary and others benefits from 2003.
Where is that?
This is there, your lordships. This is also that part, your lordships, set aside by Subal Bhattacharya case.
Yes. Yes.
Now, your lordship, this writ petitioner,
What is the name of the writ petitioner?
this writ petitioner, your lordships,
Joy-
Jayati Bhattacharya.
Yes.
Now, up to 81, the school authority run from 12 teachers, there are no dispute at all. On 1981, 12 teachers appointed, 4 teachers approved by the school authority and higher authority, there is no dispute. Now, 8 teachers who are approved by 88 memo, now they are will affected by 88. Now, subsequently, Honorable High Court in Jaya Das Gupta says no, rule of election analysis the order and allow the writ petitioner Jaya Das Gupta and directors the government to pay all the benefit from the date of joining. Now, subsequently, up to 2017, all the teachers retired, all the teachers getting benefit from the date of joining. I am annexed those some PPO also. Now, in 2017, this memo is came up. Deputy Director says all the teaching and non-teaching staff.
Where is that? Where is that 2017?
Lordships. Page 32, P7.
Yes.
Lordship says, with reference to the above, the undersigned has to inform him that the teaching and non-teaching staff of Sishumol PG school are entitled to get paid fixation benefit with 1/1/1988. Now, this memo challenged by Suprashom. I am annexed the order, your lordships.
Page.
Suprashom, your lordship.
Page 66.
Nat 59. Yes, lordship. Page 66.
Yes.
This order challenge in the division bench, your lordship. Division bench upheld
This
this
order was
order.
challenged in the division bench. Where is the division bench judge?
Lordship, page 71.
Yes.
Subsequently, contempt file rule issue.
Give me a minute. Yes. But that memo was set aside, no?
No. That order says that's the lordship. Every teachers after they objection, they came before the court. After hearing court pass a direction, subsequently they pay either contempt fine.
Yes, what happened after that?
Now, your lordship, subsequently, all the teachers, your lordship, in Subrashom case, after Subrashom case, after affirming the order of the single bench by the division bench, Subrashom get the benefit from the date of joining, all that. Now, subsequently, when Sami Chakraborty in the same case, Sami Chakraborty filed a writ petition. Then writ petition was allowed, your lordships.
Yes.
That is in page 75. Now, Sami Chakraborty, thereafter, one of the teacher, Onupoma, page 79, 353, 2023, filed the writ petition. On the same footings, your lordship, they get all the benefits from the date of joining.
Yes.
Now, it says subsequently, one Ila Chakraborty, page 83, order passed by your lordships, your lordships.
Yes.
Now, subsequently, Shubal Bhattacharya, that is page 87. Now, in Subal Bhattacharya case, your lordships set aside those portion of memo number 2003, that is the monetary benefit giving from 2003, page 89, your lordships, kind of page 89.
Yes.
Now, in view thereof, the portion of the order dated June 2, 2005, issued by the chairman, District Primary School
Which
Council.
portion you are placing? Page?
Page 89, your lordship, Subal Bhattacharya's order.
Yes.
Now, in view thereof, the portion of the order dated
Give me a
June
minute. Yes, view thereof. Yes.
June 2, 2005, issued by the chairman, District Primary Council, Jalpaiguri, that the monetary effect will be given retrospectively with 1st April 2003 is set aside and cost.
Yes.
Now, your lordship, as today, all the teachers of the Sishumal, including this petitioner, is entitled to get the benefit from the date of joining, your lordship. Now, here in this petitioner's case, petitioners up to the retirement get all the benefit as per the government, from the government funds, as per their pay scale from the date of joining. There is no dispute. There is no area of salaries question is concerned up to date of retirement. Now, after the retirement, when lordships come to memo number, page, your lordships. Page 31, your lordship.
Yes.
Page 31.
Yes.
Page 31, your lordship, Jayati Bhattacharya's cause of objection. Cause of objection says memo number 2017.
Yes.
Now, memo number 17, your lordship, already dealing Subra Som case and other teachers are also.
Yes.
Now, their instruction, they categorically stated, your lordship, paragraph 8 and 9 come to state government's instruction.
Paragraph 8 and 9.
8 and 9, your lordship. 7, 8 and 9, your lordship.
Yes.
That in accordance with the above direction and in order to comply the objection raised by the AD accounts, recast service books of the petitioner was made with effect from 1188, and accordingly calculation of pension and other retrial benefit was also made and submitted to DPPG for issuing PPO in favor of the petitioner. It is also mentioned here with that the revised last basic pay stood 16,390 as on 31st August 2016 instead of 18,000. Lordship, I have received basic 18,000 from the date of joining. After objection, they recast my service book, and on that day, because they recast my service book, my basic is 390. Now, your lordship, which was calculated.
So your pay has been recasted.
Recasted on the basis of.
So you are getting pension on the basis of 16.
Yes. Annual my service 30 years, 38 years, 5 months. For issuing memo.
Yes, so Singhania, give me a minute.
No, lordship, paragraph 8.
Give me a minute. Give me a minute. So, they have applied the 24th November 2007 memo to your case also.
Yes, Lords, that's the problem.
How to do this?
Lordship,
And your Lordship, they admitted, they recast, even if that the DPT.
This 24th of November was set aside in
Subra Som case, or say deal. Dealt with in Subra Som's case. Lordship, can I read this order? Last portion.
Page.
Start from 66.
Yes.
Lordship, page 69, last para.
Give me a minute.
Lordship.
Yes. Yes.
Now, your Lordship, the instruction, Lordship, para 8 of their instruction, the DPG has issued PPO in favor of the petitioner by PPO 20th February 2018, and thereafter revised PPO as per ROPA 19. Now, ROPA 19, implementation of the ROPA 19. Now, Lordships, I am annexed my PPO, both the PPO, Lordships. In PPO, my qualifying service, they have stated 30 years only.
28.
And,
28 some months.
but my qualifying service 38 years 5 months. My last basic pay is 18,000. They recast 16,319.
Yes. So, this,
So I am entitled.
Pay has also to be recasted.
Yes, Lordship. So, your Lordships, I am entitled from the date of joining all the benefits, your Lordship.
So, from the date of joining, you have to also to recast the
Yes, Lordship.
pay of the.
Yes.
recasted because.
If your Lordships pass a direction for revised PPO calculating my service from the date of joining.
Yes, as per the EO of 1988, the pay is to be, was calculated. It was in other, it was
Yes.
set aside and it was given direction.
From the
for-
date
from
of joining.
But since there was no order, specific order, general order after 88, so
After
with the order of.
Jaya Das Gupta,
With the order of direction of honorable court.
You have complied.
We have complied. The petitioner
But since there was no order in respect of the
that
petitioner.
is the short
that
point. And
They have several points that they have given undertaking not to claim the areas. However, in
No,
this case.
in this case, I am not file any, not to claim area because this question does not arise before my retirement. I am joining in 78. This all the memo in my little understanding not applicable in my case because 88 memo applicable those 8 teachers
What have
only.
you paid for? What have you paid for?
For revised PPO from the date of calculating my service.
That
is the main, your lordship.
For doctrine of equal pay for.
If your lordship pass a
that was
direction
taken into
to
consideration. If there is a direction, we will.
lordship, if Subrat Somkes and others, all the
Wait,
directions for respondent number 5, your lordship. Issue either your lordship might pay for 2017 or set aside, your lordship.
They will recalculate because let them recalculate with effect from the date of your
Joining.
Lordship, date of joining.
Who is the respondent number 5?
Lordship, main commissioner of the school education at now who issued the memo number 2017. And that's why pension department and others authority raised their issue.
Give me a minute.
Commissioner of the school education.
Direction.
Respondent number 5, the commissioner, commissioner who issued the memo, your lordship.
The petitioner
And now rename
Joint
is commissioner.
Commissioner Shishu Mohol,
Lordship.
Junior Basic School, Jalpaiguri. As a teaching staff on September 1, 1978. The service of the petitioner was approved with effect from 1st of September 1978 by the Secretary, District Primary School Council, Jalpaiguri by memo dated 168, by memo being numbers 168 dated 6th of February 2013. And such approval was accorded as per GO dated January 29, 1988. The pension payment order was issued on the basis of pay fixation of the petitioner with effect from 1st of January 1988 on the basis of the memo being number 1302 capital A small c /P dated November 24, 2017. The pay of the petitioner as per the pay scale with effect from 1st of September 1978. Mr. Singhania, learned advocate appearing for the petitioner submits that the pay scale of the petitioner was rupees 18,000 with effect from September 1, 1978. But the same was recasted, but the revised last basic pay of the petitioner was recasted at rupees 16,390 as on 31st of August 2016. Mr. Singhania further submits that the respondent authorities could not have issued the pension payment order on the basis of the memo dated November 24, 2017, as the same was set aside by a coordinate bench in the case of in WPA 342 of 2019 in the case of Shubhra versus State of West Bengal and others, ordered passed on August 29, 2019, which was subsequently affirmed by the Honorable Division Bench. Therefore, submits that the pay fixation, that the pay of the petitioner for the purpose of calculating the pensionary benefit ought to have been considered on the basis of his pay scale with effect from the date of the joining of the petitioner, that is with effect from 1st of September 1978. Yes, Mr. Singhania?
Yes. Lordships. Lordship, one memo set aside by your lordship, that is 8 euros.
That memo not be required, no?
Yes, sir. Actually, not required.
The learned advocate appearing for the state files the report of the District Inspector of Schools Primary Education, Jalpaiguri, dated March 24, 2025. From the report of the District Inspector of Schools within bracket primary education, it appears that the pensionary benefit to one of the retired staff of the said school, namely Joya Dasgupta, was calculated with effect from the date of her joining the school as per the order of the Honorable High Court at Calcutta, Circuit Bench at Jalpaiguri. The learned advocate appearing for the state submits that the pensionary benefits in the case of Joya Dasgupta had to be calculated pursuant to the order passed by the High Court with effect from the date of her joining, with effect from the date of her joining the service. Heard the learned advocates for the parties and peruse the materials. It appears from the memo dated November 24, 2017, that the Deputy Director of School Education from West Bengal clarified that the teaching and non-teaching staff of Shishu Mohol KG within bracket pre-basic nursery bracket close schools are entitled to get pay fixation benefit with effect from 1/1/1988. One Shubhra Shom was a teacher of the said school, filed a writ petition being WPA 342 of 2019. And the coordinate bench passed an order. Now, you filed a writ petition with number such and such, claiming that though she was appointed as an assistant teacher in the primary school on August 3, 1981, but the approval was given with effect from January 1, 1988. But in your case, it has been given from a date of your joining. Approval.
Yes, Lordship, from the date of joining, before.
But in
these
Supra,
two,
it was.
Yes, Lordship, from 88. So all the memos applicable for 8 teachers, in my little understanding. But 2017 memo says all the teachers, that's the problem.
The coordinate bench in Supra noted the decision of the Honorable Supreme Court reported at AIR 2017 SC 4072 in the case of State of Punjab and others versus Senior Vocational Staff Masters Association and others. And observed that since 3 other teachers, on an equal footing with Supra Shom, who had retired in the meantime, were given all benefits with effect from the date of their joining. Was held that the petitioner was also entitled to disbursement of all benefits, taking the scale to be effective from the date of her joining service. The District Inspector of Schools within bracket P in Jalpaiguri carried the matter in appeal, being MAT 55 of 2019, and the Honorable Division Bench, by an order dated 11th of March 2020, dismissed the said, disposed of the said appeal without interfering with the order passed by the coordinate bench. Without interfering with the order dated 29/8/2019 passed by the coordinate. Thus, thus it is evident that the coordinate bench that has been well settled. Thus it has been well settled that the teachers who were on equal footing with that of the petitioner was directed to be given the pensionary benefits, taking this pay scale to be effective from the date of joining the service. Paragraph. As it is not in dispute that the petitioner joined the service on 1st of September 1978, and her appointment was also approved. Confirmed on 1/9/19. Was also approved with effect from 1/9/1978.
I have any memo.
That's what the report, it was confirmed with effect from 1/9/1980.
But with effect from, that is your report also. I've quoted from your report.
Lordship, P2, P3. Lordship, P2 and P3, your lordships, in my writ petition.
Please see paragraph 3.
Yes, petitioner joined his school in 1/9/1978 and retired after our service was subsequently confirmed.
Paragraph 4. service of the was also approved with effect from 1/9/1970.
Yes,
Confirm with effect from the date of payment.
T2 and T3.
Yes, approved with effect from, so that is the date of effect. You have approved it subsequently, but the date of effect
Confirm what the effect was given from 17.
1978. So that is the relevant.
You will not need 1970. T3 says.
With effect from said date. Full stop. The only dispute is that the pension payment order was issued by taking into account the pay scale of the petitioner with effect from 1/1/1988 instead of 1/9/1978. It is also not in dispute that the pay of the petitioner was also recasted by taking into account the pay scale of the petitioner with effect from 1/1/1988. Paragraph. This court has already held that the petitioner was entitled, that the petitioner is entitled to pensionary benefit on the basis of the pay scale effective from the date of adjoining the service, that is from 1/9/1978. For the reasons as aforesaid, this court is inclined to grant relief in favor of the petitioner. The respondent authorities are directed to.
But 2, 5 and 6 is mainly concerned. 2, 5 and 6.
The concerned respondent authorities are directed to recast the pay of the petitioner with effect from 1/9/1978 and to disperse all benefits to the petitioner by taking the pay scale of the petitioner with effect from a date of joining the service, that is from September 1, 1978. The respondent authorities are directed to take all consequential steps, including release of area benefits to the petitioner. Now, the authorities are directed to take all consequential steps in terms of this order by issuing a revised PPO and by releasing the area benefits to the petitioner as the revised PPO. Yes, how soon can you issue the revised PPO? 4 weeks, within a period of 6 weeks from the date of communication of the server copy of this order. The all area benefits which may accrue to the petitioner pursuant to the issuance of revised PPO be released in favor of the petitioner as expeditiously as possible, but positively within a period of 4 weeks from the date of release, that within 4 weeks.
6 and 4.
6 and 4, 10. 4 weeks from the date of issuance of the revised PPO. With the above observations and the
That's
no cost.
Next.
No. Yes. For the next matter.
Lordship. In the next matter, your lordship.
Same.
Subal Bhattacharya's case is same, your lordship. This petitioner is within the 88, 81. This writ petitioner. So Subal Bhattacharya case and this writ petitioners is the same. Same footing, same memo, same date of birth.
And what is this page?
Subal Bhattacharya, page, your lordship, 87. Page 87.
But where is this order? Decision passed. In that case, then you have challenged the decision of April 6, 2021. Where is the decision taken?
Subal Bhattacharya case?
Yes, in Subal Bhattacharya, you had challenged the decision of April 6, 2021.
Yes, that.
Where is the
yes.
decision
There is
taken
a
in your case?
monetary benefit, 2015 monetary
Yes.
benefit, there, your lordship.
But here, where is the decision taken in your case? No decision has been taken in your case.
Yes, PPO issued, revised PPO issues from the
Please come to page 86.
86.
Yes, Subal Bhattacharya's case.
Lordship.
So here, the
86.
challenge was with regard to the memo dated April 6, 2021.
Yes.
So wherein it was held that
Lordship,
the writ
kindly
petitioner may
operative,
get the benefit from the date of joining the.
Lordship, 89, operative portion 89, your lordship, Subal Bhattacharya case.
Yes.
All the same, the memo is same. Now, your lordship.
Yes, sir, but there was a decision in that case.
Lordship, director
Here-
of the school education being respondent number 5, and the deputy director, office director of the pension, provident fund, group insurance being respondent number 6. Herein a directive to take all necessary steps for issuing the revised pension payment order in terms of this order or to release all benefits in terms of this order of the petitioner. The entire exercise is the same. Now, earlier page, your lordships. After taking note the coordinate bench decision in T 42 2019, this court directed the concerned to issue necessary direction for disbursement all the benefit in favor of the petitioner by treating the petitioner to be entitled all the benefit from the effect from her date of joining. That is the same, lordships. This petitioner also joining in 1981 and the respondent authority give effect from 1988. Their instruction also same, your lordships. The Shubra Shom in para 9, the respondent says the pensionary benefit has been provided to Shubra Shom, a retired staff of Shishumol Basic School, with effect of her date of joining.
Yes, but here in your case with effect from which date?
88.
88,
Same.
not 81.
Date of joining 81.
So,
and effect 88.
So Shubra Shom's case.
Same,
the same
81 and
benefit
88.
to you.
Yes, same.
Date of joining is.
Shubra Shom, lordship, Shubra Shom case and my case is same.
Yes, and you have been given, where is your PPO?
PPO, lordship.
Your pensionary benefit has been calculated with effect from what date?
From 1988.
So from the date of your joining.
1981, my date of joining.
From the date of joining, it has been given.
PPO issued 88. Joining PPO
Taking 88, where is that? Show me that.
Lots.
Where is the PPO?
Lordship, page 16. 62, your lordship, the first PPO. And page 63 is the revised PPO in implementation of lordship. That is.
Show me it was calculated as per 88.
Lordship.
Yes, what does your instruction say?
Instruction say admit our claim, your lordships. 8 and 9, para 8 and 9. Para 7, your lordship, para 7. That in accordance with the. Here also recast my service, your lordship. 760.
So same order can be passed as
Lordship,
the earlier.
same order, same order. Date of joining and basic.
একই order, এখানে হচ্ছে শুধু date of joining টা না, হবে 1st of, no, 31st of July.
Lordship. And date of retirement 28 February 27.
31st of July 1981. Approval with effect from 31st of, approval is also 31st of July?
Same.
31st of July 1981.
Date of retirement 28 February 2027. Taka is the difference. Yes, here your lordship 7,690.
17,690 আর ওই 16,000 কত ছিল না সেইটা হবে 15,970
লর্ডশিপ।
ঠিক আছে, 15,970 টা হচ্ছে as on 28/2/2017 ঠিক আছে, আর 17,690 28/2/2017 আর 17,690 টা হচ্ছে 31st of July 1981 ঠিক আছে, আর other things same.
Lordship, get to level.
Give your appearance. Dispose of next.
Thank you. Lordship 22, I'm praying for 1 week's time, Lordship. We are currently looking for the execution proceeding records. Once we find them, we'll file a supplementary affidavit annexing the same, Lordship.
The learned advocate appearing for the petitioner prays for a week's time to file a supplementary affidavit annexing the copy of the order passed in the copies of the orders passed in the relevant orders. The copies of the relevant orders passed in the execution case. So this such supplementary will be filed in a week from date. This matter before the next available circuit bench. The point of maintainability of the petition is however kept open.
Stated representative. Good.
Is however kept open to be decided at the time of hearing of the petition.
Good.
Yes, call the next matter. You are appealing for the bank. You are for the petitioner.
No.
Oh, Devobrata Dhar.
Lordship.
Last occasion, Malad asked me to inquire whether the proceeding is pending or not. Proceeding has been disposed of by the
Which proceeding has been?
Section 14.
Section 14. Yes, you are appearing for the petitioner.
Lordship.
Yes.
Lordship, in this matter, there was an earlier direction by this honorable court by an earlier order. I told your Lordship yesterday. That order is, Lordship, passed by Justice, Honorable Justice Basu, Biswajit Basu.
Yes.
That is page 41, Lordship, page 41. And the respective part is page 42, wherein on the basis of the prayer of the writ petitioner, the Honorable Court is pleased to direct the petitioner to approach before the DM in a district magistrate in a section 14 proceedings.
Yes.
And accordingly, he had been there, but the district magistrate office refused to accept the check, and thereafter he sent it by postal service, and they acknowledge it. So let them encash the check, Lordship.
Who will encash the check?
Lordship, district magistrate will hand over it to the bank because section 14 proceeding is there and no further order is communicated us. So they will hand over it to the bank, and bank
will direct the district magistrate to communicate the order to you. Then you take appropriate steps.
Lordship.
That's already been passed.
Lordship.
Kindly records our objection with regard to
Lordship.
The learned advocate appealing for the bank raises an objection as to the maintainability of this writ petition.
As with the
Paragraph
state,
the learned
as well as the state.
the bank and the state. ঠিক আছে, learned advocates for the bank and the state raises an objection.
No copy has been served upon the bank. Till date, he has not served any copy. I have no ground.
I'm for the state.
Oh, Mr. Pal is for the state. Alright. The learned advocate appearing for the, then how can you raise an objection with regard to the mentality without a copy being?
No, I have taken a.
He has procured a copy from me.
The learned advocate appearing for the bank submits that no copy of the writ petition has been served upon the bank. Full stop, paragraph. The learned
No, Lordship,
petitioner submits that in terms of the order dated December 3, 2024, passed by a coordinate bench in WPA 2373 of 2024. The petitioner has paid, has handed over a check of rupees
7 lakhs, the entire dues, Lordship, whatever they claim, rupees 7 lakhs. I have annexed the check, Lordship. Lordship, 1 minute.
has submitted a check of
Check of rupees 7 lakhs,
has submitted a check covering the entire deal.
3 check, Lordship.
Has submitted 3 checks covering the entire amount due to the bank before the
Lordship, 7 lakhs 42,649 and 83 paisa.
would be concerned district magistrate. First up, he submits that that an order be passed directing the district magistrate to hand over the checks to the bank with a direction to the bank to encash
Lordship.
same. First up, paragraph. The learned advocate appearing for the state submits that the application under section that an order has already been passed by the district magistrate, by the concerned district magistrate on an application filed by the bank under section 14 of the SARFAESI Act. The learned advocate appearing for the petitioner submits that such order has not yet been communicated to the
Lordship.
petitioner till date. So in the light of the submissions made by the learned advocates for the parties, WPS 624 of 2025 is disposed of by directing the district magistrate,
Which we are.
being the first respondent, to communicate the order passed under section 14 of the SARFAESI Act to the petitioner. Yes, how soon? Within 2 weeks from the date of receipt of a server copy of this order. It will be open to the petitioner to work out his remedies in accordance with law.
Lordship, only one thing, Lordship, may kindly record that no sale process has been initiated up till now.
That is not initiated, not initiated.
Wow.
Yes, next.
Lordship. Lordship. Obliged, Lordship.
Lordship, item number 24, Mr. Vinay Saraf is appearing virtually. Lordship.
Yes, Saraf. Yes,
Last occasion, your Lordship.
Yes.
My lord, the short issue, my lord, in this petition is that I availed credit of IGST under the heading CGST and SGST. And my lord, my humble submission.
Mr. Saraf, there is no scope to pass any interim order. Let them file a report in the form of an affidavit.
My lord, there is a judgment to this court, my lord.
Yes.
Similar fact, my lord, if your lordship kindly.
The Madras High Court.
My lord. So what is the case in hand, my lord? If your lordship comes to page number 107 of the writ petition, my lord, it is that there was 9 IGST inward invoices. That tax has been charged as IGST. But the appellate hearing inadvertently.
So according to you, this was dismissed with the liberty to the petitioner to file a rectification application under section 161.
Yes.
Mr. Saraf.
Yes, my lord.
Relying upon a decision wherein saying that you can be given liberty to file an application for rectification under section 161.
No, my lord, I am relying upon the judgment of this Honorable High Court, division bench judgment, my lord. It
Alright,
is there in
so
my compilation.
let them file report. So to be decided, yes.
My lord, because it is a revenue neutral situation. If the revenue is accrued to the state and center, my lord.
All right, that will be decided. After hearing the learned advocate for the respective parties, this court feels that the issue involved in the revision can be decided only after exchange of affidavits. Let affidavit in opposition be filed within
4 weeks.
why 4 weeks?
But so many are there, my lord. I have to prepare all of them.
You will be getting 1 week leave.
Within that period, my lord, even the department cannot send my lord.
3 weeks.
No, no.
Within a period of 3 weeks. From date, so reply thereto if any be filed within a week or 2 weeks.
My lord, let there be a stay, my lord. There is a judgment of the division bench wherein a similar identical.
You are saying revenue neutral. What stay you want?
My lord, there is a stay, my lord, by the Honorable Division Bench, my lord. I have enclosed in my petition, my lord.
Stay of
It is
what?
similar.
Stay of what?
Stay of the demand. Stay of the demand, my lord.
Where is the demand?
Where the demand is, my lord. But the appellate order, my lord, is on page 90.
There is a provision of appeal before the tribunal.
But the tribunal is not in existence.
Yes. So what is the condition for granting stay? You secure that amount. Subject to that.
No, my lord. No, my lord. There is a judgment of Honorable Division Bench Chief Justice. My lord, can you refer to page 26 of my compilation?
Yes.
My lord, the condition of 10% was imposed by the learned single judge.
And this fact is totally different, my lord.
Page 26.
Page 27, my lord. Kindly refer to page 27.
Yes.
Page 27, paragraph 6, my lord. Paragraph 6, my lord, I am reading out from the compilation, page 27. This is because the case of the appellant, writ petitioner, is that they committed a mistake while claiming ITC in IGST to the tune of so-and-so in the place of actual claim of IGST in CGST so-and-so in WBGST so-and-so. And as a result of the said ICC in IGST of so-and-so was reflected in the electronic credit label of IGST. Thus, it is seen that there is no revenue loss to the government and it is revenue neutral. Considering the fact the court is of the view that the order imputed in the writ petition shall remain stayed till the disposal of the writ petition. The petitioners are exempt from making payment of the 10% of the tax. Similar, my lord, very recent order, my lord. 25/3/2025.
Mr. Saraf Lanet, advocate appearing for the petitioner, places reliance upon a division bench judgment.
But there is no stay, my lord.
Yes, yes. Stay is there. You see, paragraph 2. The single bench directed stay upon payment of 10% balance amount of tax in dispute, and the honorable division bench said shall remain stay till the disposal, and the petitioner are exempt from making payment of 10% tax. Paragraph 8 of the judgment, page 27. Places reliance upon a decision of the honorable division bench in MAT 319 of 2025 in the case of page 27 so party number 2 order passed on 25th of March 2025 in support of his contention that under similar circumstances the honorable division bench passed an order of stay of the impugned order without requiring the assessee to make any payment to make any payment therefore. Now to make any payment as a condition for stay. So, the relevant portion of the order passed by the Honorable Division Bench is extracted hereinafter. Bole paragraph 6. Paragraph 5 to 9. In view thereof, the order impugned dated
But the order impugned is dated
22/10/2024.
22/10/2024.
Passed in appeal case number GST/APP/224/2024-2025 shall
Yes, my lord.
take till the disposal of the writ petition. Yes.
Much okay.
Yes,
And
next.
next,
Yes,
Mr. Bari is appearing in this matter.
yes, Mr. Bari. Mr. Bari, you are not audible. Yes, Mr. Shah, you are ready.
Your Lordship directed Mr. Saar to take instructions. Specifically, my lord, this is a notional fixation matter.
Yes.
Where my lord, the court directed for considerations. And after considering the same, it was forwarded to page 58 is the impugned order.
You have not got instructions. All right. Mr.
My lord,
Bari
your
Lanet,
your lordships, without instruction, your lordships can dispose of the matter. Your lordships kindly have a look to this last portion of the order. Last portion of the order. Page 63.
Page 63.
Page 63. Para 6. Your lordship got it?
Page 63, paragraph 6. Yes.
Yes. Having considered the facts and of the case, records available in the instant case, submission of all concerned parties, repayment of the petitioner dated such and such, it is stated that in compliance of the order of the Honorable Court, 2 posts were created in order number such and such in the concurrence of the Finance Department, Government of West Bengal, such and such prospectively. Thereafter, the petitioners were appointed in these 2 posts in such and such schools by memo number such and such. The West Bengal Central School Service Commission by memo number reported that responsibility of the commission is restricted up to the time recommendation of a candidate. It may further be noted that if delay has been caused, it was due to the pendency of the litigation at the Honorable Court. In the light of the above, the undersigned is constant to give any relief whatsoever to the petitioner regarding their prayer, allowing the notional benefit of their service from 2000, from the year of the impanelment instead of the date of joining of their service, considering the fact that 2 posts were created in compliance with the Honorable Court's order dated such and such. Thus, the matter is disposed of. However, it appears the petitioner filed representations.
There is
Your lordship kindly see the Finance Department, it was forwarded.
Only with regard to one point, here it's not a case where the posts were in existence.
No.
Here posts were created, though you are appointed previously, but the posts were created subsequently. The issue would be here whether you can be granted notional fixation with effect from a date prior to the creation of the post.
Grateful. So the question is, I tell you, lordship,
that has to be let
no, your lordship kindly have a look to the judgment my learned friend will cite. My learned junior is citing 1 division bench, 1 single bench.
Yes.
Division bench of mat number 1211.
Yes, yes.
Now, my lord, this paragraph, page 3. The delay was attributed to the conduct of the authorities.
Mr. Bari, I have also passed a similar decision on that.
Yes.
But there, the only decision, that is why I have pointed out. If the posts were in existence, there was a delay in appointment, yes, from the date of the empanelment. But here is a case where posts were created subsequently. Whether
Question
in
is,
that case,
your lordship, remember I made submission, your lordship accepted the submission.
Mr. Bari, this proposition I am aware of.
No,
I also passed I've also passed this on a similar circumstances.
Yes.
I've directed notional benefit from the date of joining, I think, 1 or 2 days back. But here is a case where posts were created pursuant to an order of the court.
No, my lord, this is the distinguishable. Here, my lord, the advertisement was made in 1998.
I follow
according
to you how
unless the
advertisement-
posts are there.
Yes, but
yes,
I follow you. So that for that, I think a report or a affidavit is necessary because
No, my
these
lord,
facts have to come.
they have forwarded finance department. You lordship kindly see the last page. They have forwarded. It is not they have sympathized. They have forwarded the case before the finance department. Your lordship page 64.
64.
However, it appears the petition of high representation dated inter alia stated we have been appointed in 2000. We pray before your good self to consider our prayer sympathetically for giving notional benefit from the year 2000 so that we may not be deprived from getting our seniority
What
as well
happened
as
after
retirement
that? What
benefit.
did the finance department say?
Now the finance department decisions, your lordship kindly see. Whether
Yes.
it is tenable in law, page 66. Page 66. Let it be set aside. Let your lordship kindly direct them to.
Sir, Bari, I think affidavits are necessary because the finance department has said since the posts were created subsequently, it cannot be from a. I think they have to be hard. Let them file the affidavits.
Let them then file the report, finance department.
Okay.
Let them file the report. Next. Your lordship kindly 2 lines report will be sufficient. No further. It is a factual dispute. There is no factual dispute. Your lordship direct the finance department to file a report so that matter can be taken up for next circuit. Finance secretary is the party here.
Appearing for the petitioner submits that the petitioners that though the petitioners participated in the selection process, which was conducted when
1999,
which was conducted sometimes in the year 1999, but the petitioners were ultimately appointed to the post of
assistant teacher in Jalpaiguri school. Assistant teacher of Jalpaiguri school.
Of a high school.
Of a high school.
Assistant teacher of a high school only on December 17, 2010.
Yes.
10. Mr. Bari submits that the reasons for the delay in appointment cannot be attributed to the petitioner, and therefore the petitioner is entitled to and as such the Mr. Bari, you have retired.
No, we are in the service, my lord. The regional service.
Why do you want? For the purpose of pensionary benefit?
No, notional fixation, seniority, headmastership, others, all these they are 10 years. Yes.
I think in this
my examination was held 1999.
Mr. Bari, this judgment, I have followed this principle. This judgment of the division bench was for the some shortfall in the qualifying service for the purpose of calculation of pension.
No, this is not. This is
yes. Division bench is that.
No, single bench, your lordship kind. Single bench.
No, division bench is on pensionary benefit.
A single bench. Your lordship single bench in the same. Your lordship kindly have a look. Let
me see this.
Single bench. Same line. Relying on further division bench.
No, this is also retirement benefit.
No.
Yes, please come to the last paragraph.
Yes, Suman Rai, your lordship kindly notional fixation
will be allowed. Notional benefit will be allowed only for the purpose of calculating the retirement benefits.
No, that may be. That is that they are in the service. They have not retired.
These 2 decisions were for the purpose of condoning the shortfall in the qualifying service.
Condoning of the shortfall service doesn't arise here. It is not the case.
These 2 decisions are for that, Mr. Bari. These 2 decisions are for that.
Not the condoning of the service. Notional, they are in the service.
notional benefit for the
They
purpose
are
of
competing more than 10 years. I did it. They are competing more than 10 years without
But-
notional.
But this is for the purpose of calculating the retirement benefits to them.
No, that scenario will be given. Retirement benefits means
Alright, so
scenario will be
that
given.
will
Huge difference.
Will be.
Now, madam, the selection was conducted 1999. Admit card I have annexed.
Reasons for the delay are not attributable to the petitioner. তারপরে কি বললো? Mr. Bari submits that the petitioner is submits that the date of joining of the petitioner in service should be notionally fixed from the date of empanelment.
Yes.
From the date of empanelment and not from the date of joining in the
Yes.
case on hand.
And
Such an issue cannot be decided without calling for a report in the form of an affidavit from the respondent authorities.
but respondent number 10 is the finance secretary. Finance secretary rejected.
Finance Secretary, Government of West Bengal, being the 10th respondent, is directed to file a report in the form of an affidavit with regard to the issues raised in the writ petition within a period of 4 weeks from.
Well, let it be 2 weeks so that next circuit.
Finance
can be
Secretary,
decided.
Mr. Bari from Nobanno.
Not your lordship, not asking for a report, affidavit, report.
Report, I have said report, but from Nobanno it will come from here.
No, well, let it be
Sir,
2 weeks.
can it be done earlier?
Well, let it be. If there any problem, they will seek for extension.
3 weeks.
4 weeks. 4 weeks.
3 weeks.
Let it be 3 weeks. Well, let it be 3 weeks.
Within a period of 3 weeks from date. First up, parties will be at liberty to mention the matter for inclusion in the list immediately after expiry of the period fixed for filing of the report in the form of an affidavit.
Well, a selection process of 1999, your lordship can leave.
So, Bari, I follow this, but only thing what is troubling me is that the posts were not in existence as on that time. But you
Mala, that
said,
is the creation was made. Mala,
Yes.
I prayed for
So,
the creation.
Mr. Bari, so the creation
Yes.
has to be from a retrospective effect. So creation has to be from a back date also.
Mala, kindly see what has happened. 1999, I appeared. But without vacancy in terms of the
Follow your
advertisement meant.
argument. Mr. Bari, I follow your argument, but the fact situation is otherwise. Fact
No,
situation is
The
posts have been
creation,
created.
Mala, creation different. Mala, when the post has been reported for the advertisement and I participated in 1999, selection process completed, I secured position in the panel. Can you say that there was no post? I have created the post in 2010.
So then
I was
creation
not
of
given
the-
appointment. That's why that was there.
Yes, only difficulty is that of the creation of the post. Let me see whether. Yes, Mr. Bose.
Millard, one small trouble.
Yes, yes.
100
May I pay, my lord, instead of 4, my lord, after the 2 p.m. matters which have been fixed?
Why, Mr. Chatterjee?
But the flight is,
You have just arrived
no, I have arrived in the morning, my lord, was trying to come, my lord,
on your way.
on my way, my lord.
When did your morning start, Mr.
Well, my morning started at 5 o'clock. 5 o'clock in the morning to the airport, coming again here.
Took this much of time to come here.
Well, I was on my way, my lord. In the meantime, my lord, High Court, Calcutta High Court also, my lord. Calcutta High Court. Online, my lord, is a thing now.
Physically circuit through virtually
Online
principle.
Say so. That is why I wanted to do that. It took so much of time for you to come here.
On my way.
What is the time of your?
It is, my lord, I have to reach by 6. So,
It will take 10 minutes.
My lord,
it's almost
no, next, tomorrow, I'll get tomorrow.
possible, my lord. Oh, do it
lord.
tomorrow, also.
Yes, Mr. Rai.
I'm coming in the morning, but I'll take tomorrow morning.
Tomorrow.
I'm coming then.
What is your item?
Yes,
That my lord, yesterday's matter.
15.
15. I did 15.
1-5.
1-5.
All right, tomorrow.
Tomorrow.
He says, your friend,
Yes.
are you opposing?
No, I'm not opposing.
No, he was not present in the morning. I'm coming, my lord.
All right. Yes,
Yes, sir.
call the other 2 p.m. matter. Yes, you have taken instruction.
My lord.
My lord, clients are agreeable.
No, my lord, college has one proposal.
My lord, the entire solution to this problem is solved in your lordship's order dated 3/4/25. And I will explain how. And everyone, all the parties will be in a win-win situation.
No, not that. The question is, what will happen?
Yes, yes. I'm
Where is Mr. Mojumdar? Has Mr. Mojumdar joined? Where is the university? He's here. Where is he? Yes, Mr. Mojumdar.
Yes. May I submit the solution? If the university, in compliance of the order passed by your lordship on 3/4/2025, that is to publish the result within 7th. If the result is published immediately, then what happens? Then the petitioners can sit for their 8th SEM examination.
8th or 7th?
8th, as per the university rules. I will come to that. 8th SEM examination as a regular candidate, which is to be held as per the university schedule from 23rd May till 10th of June 2025. Without clearing the 7th SEM exam. Now, how is it possible? I draw your lordship's kind attention that as per the...
Only one thing.
Yes.
He has not attended the classes of the 8th semester.
Yes. No. They unofficially they have attended.
8th also?
Yes.
7th also?
Yes.
How is it possible?
As the matter was pending on humanitarian ground, they were allowed to.
During which time they attended the classes of 7th semester? During which time?
I can.
There are also internal assessments.
Yeah.
Made. Show me your internal assessments
Now,
which you have made.
my lord, please let me submit one thing. As per the provisions of the university guidelines, for example, notification number COE Macau 21 of 2022-23 dated 7/8/2023, as well as similar notification in the year 2024, there is a provision, a student who appears in the 8th SEM
within 2 months, a special supplementary examination is conducted by the university as per their provisions. Now, then what happens? Therefore, the petitioners can appear for their 7th semester in appearing the separate supplementary examination after completion of the 8th sem, which usually the date is fixed every time within 2 months from the date of 8th sem. That means there will be no year loss at all.
Not a question of year loss. Can he be considered to be a regular
Yes,
candidate?
yes. As per these provisions. Now, but as the petitioners, there is a problem. As the petitioners, they have backlog paper in even sem as well as in odd sem. Now, what is the solution for that? The solution lies that the petitioners with backlog in even sem can sit for their backlog paper in the 8th semester itself after the 8th semester, and the petitioners, those who have a backlog on odd sem, they can appear in the special supplementary examination which is held after 2 months.
Then you disclose this by way of an affidavit, in the report in the form of an affidavit, let the university also disclose their stand.
It
cannot be decided in this way.
No.
Because none of you are agreeing to one thing. So Mr. Majumdar is
No,
giving
this is
one
a solution
proposal.
from my side.
Yes,
I'm
yes.
saying.
So you have to, that is to be disclosed. It has to be
No,
decided then.
No,
Let it be
my
decided.
respected learned senior counsel, Mr. Majumdar is here. He will, whatever I have said, whether it is,
Mr. Majumdar, is it possible?
That special supplementary examination is never taken not unless directed
Alright,
in
so-
the norms of the university.
Milord, one indulgence, Milord, regarding the backlogs, Milord. Milord, our.
All right, let them disclose their stand in the report in the form
No,
of
Milord, if
affidavit.
one review chance is given, because Milord, our result was
All right, these
published.
are all factual aspects, sir.
No.
All these things have to be
No,
considered.
Milord.
If you want to file a supplementary affidavit,
Milord.
you file a supplementary affidavit, let the college disclose their stand. After this, the university will file a report, then it will be decided.
Then Milord, regarding review, one second.
And Mr. Majumdar, you nothing with regard to the holding of the 7th semesters, but you publish the results of the 6th semesters.
As you wrote. Kindly grant us a few days time. The papers have to be evaluated in that time.
The evaluation was done. Only the results have been withheld.
Yes, not their papers. I am told not its evaluation is yet to be completed.
Yes.
2 or 3 days time. Please give us 2 or 3 days time. We shall do that.
All right.
Milord,
So you publish your results. Now the petitioner have to decide which is good for them.
Very
Milord,
well.
one indulgence, Milord. Regarding review, Milord. Milord, because Milord, there are backlogs they are saying, Milord, but we have not given chance.
I'm not deciding anything. I'm only directing them to publish the 6th semester
Yes.
result.
Only
File a
one.
supplement.
No. Please appreciate this. If the petitioner's results for the 6th semester has to be published immediately, say in the month of today, we're in April 2025.
Yes.
This will not be as a regular result
Publish
published.
it as the rules of the university permits. Then they will consider.
That's due to be published in June, July 25.
No. Please publish now. It will be for them. What action they will take.
The results were published in February 2025 for the 5th semester.
Yes.
So the 6th semester result has to be after February 2025.
After February 2025. So now we are in April.
So the 6th semester result for the regular students is due to be published in June, July 2025.
Mr. Majumdar, they are not regular. Mr. Majumdar, they are not regular. They are irregular because in June 2024 their exams were held. So please publish.
But all results were published along with the regular students thus far.
Yes, but
If
these
they
are
want-
exceptions because 5th semester also has been published subsequently. These are all pursuant to the orders of the court.
Right.
So you
So fifth
publish,
semester
thereafter it
exam-
will be considered what will be the effect of that.
Because 5th semester result, please appreciate these things. 6th semester he passes or fails, whatever is the outcome, in March 2025, in April 2025.
Yes.
He takes the 7th semester examination, if at all, in May 2025, which is not due, December 2025, according to us, he is to take this examination.
No, I'm not saying about the examinations now. Only publish the results. I'm
Yes.
not saying anything with results with regard to the examinations. They will be, the petitioner wants to file some supplementary affidavit saying something, review and other things. Let the college also disclose their stand. They are saying in this way it can be, is permissible. Let both of them disclose their stand. You can file a report. Then it will be decided. I'm not saying anything with regard to the semester examinations. Only publish the
Thank you.
6th semester results. I'm giving
Immediate
some time.
compliance of this order.
All right.
That solves the entire problem.
Yes.
No, I was only projecting this. Publication will lead to hazards for the petitioners themselves.
Nothing,
Yes.
nothing.
Mr. Majumdar, let them take that risk. Mr. Majumdar, learned senior advocate appearing for the petitioner, prays for extension of time to publish the results as directed by the order dated, to publish the results of the 6th semester.
I seek for leave to file to publish the result along with the regular students.
No, that cannot.
Your lordship, your lordship,
Yes,
that's
yes,
the court's order. My
Yes,
instruction is to
Yes,
publish
I
it
will
along with the
record your
regular
submission.
My
Yes.
lord.
Mr. Majumdar, learned senior advocate, appearing for the university, submits that submits the prays for leave to publish the results of the petitioner for 6th semester examination, along with the regular course candidates.
Regular
Along
course
with
candidate for the 6th semester.
Along with regular course candidates for the 6th semester on July.
In June, July 25. In June, July 25.
In June-July 2025. Stop. At this stage, it would be relevant to take note that the petitioners appeared in the 6th semester examination and in the year 2024, and the last date of the examination
Appeared in January 2025.
No, 6th semester June 2024.
10th June to 28th of June 2020.
No, he says 22nd. What is the correct date?
No, that was the scheduled date.
No, what is the last date of your examination?
24th June was the last date.
On June 24, 2025. And the last date of such examination was June 24, 2024. Full stop. In view thereof, this court directs the university to publish the results of the petitioner of the 6th semester exam.
My learned friend will kindly correct himself. Please come to paragraph 8 of the writ petition. He appeared in January 25 for the 6th semester. That's his pleading.
Paragraph
8 at page 6.
January 2024 is the 5th semester.
6th is 25 probably. That's what he meant.
Where is 6th? Where have you stated when you appeared on 6th?
My lord, in the readings in the paragraph 8,
yes,
it is mentioned the submit petitioners appearing to papers of 5th semester. 5th semester's 2 papers were taken in January 2024.
Yes.
And thereafter petitioners appear in the 6th semester examination. And in the date is not mentioned. And in month of January.
You have not mentioned the date in the pleadings.
It is, Mr. Gap. I'm making apology on that.
For the 6th semester, which the petitioners claim to have appeared in the month of June 2024, on or before April 17, 2025. As paid for by the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit for bringing on record certain additional facts. Let such supplementary affidavit be filed within
a week, my lord.
Within a week from date, and copies of such supplementary affidavit be served upon the university as well, upon the learned advocate for the university, as well as upon the learned advocates for the university and the college immediately thereafter. First up, the college and the university will be at liberty to disclose their stand with regard to holding of 7th semester examination and 8th semester examination of the petitioner in their report in the form of an affidavit to be filed within a period of 2 weeks after service of such supplementary affidavit. So, petitioner will be the parties will be at liberty to pray for inclusion of this matter in the list immediately after expiry of the time fixed for filing of the report in the form of an affidavit by the college and the university.
My lord, one indulgence matter. The result of the 6th sem, which is withheld, that should be published immediately.
Yes, sir, 17th I've said. 17th of April, bolechi to.
Then everything will follow automatically.
I'm obliged.
Only one humble submission, not so that it does not goes down as my prayer.
No, I've said you paid for leave to publish along with the regular course, but this is the court's direction.
That's it. The court's direction. Very
17th is the court's direction. I've recorded.
court's direction. My lord.
যাতে শুনতে পায় ওই মাইক্রোফোনের কাছে। হ্যাঁ, মিস্টার মজুমদার সাবমিশন এখানে শুনতে পাবেন।
Mr. Mojumdar, learned senior advocate appearing for the university, prays for leave to publish the results of the petitioner for the 6th semester examination along with the regular course candidates for the 6th semester in June, July 2025.
That I've recorded that and I've directed you to publish on 17th.
That's it.
On or before 17th.
On or before 17th.
Greatly obliged. Yes, call the next matter. Yes,
I am praying for next circuit, my lord.
as prayed for by the learned advocate for the petitioner, list this matter before the next ambulance second main. Yes, call the next matter.
Lordship, 27 to 37, I appear virtually, Lordships.
Yes, Mr. Kanoria. Yes.
Lordship, this matter relates to GST.
27 to 37. I am for all the
State GST or central GST?
Central GST, Lordship, Central.
Yes, who
Central is appearing virtually, Lordships. They are appearing virtually.
But we pray for adjournment. Actually, yesterday, my lordship, the learned counsel had prayed that today they will not.
Lordship, I was at Supreme Court, so I told your Lordship I may be at Supreme Court for some difficulty. But now that matter happened pre-lunch. Therefore, I joined it.
My lord, the senior counsels are not there, my lordship.
Lordship can keep it tomorrow then. Tomorrow first.
My lordship, I prefer next circuit, my lordship.
Lordship, I am waiting for the first week of this circuit. On first day when it came on last
Tomorrow
Wednesday.
you come.
Lordship, last Wednesday they took time for instructions. Last Wednesday they took time for instructions.
Lordship, kindly some preference may be given.
Lordship, kindly some preference.
Lordship, since this matter is running since long.
Lordship, since
you have got today.
Lordship, kindly give some preference, Lordship.
Yesterday you paid for time.
No, Lordship, I didn't.
No, Lordship, we haven't paid for time.
Lordship, I was there till 4:30 in the court.
All right.
Lordship, kindly, Lordship, some preference,
My
Lordship.
lordship, kindly
Some preference,
permit
Lordship.
to next circuit, my lordship, because the council will not be available, my lordship, yesterday tomorrow. They have a matter, GST matter in regarding arrest of a person in Siliguri, my lordship.
Yes,
Lordship.
yes, tomorrow. Yes,
Yep.
next. Call the next matter.
That will not be transmission.
Yes, Mr. Ghosh.
Transmission company will not supposed to the.
Yes, where is the transmission company?
They were supposed to come and disclose, Millet, who is the authority under the Telegraph Act.
Yes. Nobody is here. Why today the court is vacant?
I think tired, I think so.
Mr. Kanodia's 10 clubbed matters probably scared
From
everyone.
my, yes. From my end, my lord, the
Not today.
my lord, then tomorrow, my lord, we'll keep it in the next circuit. Otherwise, my lord,
কালকে
purpose
থাক,
remain.
তুমি তো শুক্রবার থাকবে।
Yes, yes.
Tomorrow will tomorrow.
Tomorrow আর কিছু হবে না। নিয়ে যাতে পারো ফাইল।
Just call the next matter.
Okay.
39 yes.
Transaction component. My lord, I am appealing for the petitioners.
My lord, 39, Mr. Arijit Chakraborty is appearing for the Enforcement Directorate, my lord.
My
Yes.
David of service.
Where is Mr. Chakraborty?
Lord, he is before special court, my lord, engaged in before
Is
special.
for special court,
Yes, my lord.
not ordinary court. Yes. Yes, yes. Yes,
My-
what do you want?
My lord, my matter is, I am an owner of a flat. The deed of my conveyance is annexed in the annexure P2. In the due course of time, due to my necessity, I want to sell my flat. And what happened? I have duly paid the stamp duty and the registration fees, and I've presented my deed of conveyance on 7/1/2025. My lord, my annexure P4, page number 37. What happened after that? That the ADSR Shiliguri, they informed me that the property has been put on hold due to a order of the Supreme Court that has been passed. And they have handed me over to me a document that is the annexure P5, my lord, page number 38.
38.
Page number 38. They have handed over to me that document. Whereas after that, I came to know that the ED has put on the hold to another property which is situated in the same building.
But what is your log number in respect of where your property is
My lord,
situated?
it is a flat. It's a
Yes,
building.
flat has to be situated on some plot numbers.
Yes, my lord.
What is the
obviously.
plot number?
My lord, my plot number. My lord, my RS plot number is 9460 and RS Khatian number is 6106.
RS plot number is?
9460.
Yes.
My lord. Now, what has happened is they have.
But this is not within this list.
Yes, my lord. If you come to page number 66, my lord, the 13 number, the serial number 13, they have annexed a flat of 900 square feet, which is situated in the same building.
Yes.
My lord, now how I am, my right is being deprived is that I am not being able to register my sale deed. My lord, I am simply seeking a direction upon the ADSR to register my sale deed and continue with the sale proceeding.
Approach the ED.
My lord,
My lord, that
There
is
is no
not,
objection from that.
my lord,
ED can say, yes, your property is not attached.
No, no,
my lord,
no,
my
my lord.
property is not
Their,
at all
their
attached, my
property
lord.
has not been attached, my lord.
Yes, my
We
lord,
have
that is the thing.
attached the property in the 4th floor, my lord, and their building is on a 1st floor. That is
Yes,
flat
my-
number C.
That
So
is
you
my,
file an affidavit in that regard. So you do not have any objection with regard to
No,
the
my lord, no,
registration?
no, my lord.
File an
The
affidavit to
contention
that
of the
regard.
petition, we have no objection, my lord.
The
I'll file the
petitioner
affidavit by tomorrow.
by tomorrow and to be heard day after tomorrow.
If my,
Thank you. Yes. The petitioner, the learned advocate appealing for the petitioner submits that the petitioner presented the deed for registration before the concerned registration authorities, but the registration authorities have refused to register the same on the ground that the property is subject to an attachment order by the Enforcement Directorate. First up, paragraph. The learned advocate appearing for the Enforcement Directorate submits that the property in question, that the property of the petitioner, which is the subject matter of the writ petition, is not has not been attached by the Enforcement Directorate. First up, have you implemented the Enforcement Directorate?
yes, my lord.
Which respondent?
Point
My
number
lord,
3, my lord.
respondent number 3.
Three, my
The additional, the office of the Additional Directorate Zone 1 Enforcement Directorate, being the third respondent, is directed to file a report in the form of an affidavit disclosing their stand as to whether the property of the petitioner is subject to any attachment by the said authority.
My lord.
It's such report in the form of an affidavit. Yes, how
My
soon
lord.
can you file?
My
How
lord,
soon?
My lord, 1 week.
Within a week from date. First up, list this matter before the next available circuit bench. Affidavit service filed in court today is taken on record. The state is represented by its learned advocate. Now,
I'm for the respondent number 3 here. Grateful, my lord.
Yes, call the next matter.
Lordship, Mr. Ratan Das appearing virtually in this matter.
I am for the private respondent and I have some serious objection regarding the
Serious objection.
maintainability of the writ petition.
Why?
For a private institution, my lords, and no public duty element is being involved here in bus flying. Lords, I give it to somebody else, I give it to whomsoever.
You are the St. Xavier's?
I'm the school.
Lordship, our grievance against the RTA Coachbehar, Lordship. Despite
What RTA is doing?
Lordship, RTA Coachbehar, despite knowing the fact that the we have agreement between us to upon 6 year, Lordship, but we have made representation to them, but without considering that representation, another permission has been given to the other bus owner, Lordship.
Have you implemented them? To whom? So according to you, you have been discriminated.
Yes. Yes, Lordship.
Where is the case made out of discrimination?
Lordship, page 10, Lordship.
Page 10.
Yes, Lordship.
Page 10 is the representation.
Lordship.
In the writ petition, you have not made out any case of discrimination. Nothing has been said.
Page 10, Lords, is my letterhead of the school.
Yes, my representation.
I have agreement with them, but how is that enforceable under public law doctrine, my lords?
Yes, Lordship, because the RTA, despite knowing.
Yes, can be enforced. Private contract, you are saying yes.
Despite knowing the fact that RTA Coachbehar we have a contract between us,
another school bus permit to the said school.
Yes, Lordship.
Permit has been issued to the school. What is your prayer? I could not make out anything from your prayer.
Lordship,
please place your prayer.
Lordship, in this matter, Mr. Ratan Das appearing.
That's I will explain. They were flying 2 buses with the school. Now the school wants to engage more buses because the number of students have increased. Now, based upon my agreement with them, they are challenging before the RTO that others should not be allowed to the given permit.
He is having permit.
Yes,
having permit for 2.
Yes, we have permit.
But you don't want others to.
No. He will do it.
Lordship, there are so many issues, Lordship.
What are so many issues? Tell me one of the issues.
Lordship, Mr. Ratan Das appearing in this matter.
I am amenable to read jurisdiction.
The prayer of the learned advocate for the petition. Where is Mr. Ratan Das?
He is supposed to appear in virtual.
Supposed to. Let him appear before the next available circuit bench. Yes, call the next matter.
Same matter, my lord.
Next, same order. Next.
Keep your list.
Lordship, affidavit in service. Lordship.
Every service taken on record.
Lordship.
That will be taken on record. Yes, next.
Grateful, Lordship.
Yes, 42. Yes, who is appearing in this matter? No one is. None appears for the petitioner at the time of call. No accommodation has been sought for either. WPA 694 of 2025 stands for default. Yes, next.
I'm praying for next circuit.
Prayed for by the learned advocate for the petitioner is this matter in the next available circuit bench. Yes, next.
I am for the petitioner, my lords. I am challenging the technical disqualification in a tender matter Mr. Singhania was there on the last occasion, Lord, he accepted the notice in court.
Revision will.
Not today, next.
Lords, in this case, Lords, if they open the financial, then my writ becomes.
Yes.
Lordship, with some accommodation for filing a short report with some documents.
Lords, they let the financial be straight in that case.
No, Lordship.
Otherwise, my writ will become infructuous.
No. Lordship,
They will not open the financial bit till the time the report is filed.
No, Your Lordship. The SSB matter.
So what?
Tender relating to rations.
Huh.
Two persons, Your Lordship, two
If you are
enterprises.
not ready today, Mr.
Not-
You can come tomorrow.
Lordship,
Yes.
tomorrow.
Lords, in
I
the
am
meantime,
prepared,
let the financial be not.
No, Your Lordship.
Tomorrow,
Not-
it will be open today.
They can open it anytime.
Might have opened before this matter has been called.
Now they will definitely open, Lord.
Yes, next. Call the next matter.
45 minutes.
45, yes.
I am for the petitioner, my lords. This is the matter.
Is the one to take. Yes, transfer.
No, no, my lords. Herein I missed a counseling because I was ill, my lords. Therefore, my lords requested them to seek
Where is
whether
the school service
another
commission?
opportunity.
My lord, I am appearing for the School Service Commission.
Can
My
he
lord,
be
kindly
allowed to
take up the
participate?
matter.
Can he
My
be
lord,
allowed?
my lord, I have not received the brief, my lord, yet, my lord. My lord, I have only instruction to appear, my lord. I have not received the brief from the School Service
Tomorrow?
Commission office. My
Tomorrow?
lord, kindly, yes, my lord.
Tomorrow, yes. Please consider as to whether the petitioner can be permitted to participate in the fifth counseling,
As per,
fifth round of counsel.
as per the 2015 rules.
Yes. Next. For the next matter.
My lord, 46.
Yes,
My lord, 46. My lord, I am for the petition.
yes.
My lord, this matter, my lord, pertains to a transfer of a school assistant school teacher or government aided school. My lord, petitioner applied for transfer in the designated portal, that is Utsoshri. Your lordship may find page number 17 that extract my application. My lord, 6th of July 2022, it has been applied through my lord Utsoshri portal. Page 70, which is pending before the school authority. Already I am seeking a mandamus to consider my application in accordance with law.
Authority, have you served the school?
My lord, school, my lord, possibly school, my lord, start, my lord, let DI is appearing, my lord, school is, DI is, my lord, school is going to the application, is the process is first application going to the DI, after necessary NOC, DI will consider.
DI through the school.
My lord,
Yes.
Yes, to
the
go to the DI
school,
through the school with the no
My lord,
objection of the
yes,
headmaster.
If the school, yeah, if the school think fit, my lord, since my lord, I don't know, my lord, if the school think fit,
Have you served the school?
in accordance with law. My lord, I do not.
Yes, yes, Mr. Shah, what is your instruction?
Not. My lord, kindly let it be directed to the school in accordance with law. Consider my application in accordance with law. If they think fit to subserve the justice, my lord.
The petitioner.
my lord, then my lord, kindly direct the school authority to consider the application, and if the school authority thinks fits, then transfer it to the DI.
Yes.
Yes.
Petitioner
Yes.
claims to have applied, the petitioner who is an assistant teacher of junior,
My lord,
of a junior high school in the district of Jalpaiguri.
Yes, Borogari Junior High School.
In the district of Jalpaiguri has paid for transfer to a school which is near to the residence of the petitioner. The petitioner claims to have applied through the Utsoshri portal for transfer. The learned advocate appearing for the petitioner submits that the school authority has not yet forwarded the application for transfer to the concerned district inspector of schools. Paragraph. Where is your affidavit of service?
Yes.
Affidavit of service, school has been served. affidavit of service filed in court today is taken on record. It has been submitted by the learned advocate for the petitioner that all the respondents have been duly served. Paragraph, the secretary of the ad hoc committee, Uttar Paragari Junior High School, being the sixth respondent, is directed to consider the application for transfer of the petitioner. First up, if such authority to consider and to take a decision as expeditiously as possible within a period of 4 weeks from date. First up, if the said authority decides in favor of the petitioner, if the said authority decides in favor of the petitioner, consequential steps shall be taken by the school authority in that regard. First up, paragraph, the respondent authorities shall the other respondent with the above observations and directions, the petition stands disposed of. Yes, next.
I'm grateful, I'm grateful.
Grateful, my lord.
Lordship, one analysis, Lordship, one analysis, Lordship. Item number 42, Lordship. Mr. Shaktiwata Jana will appear, Lordship. Lordship, there is a resolution, Lordship. He could not appear, Lordship. Kindly, Lordship.
What happened? 42.
Dismiss for default, Lordship.
So default. Restored for the. Yes, next.
Great. Lordship, please number tomorrow, Lordship.
Advocates from Calcutta High Court are not appearing in courts.
Yes, Lordship. Some matters.
All right.
No, my lord. Those who are, my lord, attended the
all right. So
funeral,
I remember this.
There is no, my lord, there is no bar to attend. My lord, person anybody can.
My lord, only resolution has,
practicing in the principal seat, they are not appearing. All right.
my lord, only resolution has been adopted.
Yes,
no
yes,
order
yes.
should be passed in absence.
All right.
Absence.
Yes.
My lord, 47. My lord, 47. I am for the petitioner. This is also, my lord, 47. My lord, I am for the petitioner. This is also for the transfer. My lord, what happened, my lord? There, my lord, I applied in the Utsosri portal. My lord, page 18, your lordship may see my transfer application, which has been considered by the school authority and rejected that, that already quota of is completed. My lord, what happened? My lord, thereafter new teachers have joined. My lord, Utsosri's portal has suspended from 29 September.
Best of luck for the next time.
Yeah, better luck next time. Better luck just like a lottery. My lord, there, what happened, my lord? Why I am here at this stage? But thereafter, new incumbent, new teachers is joined in the school. Teacher strength is also augmented. Yes, yes. That liberty I want. That liberty I want. In
Why liberty is necessary?
My lord, portal is suspended, my lord. Until and unless court is interfered at this stage, my application could not process, my lord. That is why, my lord, I am here.
Yes,
my lord, at this stage,
what you say?
My lord can give liberty to the petitioner to apply afresh in offline mode, my lord.
Offline mode. Yes.
Offline mode, my lord.
The petitioner.
My lord, in prescribe pro forma, my lord.
All right. The petitioner who is an assistant teacher of
Milord, Deogaon High School. Deogaon House, respondent number 6.
High school in the district of Alipurduar. Prayed for transfer to a school which is near to her residence. Her or his?
Her. Joita.
Through Utsosri portal. First of the learned advocate appearing for the petitioner submits that the prayer for transfer was rejected by the school authority on the ground that the quota was already completed. The quota has already been completed. First up, the learned advocate further submits that in the meantime, several other teachers have joined.
Yes. That I have averted.
Have joined, and as such, there is no impediment on the part of the school authority to consider the prayer of the petitioner for transfer. First up, the learned advocate for the state and the school service commission. First up, the learned advocate appearing for the school service commission submits that if the petitioner applies in a prescribed form through offline mode, the same can be considered by the authorities.
in accordance with law.
The same shall be considered by the authorities in accordance with law. First up, in the light of the submissions made by the learned advocates for the parties, WPS 699 of 2025 is disposed of by giving liberty to the petitioner to apply for transfer through offline mode in prescribed format. First up, if such an application is filed, the authorities will consider the same and take necessary steps in accordance with law as expeditious as possible.
That's
Next.
grateful. I'm grateful.
Next.
At 48, I am appearing for the petitioner, my lord.
Yes.
In this matter, my lord,
But then I am appealing for the DPSC Kuch Bihar, my lord.
2004 September, yes, your lordship. My lord, the petitioner was appointed for the post of Gram Panchayat Kormi, which is a substantive post, my lord. Subsequently, my lord, he appointed as an assistant primary teacher of a concerned primary school, my lord. My lord, there is no break service. So, my lord, and after completion of his service, my lord, after his superannuations, my lord, the pension payment order was issued where, my lord, he has not received the pension but the gratuity. Now, my lord, the pension not been issued on the ground that he has not completed the eligible qualifying service. Not qualifying service, the period, lordship, the 10 years period. Now, lordships, the petitioner approached before the Honorable High Court, my lord, there was a direction to consider his grievances and
Show me the rule which permits that
now,
this.
Yes, my lord. Rule, my lord, it is, my lord,
Is there any notification?
There, my lord, where it has been stated what is qualifying service. In
Qualifying
my lord,
service.
that qualifying service is that, my lord, where the
In the impugned order,
yes,
order
my lord.
passed by the DPSC, it has been referred to the principal secretary.
Not referred to the principal secretary, but has not yet come up with any any intimation, lordship. Now, my lord, lordship can.
So I mean direct the principal secretary school education department
Yes,
to
my lord,
consider
41, because unless he considered rightly, negatively or positively, I cannot proceed further, lordship.
But
Because
who will consider? 4 authorities have been directed.
principal secretary, they have already sent, lordship, the order, the recent order is not exactly against me. Because, my lord, in the recent order, it has been paragraph number 2, lordship, kindly see. On a perusal of the documents, it transfers that the petitioner was selected appointment to the post of Gram Panchayat Kormi by memo number such and such. Then a letter of appointment was issued by memo number such and such, and accordingly petitioner joined as Gram Panchayat Kormi. He tendered his resignation to the said post as Gram Panchayat Kormi on 6/2/2011. Accordingly, the petitioner was appointed to a substantive post of GP Kormi in a regular salary established.
Yes, Mr. Shah, who can take this decision? Because page 42, it has been referred to various authorities. Who will take this decision? Commissioner of School Education.
Because the thing remains that Panchayat Karmis are given the benefit under a different school.
All right, so with the secretary has referred it to various authorities.
Secretary has referred it to the school principal secretary school education department as well as to the commissioner of school.
So principal secretary school education department can take the decision.
Yes, principal secretary can. Respondent number 2.
The petitioner was initially appointed as a Gram Panchayat Kormi. First up, the petitioner thereafter tendered his resignation from the post of Gram Panchayat Kormi and was appointed as a primary teacher under District Primary School Council, Kuch Bihar. First up, the petitioner joined the post of the primary teacher on 7th of February 2011 and he retired from service on July 31, 2020 after attaining the age of superannuation. First up, the prayer of the petitioner for release of the pensionary benefit was not acceded to on the ground that
the petitioner did not complete the minimum period of 10 years as a primary teacher for being entitled to the benefits of pensionary benefit, for being entitled to pensionary benefits. First up, pursuant to an order dated February 28, 2023, passed by a coordinate bench in WPA 377 of 2023, the Secretary, District Primary School Council, Kuch Bihar, referred the matter to the Principal Secretary, School Education Department for taking a decision in this regard. First up, in view thereof, WPA 700 of 2025 is disposed of by directing the Principal Secretary, School Education Department being the being the second respondent to consider the issue as to whether the past service of the petitioner as a Gram Panchayat Kurmi can be considered, can be taken into consideration as while determining the qualifying service of the petitioner for being entitled to the pensionary benefits. First up, the Principal Secretary is directed to pass a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative and communicate such reasoned order to the petitioner immediately thereafter. First up, the entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy. 8.
The matters relating to pension.
Pensionary benefit. Please do it within 6 weeks from the date of receipt of a server copy of this order, along with the copy of the order dated April 17, 2023, passed by the Secretary, District Primary School Council, Kuch Bihar. First up, it is however made clear that it will be open to the petitioner to rely upon any government notification from our government orders and or the orders of the court in support of the contention in support of the case of the petitioner in at the time of hearing. If it is service filing, court is taken on record. Yes, call the next matter. Next matter.
I am for the petition.
Yes.
My PR is to release the pensionary benefit.
Yes, Mr. Das, release the pension.
My lord,
why are you not releasing the
no,
pension?
my lord, the suspension is pending before the DPSC, my lord. Once they
Criminal case pending.
Yes.
criminal case
Last
acquitted.
time,
My lord,
no, I have been acquitted by the trial court. I have been acquitted.
my lord,
You have been acquitted.
Yes.
Have you placed the order before the
Yes,
authority?
yes.
Where is that?
Kindly see, first, kindly see page 40, 40.
40.
Yes, 40.
So where is the decision rejecting your claim for pension?
No, initially, my PR has been rejected.
No, thereafter you have, according
At
to
that
you,
time,
you
I
have
was
been
suspended.
acquitted. Thereafter, you have brought to the notice of the court.
But no decision was taken.
Where is that?
Page 42.
42.
The representation and no 41, my lord. 41. And my lord, page 40, my lord, this is the order of the learned court below.
Yes.
my lord,
What decision have you taken?
my lord, DPSC has to take the decision.
No, no.
Once the suspension goes, no, no.
DPSC forwarded all the papers to the district primary school council. Kindly see page.
DPSC is the district primary school council.
Yes, my lord. Kindly see, my lord.
But once the suspension goes from there, and then I can release the pension.
Yes, yes. Who will take this? You are appearing for whom?
The district inspector of schools, my lord, the state authorities.
My lord, page 24, my lord.
Who is appearing for district primary school council?
District primary school. Page 24, my lord. Kindly see.
Who has issued the order of suspension?
DPSC.
Where is that?
page 24, page, my lord, 20. This is the suspension order.
So that authority has to take a.
Well, that authority has forwarded all the paper to that DI, my lord. Kindly see page 24, my lord. Kindly see page 24.
Page 24.
Yes, my lord.
Yes, it has been sent to the district inspector of schools.
Yes,
Mr.
so
Das.
all the
Well,
papers
they have to say that the suspension, their order has to go first. Well, the order of at page number 20. Once that goes, we can release the pensionary.
Yes, the suspension order has to be withdrawn first. Have you made a representation to the DPSC?
Yes, my lord. Yes.
Where is that?
My lord.
Well,
Page 46.
46.
48 would be the.
Well, several represent 46, 48, my lord.
Which is the most comprehensive one?
Well, comprehensive, my lord, 46, my lord.
Petitioner,
48 to DI.
the grievance of the petitioner is that the respondent
next.
authorities
Next.
have not released the pensionary benefits in favor of the petitioner. First up, Mr. Das, learned advocate appearing for the state submits that the petitioner was placed under suspension on the ground of pendency of a criminal case. Mr. Kundu, learned advocate appearing for the petitioner submits that the petitioner has been acquitted in the said criminal case and the order passed by the criminal court was submitted before the chairperson, District Primary School Council, Kuch Bihar, but such authority has not taken any decision with regard to the prayer of the petitioner for withdrawing the suspension of pensionary benefits. First up, the petitioner submitted a representation before the chairperson, District Primary School Council, Kuch Bihar, by letter dated February 24, 2025. First up, after hearing the learned advocates for the respective parties, this court is of the considered view that the interest of justice would be subserved if the chairperson, District Primary School Council, Kuch Bihar, is directed to take a decision on the representation of the petitioner within a specified time limit. First up, without entering into the merits of the claim made by the petitioner in the said representation, WPS 712 of 2025 is disposed of by directing the chairperson,
That's for number 6.
District Primary School Council being the sixth respondent, to consider the representation of the petitioner dated 24th of February 2025 and to dispose of the same by passing a recent order after giving an opportunity of hearing to the petitioner or his authorized representative and to communicate such decision to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the date of receipt of a server copy of this order along with the copy of the representation dated 24th of February 2025. In case the said authority decides in favor of the petitioner, consequential steps shall be taken by such authority.
Yes, sir.
Yes. Next.
My lord, item number 50, my lord, I am appearing for the petitioner. My lord, it is that matter transferred on special ground. My school is situated, my lord, school is situated in Uttar Dinajpur. Whether that petition is maintainable or not, as per territorial jurisdiction, that point arises. My lord, last occasion, I assure your lordship, my lord, I satisfy your lordship. My lord, first of all, my lord, I am relying on decision of our High Court principal bench that is reported in, my lord, CHN volume 4 to 2012-186. Mr. Loskar, kindly give that decision. Sadhun Kumar Kundu.
I have given you.
Lord, Sadhun Kumar Kundu, your lordship, division bench decision, it has been said, my lord, if paragraph number 13, any part of cause of action arises in the court has the jurisdiction to entertain that application, read petition. My lord, paragraph 10, your lordship may find. any part, that ratio is any part of the cause of action arises in the jurisdictional court, in that
Yes.
jurisdiction, the court has.
Yes, so here
I am, yes.
part of the cause of action here arose in the district of Uttar Dinajpur, which is outside the
My lord,
territorial jurisdiction.
my lord, subject to correction. My lord, I am resident of Siliguri. I am residing in there. Every day I am going there. My lord, another decision. My lord, my lord, this, my lord, circuit passed an order. My lord, kindly, Mr. Loskar, kindly, Orjita Roy. Mr. Loskar, kindly give the Orjita Roy decision. My lord, identical point. Uttar Dinajpur. That is why, my lord, Orjita Roy, my lord, kindly see paragraph number 2.
Show me how the point of jurisdiction was decided. Show me that it was raised and it was decided.
My lord, in Orjita Roy.
Yes. Show me that the issue of jurisdiction was raised and decided.
No, that has not been decided. Then my lord, what happened, my lord? I am seeking transfer in Siliguri. I am seeking also transfer from the Siliguri.
That cannot be a ground.
My lord, I am deciding, my lord, each and every day I have to travel from my Siliguri to Uttar Dinajpur. My lord, I am the resident of the Siliguri. My lord, it is, my lord, prerogative to me to file in proper.
Who will ultimately take the decision? The SSC?
School Service Commission. School Service Commission.
Where the office of the School Service Commission is situated?
Kolkata.
My lord, in Salt Lake, my lord. None of the authority, my lord, considering authority is, my lord, situated under the jurisdiction of the.
If you want, I can give you liberty to file before the principal bench, or I will direct filing of affidavits on the point of jurisdiction. Yes. Choice is yours.
Then, my lord, I am withdrawing this writ application. Give me liberty to file a fresh.
After some argument, the learned advocate appearing for the petitioner raised for withdrawal of this writ petition with liberty to approach the principal bench for self-same relief. First up, as paid for by the learned advocate for the petitioner, leave is granted to the on the prayer of the in the light of the submissions made by the learned advocate for the petitioner, WPA 714 of 2025 stands dismissed as withdrawn with liberty to the petitioner to approach the principal bench for self-same relief.
My lord, only one point, my lord. My lord, instead passing this order, your lordship straightaway transfer this file. My lord, this is also permissible. Your lordship also permissible, my lord. This file to the principal bench. Generally, we filed an application for principal bench. My lord, principal bench also converted it to transfer the matter to the.
What is the difficulty, Mr.
It is permissible.
If it is transmitted,
another for they will file here, they will transfer there. They will file here and
My lord, principal bench generally asked us to transfer the.
My lord, it is permissible. Your lordships can transfer the brief from the circuit bench to principal bench, my lord.
Yes. It is permissible without withdrawing the matter.
After some argument, the learned advocate appearing for the petitioner submits that that the records of the instant case may be transferred to the principal bench since the petitioner is at present serving as an assistant teacher of
Kaligach Miling Bosti Junior High School.
And the same is and such school is situated outside the territorial jurisdiction of the circuit bench of the High Court at Jalpaiguri.
The direction be given about it to serve up the GP office because we have lost our jurisdiction.
Yes, that they have to do.
Yes.
Let the records of this case, but I do not know because I think it would be better.
A new number will be generated, my lord.
No new number, my lord.
Nobody knows. And the
new number is
allotted.
Yes.
Renumbered.
Yes.
New renumbered. It will be renumbered.
Let the records of this writ petition be transmitted to the principal bench. First up, the department is directed to take necessary steps for expeditious transmission of the records of this case before the principal bench. First up, the of this case before the principal bench.
Extremely grateful.
The petitioner is directed to communicate this order as well as a copy of the writ petition upon the learned government pleader, High Court, Calcutta, as well as the other respondents.
Lordship.
On the next day. Yes, call the next matter.
Grateful, my lord.
I'm for the petitioners.
I for the state, my lord.
What do you want?
Well, this issue involved in the writ petition, my lord, where the petitioner is the widow of the deceased employee can get the family pension after deferring the CPF amount along with the interest. That is the issue.
Special bench has decided.
Yes, already decided. My lord.
Yes.
My lord, kindly see, my lord, lordship's order, my lord.
Special bench is there. Why are you relying upon a single bench judgment?
No, my lord, I have relied division bench judgment. Page, my lord, 28.
Page 28, yes.
Yes, my lord.
My lord.
Page 28, my lord. Third paragraph, my lord. Can you see?
Yes, Mr. Shah.
Petitioner cannot be favored with any order, my lord.
Why?
Because of the fact a report has also come from the DI.
The DI report, my lord, that they had put choosers
Please,
option.
please.
Oh, evidence.
My lord. Paragraph number 4. As per judgment and order dated 16th of the Honorable Special Bench of the Honorable High Court, Calcutta, in connection with APO number a notification was published by the School Education Department, Government of West Bengal, by notification number 749 of the 2014 circular, and 3 months time period was offered to the teaching and non-teaching staff of recognized and non-government aided educated institutions, whether in service or retired, to switch over to pension come gratuity scheme under the West Bengal.
Yes, what do you say to this?
Well, kindly see division bench judgment, my lord.
And my lord.
Well, kindly see.
Paragraph number
Page
5.
28.
As per the aforesaid notification stated in paragraph of the husband of the petitioner should have exercised his option within the said timeline of.
But
3
Mr.
months.
Shah, they will have to refund the entire amount together with interest.
Yes, my lord.
Till that date.
Yes. But they have not, some.
They want that. They want you to calculate that amount, they will deposit that.
No, there's a policy.
No, if they cannot deposit, then gone.
Yes, my lord. Somewhere in some paragraph.
I am ready to deposit, my lord.
He is now ready
Yes,
to
my lord, as
deposit.
per the division
Now
bench
you have
judgment order.
collected.
Yes,
money.
Then it's all right. Then it's previously they showed so many grounds that we are not in a position.
No,
to
now
enact
they
it.
are.
Corrected.
You have passed an order. All right. Same order. Disposed of next. Yes, next. Yes, yes, same.
52, my lord. Next item, same.
Yes,
my lord.
same.
Yes.
Same order.
হিসাব তো দিয়াই করা আছে হিসাব ডাইরেকশন
Yes, next.
নেক্সট
53, my lord, I am for the petitioner. My lord, yesterday's matter, my lord, I am relying upon one judgment of 2006, 9 SCC 195.
You have got hold of that judgment.
My lord, gratefully, your lordship. My lord, that judgment along with my lord rule also, my junior is there, my lord. My lord, that judgment kindly come to paragraph 2 and paragraph 5.
Yes, what do you say to this? Now he has got that judgment. I have given him a clue and he has got that judgment.
Gratefully, your lordship, my lord. And rule, my lord, kindly come to rule also.
But you did not bring that judgment.
Yes, my lord. That is my
Yes.
fault, my lord.
What do you say to this?
The division bench of this honorable court Justice, Honorable Justice Boshak also said that it is not the hereditary right. That is what just I am saying.
No, no, no. It's
Because,
not a hereditary right.
because at the time of the death,
Nobody is saying it's a
child was
hereditary right.
already 13 years.
Compassionate appointment is not a matter of right. So only right to be considered in terms
Yes,
of
my
a
lord.
scheme or the
Scheme.
relevant rules. That is only, but here is the question of a minor. That person was minor at the relevant point of time. What do you say? Have you seen this judgment? Or you want to go through this?
Not sure I will go through.
Come tomorrow.
Not sure.
Yes. Yes, call the fixed matter.
Grateful, Your Lordship. না, পড়তে দিন।
Mr. Chatterjee will not be allowed to what?
No, my lord, I am today, my lord, a circuit bench lawyer.
I've heard it has been said that resolution has been adopted and you are very much member of the
Resolution, my lord, is, if I was in
Calcutta High Court Bar
Calcutta,
Association.
if I was in Calcutta.
You are not a member of this bar association.
Today, I'm, my lord, I'm a practicing lawyer in Jalpaiguri.
Have you been admitted as a member of this bar association?
Deemed admission. Deemed.
Not deemed.
It is actually, my lord, for me, it's a very sad day. Because
Why?
if your lordship remembers, I first opened my mouth before.
I also,
Your lordship,
I also remember those days.
it was the first day my lord went and mentioned and opened my mouth for the first time in my life before. So it was, he came after my father passed away. Who was sick. It's not that he was very ill and hearty, but he was elder than my father.
Yes.
He was about 2 or 3 years older than me. So a lot of memories come back
Yes.
because there was a time when they
When
were
I
all
received that message, those
days.
initial days of my practice,
Yes. Same
All the motor vehicles matter, my lord.
that
even order
when we
41
started, when I started, it was first step.
Order 41 as well.
Order 41 and first step.
Your lordship's elder brother has at least, Lord, in a day he would get at least 7 to 8 matters admitted. And all those matters were on the ground that the appellate court had not framed issues while deciding the appeal. So he was that liberal, my lord, in admitting appeal.
And you must be knowing that your clerk's elder brother made a submission before.
Yes.
In the division. Then the
Yes.
division bench was sitting.
Yes. And
your clerk's elder brother said, please wait,
Ashe.
such and such is coming. And the division bench was sitting
Sad.
idle.
Did not have that, my
And
lord.
do you know who was on the other side?
I don't remember.
Mr. Dashgupta.
He said my lord's elder brother was coming. Or
Yes, Mr. Dashgupta was on the
Dashgupta
other
was-
side, on the respondent. He was for the caveat.
Yeah, those were better days.
He was there to move, then asked, he told, sorry, it's the other way around. We were for the caveators, he was for the appellate. So he started, he said that there was a
Ektu
caveat,
darana
order
asche.
41 matter, then said, asche, please wait. This was,
Those
yes,
were
when also I
better
got that news, those days.
That memory just comes back.
It's reminded.
It comes back. My lord, here in this matter,
Before that, Mr. Chatterjee, my lord, last occasion, yesterday, my lord, I have
everything.
My lord, I will remind you, lordship. My lord, what happened? The notification of ESZ.
I wanted you to take instructions
Because
after revision or prior. to
I
that.
said a wrong submission, my lord. It's completely opposite to that. Now, my lord, just for a moment, my lord, in 2011, there was a notification of ESZ by the central government.
2011.
11. Pursuant to the 2010's, my lord, the order of the Honorable Supreme Court.
So that was the notification. So it took the final shape.
Final shape in 2011.
11, yes. What is the position as per
Yes,
the
in the-
petitioner's unit is concerned?
I just want, give me 5 minutes, I will,
Yes.
kindly turn around first, Lordship kindly see, this is the 9th February 2011 notification.
Have you given a copy to your learned friend?
9th, that is the,
This bunch, otherwise he will not be able to make his submissions.
So at the present
This is-
moment, my lord, the
let me explain that, my lord, I will just,
Yes.
very short, my lord.
Yes.
This is the notification, my lord, the Government of India, Ministry of Environment and Forest. My lord, kindly turn the guidelines first, third page.
Third page.
Third page. Lordship got it, guideline, background,
Yes.
background. Guidelines for declaration of eco-sensitive zones around national parks and wildlife sanctuaries. Now, my lord, 1.1.1, it is decided during the 21 meeting of the Indian Board of Wildlife held on 21st January 2002, a conservation strategy was adopted wherein the 9 emphasized the lands falling within 10 kilometers of the boundaries of national parks and sanctuaries should be notified as eco-fragile zones under Section 3, Roman 5 of the Environment Protection Act and Rule 5 of Sub-Rule certain circular. So, my lord, initially, all the sanctuaries and the, the reserve forest, in view of these notifications, that they has come within the boundary of 10 kilometers. First. Now, my lord, thereafter, which I have annexed, my lord, that the state government, my lord, sorry, my lord, on the basis of the recommendation, my lord, kindly take my, my lord, the report, my lord.
Earlier, yes.
Never, but a report,
Yes.
yes, you can take.
Yes.
Which I have annexed it, my lord. My lord, in the, my lord, it is, my lord, annexer 3. My lord, it has not been. Three.
Yes, yes, Annexure 3.
No, Gazette of India notification.
That is Hindi.
Yes, Hindi, but the later part is in English, my lord.
English,
The,
yes.
my lord, if your lordship sees, that's the page 15.
Page 15, yes.
Yes. So this is the, my lord, the notification of the 7th September 2020.
Yes.
The Ministry of Environment, Forest and Climate Change. Now, my lord, if your lordship see SO 3031E, whereas a draft notification was published in the Gazette of India Extraordinary, Government of India, the Ministry of Environment, Forest, Climate Change, dated 11 June 2019, inviting objections and suggestions from all persons likely to be affected thereby within the period of 60 days from the date on which copies of the Gazette containing the said notification were made available to the public. So, my lord, in 2019 first, the draft publication was published through a Gazette notification.
So that was finally published on 7th of September
In
2020. No objections were.
Objection was received after consultation of the objections and the reports. Then, my lord, now next page.
Yes.
1, 2, 3, 4th. Now, therefore, lordship got it.
Yes,
Fourth.
yes, yes.
This is in exercise of the power conferred by subsection 1 and clause 5, 14 of the subsection 2 and subsection 3 of section 3 of Environment Protection Act 1986. Hereinafter, all his notification referred to as the Environment Act, read with Rule 3 of the Rule 5 of the Environment Protection Rules. Now, my lord, the central government hereby notifies an area with an extent of eco-sensitive zone varying from 0, my lord, within bracket, due to international boundary with Bhutan towards the northern boundary and interstate boundary with Assam in the eastern side of the protected area. So this is, my lord, the 0. So this, my lord,
From 0 to 5 kilometers.
Yes, 0. to 5 kilometers around Boxer Tiger Reserve in the state of West Bengal and Tiger Reserve eco-sensitive zone.
Yes.
So, my lord, these now the my lord kindly come to my lord the column page 23, my lord. Boundary. I'm talking about the now boundary.
23.
Yes. My lord, the internal page
Yes.
of the notification.
Yes. Yes.
Lordship,
23. Yes.
bottom boundaries. Lordship, got it? Boundaries details of 1 kilometer and 5 kilometer ESZ of Boxer Tiger Reserve. So, my lord, this establishment falls within the Boxer Tiger Reserve. So, my lord, north boundary, my lord, 0. The northern boundary being shared with the international boundary Bhutan, there is no eco-sensitive declared area. So, 0. East is also, my lord, 0. Boundary of Assam. Now, southern. Southern is in the southern part, 1 kilometer ESZ has been proposed. Southern part is 1 kilometer. Now, the west, ESZ of the western flank.
His unit is on which side?
West. No. My instruction is west. 5 kilometer. My instruction is 5.
After National Highway 31.
No, my instruction is 5 kilometers.
There from the
No, this is
Because of
the, Mr. Chatterjee, this is the boundary of that
of the
reserve.
reserve.
Yes.
Yes.
So where is the
We are saying
national
on the
highway?
Southern side.
There should not be this dispute on facts.
No, cannot.
Dispute on
Because
which
your
side.
lordship will also find from below the.
No, my lord, even so for assuming that southern part, for even the assuming the
No,
southern part.
Mr. Additional, without going to that, what is your instruction? Whether,
My instruction is that
whether as per the
as per
earlier,
this notification,
as per the
it falls within the ESZ zone.
within the ESJ,
As per this notification.
and
Now, my lord,
the
kindly
draft-
take
what
draft.
is the revise?
You now kindly take my affidavit.
No, what is your instruction? What happens after the revise?
Now we have made a proposal
Yes,
for a draft publication,
yes.
and within the
Which is
draft
pending before the Union Ministry.
Union Ministry,
What is the, what?
then it will not fall within the ESZ. It will not follow the ESZ.
Mr. Chatterjee.
So this is the reason, my lord.
That is so. I think because that may, this
Because my colleague,
now as it has come, that presently, as per the present notification, let us not go to the draft one. Present notification, your unit is situated within years. Yes.
yes,
But as per the subsequent draft notification.
I'll be outside here.
Will be outside. So you may be allowed to function.
Well, there are 2 points here.
So one is, how soon does this draft is finalized? Otherwise, till it is finalized, you are within that.
I'm within ESZ.
So if you are within ESJ, the question would be whether we have, you can be allowed to function,
operate. Yes.
To operate.
My point is there. I'm on
So
that.
according to you, even within ESJ, you
There
can
is-
function.
Yes. Yes. And that is why, my lord, the Pollution Control Board, my lord, gave me the consent to establish. There is nothing under the law, my lord, to consent to operate. Have a look at section 25 once. Have a look at it. The entire thing, my lord, is like I am being made, my lord, in colloquial thing, my lord, like a balika
25 of which act?
of the water pollution, which is under which
under this has been made this notification.
under
Yes.
which the notification
Yes,
is made. Have a look at section 25. And I'll come to that.
25.
25, my lord. And subject to correction by my learned friends in the other side, senior friends in the other side. Subject to the provisions of this section, no person shall, without the previous consent of the state board, establish or take any steps to establish any industry, operation or process or any treatment and disposal system or any extension or addition thereto, which is likely to discharge sewage or trade effluent into a stream or well or sewer or on land, such discharge being hereinafter in this section referred to as discharge of sewage or such. The entire section, my lord, kindly satisfies my lord's self, kindly turns to page 97. kindly satisfies my lordship. Kindly turns to 97.
If we have.
My lord.
Yes,
Turns to 97.
page 97.
Yes, sir. Of my writ petition. The pollution control board, my lord, has got nothing at the present moment. I'll tell your lordship again why. This is my application at page 97. It says, my lord, kindly sees the marking, application for consent to operate for discharge of effluent under 25 and 26 of water prevention and emission, continuation of emission under section 21 of such and such.
Yes.
Lordship has seen that. In terms of that, my application is on. Then it turns right at the end. I've given everything in terms of that long time back. And it's a wrong submission to make before your lordship that I'm operating. I am not operating. I am asking them to allow me to operate. Turns to the last page at 104. Why I'm agreed by the state government's actions, not by the Pollution Control Board. Pollution Control Board tells me, beloved, on 6th of March 2024, as per Baksa Tiger Reserve ESZ notification, the state of your unit falls under ESZ. You are required to obtain NOC from PCCF. That is, below the Chief Conservator of Forests.
Which page?
104, below. Top. So Pollution Control Board gives me, below, consent.
What is PCCF?
Principal Chief
Conservator of Forests.
Forests. So in terms of this, beloved, according to the Pollution Control Board, I have not done anything illegal. Kindly satisfies my lord's self.
Now, what happened?
I'm coming to your lordship. Kindly satisfies my lord's self, beloved. Kindly turns to the beloved consent to establish, which your lordship will find at page 62. Moment you give a consent to establish, in my respectful submission, my lord, my legitimate expectation, even if there is a law, moment you say consent to establish, you are allowing me to establish an industry in terms of section 25. You can't thereafter say that you can establish, but you cannot run. First submission of mine. Now, I go back to them.
This is the strategy, my lord. You started by saying that you are not aggrieved by any action of the police.
I am not, because they have not
this
taken any
consent
action.
to establish
Is
was
granted
by the pollution control.
2022.
So according to you, if any wrong has been done,
That's
or
up to
anything-
them to take whatever action they need to take.
So
They
you-
haven't.
so
Now,
you are not-
why? What am I aggrieved by? Now, my learned senior friend tells your lordship that my unit falls within that ESZ. Now, today, my lord, if it is within the ESZ, there is not an absolute bar. I have to take certain, my lord, restrictions. Those restrictions were given, my lord, in this page 62 document. I carried out that restriction. They had, my lord, asked us
What are
to
those restrictions?
They had asked us to, my lord, boiler certificate. The boiler certificate is obtained by me and is annexed before your lordship. Because, my lord, this is a rice mill where, my lord, the pot boiler, my lord, is used. So there will be emissions from that, and that emissions are in every way industry. Emissions are controlled by certain devices made in the furnace. This was all done in 2022. Then when I went back to them, and because of their whatever notification, whatever law, I have not found out, it's my infirmity. They wanted us to file that application for consent to operate. When I filed that, they asked me to go to the state government because it's within the ESN, not the state government, but the forest consumer of forest. Conservator of forest. Then starts this game. What happens is the conservator of forest doesn't say anything.
No, may I interrupt for a second? Here in this matter, my lord, forest say it do not follow any forest.
I will appraise your lordship. Kindly turns to my lord initially at page 94. This is a letter, my lord, written to me by the forest official saying, kindly have a look at the first paragraph. Government of India and Gazette such and such, Monday, order such and such, Supreme Court of India, Govardhan, that's the Supreme Court judgment, which my learned senior friend showed your lordship. Whereas the said order issued clear direction, new construction of hotels and resorts shall not be allowed within the boundary of the wildlife sanctuary or up to the extent of the eco-sensitive zone, whichever is near. Therefore, in compliance with the above mentioned order, you are hereby directed to stop such constructions which an immediate effect and submit documents in favor of this commercial construction to Deputy Field Director. So I am not a hotel, my lord, or my lord, a resort. I am not. I go back to them and I explain to them. Kindly turns over, my lord, to page 96. I go back to the field director, explain to them everything. 96 to 97, the pollution control board's application, everything was annexed before the conservator of forests. Kindly comes down, every detail was given. Kindly comes down to page 105. We again wrote to them on 10th of March 2024, explaining to them my plight. Comes down. The next letter, my lord, is at 108. My lord need not trouble my lord self. It's the same thing. Kindly turns to 110. This is a letter, my lord, given by the Deputy Field Director to the authorities asking for the minutes of what happened there.
You attended the meeting?
Yes, I did not. It was their internal committee meeting.
No,
you have attended.
you attended.
Gives me a second. I am.
This is the minutes, my lord.
I'm sorry. Yes, I have attended. Then Millard kindly turns to 112.
Because the agenda is with regard to
Yes, that's my problem. 112. This is a letter from the Pollution Control Board. With reference to the above, this is to inform you that you are required to obtain no objection certificate from competent authority as your unit does not fall within the eco-sensitive zone.
This is a typographical mistake,
Very
Mr.
well.
Chatterjee, because otherwise
Nobody
it does
has
not make
said.
sense.
Very well.
It does not make sense.
Very well. Nobody has said this is a typographical error,
but
your
appears
lordship
so.
takes it as a typographical error.
Otherwise, it does not make any sense.
Very well. So they want me to go back to the state authorities to get their no objection. Then kindly sees, Millard. I go back, page 113.
Yes.
In 113, I'm pleading with them. See what's happening. Find out what it is. Please let me know. Then kindly sees, they are writing below at 114. Below, your lordship may skip that over. It was with respect to that meeting. My lord may. Then kindly sees the show cause notice at 116. This is where, my lord, the malafide of the state government comes in. Yes, my lord. State government comes into play. The forests have no problem. The Pollution Control Board has got no problem if they get a no objection from the state government. Sees what the state government is starting. Looks to the second paragraph onwards. However, despite the directions below, this is a letter given on 1st of December 2024. However, despite the directions from the Deputy Field Director, Baksha Tiger Reserve, pending decision by the Eco-Sensitive Zone Monitoring Committee, notice from such and such Nimoti Range dated to not commence operation of parboiling unit, you have not abided by the instructions. This is to inform you that complaints have been received from residents of nearby villages alleging that your establishment operating parboiling unit is causing air pollution and discharging harmful effluents into the adjoining areas. The allegation, if true, represents a
Yes, because
serious
it's a
violation.
show-cause notice, so they cannot come to a conclusive finding
Right,
on
so
that.
they could not have done anything without an inquiry, nothing. Then kindly turns over, and that inquiry was in the domain of the pollution control, not of the forest officials. Turns over. This is Milad, the mass communication at page 118.
Vernacular.
In Hindi vernacular, saying below that it is, my learned senior friend was talking about below where I was situated, south, north. Sees the second line, that is enough. Sees the second line. 31 number National Highway or West Poro Beat Nimti Jora Naya Bangane. My lord, this is towards the south. Towards the south. Have a look at.
That is the map.
My lord, this is the description of the boundary on the south. As on today. As on today. So, if the state government today, my lord, wants to, my lord,
yes,
Lordship has gone into it. Then I'll come back to, my lord, the facts, and then I'll make my submissions on that again. Kindly comes down again after the, my lord, this has been done. I write again to them at page 120.
This
Saying
is your reply to the show cause.
Yes,
This you have denied.
I have not just denied, I have told them what it is.
Yes.
Then 122. This is 10th of December 2024. Kindly sees second paragraph. Lord remembers the first show cause notice. This is the second one. This doesn't say a show cause. Then sees what they says. Sees what they share. Second paragraph. This office and ACF such and such had strictly instructed you to not commence operation. My lord, in the last one, if your lordship remembers, they had said that do not operate. Here, for the first time, they say the correct thing, to not to commence operation. Then, without obtaining proper permission from the Baksha Tiger Reserve Eco-Sensitive Zone. So what they want is the eco-sensitive zone to give me a no objection. Nothing beyond that. Nowhere it is being said, beloved, that I cannot set up that industry. There is a difference, beloved, between setting I cannot and I can with certain restrictions. Moment you gave me that consent to, beloved, establish, in my respectful submission, beloved, it is legitimately expected, beloved, that I will commence operation.
Promissory estoppel.
Not just promissory, legitimate expectation. Promissory estoppel.
Higher than that.
Much higher. Promissory estoppel, my lord. There are now decisions which say that state is.
Some defenses are
yes,
available.
State has certain defenses. If I am within the periphery of law, you can't stop me. And this is hoodwinking me. My lord, 2022, you give me this consent to establish for, in my respectful submission, may I ask this question to myself, for what? That I will establish a factory and I look at it. There are thousands of workers there. They will be being paid, but I will not be able to utilize my factory. Now this ESZ, this part of ESZ, that part of ESZ, all this comes in. They were not bothered by that. It's only that mass petition. It is not the forest officials who come up and say that you can't run. Not the pollution control. They said you go and get a no objection, I have no problems. If they want something to be done, I am there, I am pleading with them. Tell me, I will do it. You wanted me to do something.
So according to you, the No objection is still awaiting.
No objection is not given by them.
Yes, is awaiting.
Is awaiting, and I'm going to them for that. Pollution Control Board's actions come in much later. They only say, go and get a no objection. I will do whatever I have. So whether this consent to operate is required by law or not is not at the present moment the subject matter. It is the action of the forest officials who do not give me this no objection. Why? Because there is a mass petition, not because of law. If there was any law involved, I would have understood. Not because of law. Because the forest officials, my lord, do not have the power under the law to find out, my lord, if I was, my lord, creating any, my lord, this polluting, I'm polluting the atmosphere. They are not equipped with that. They are driven, my lord, by that mass petition, and if I may add, political.
Mr. Chatterjee, what is the consideration for granting this NOC by the forest officials?
There is nothing. I let them show, my lord, there is no law. Even if within ESZ, they can control it. They can't say no. They can control it. They can't say no. There can be no establishment. My lord, what happens is, the Supreme Court, if your lordship remembers, in all these forests, my lord, in Madhya Pradesh and Maharashtra, there were resorts inside the, my lord, the forest, core area. That they stopped, saying that you can't do it. So there have been quite a few anomalies on that, but that they stopped, saying that you can't have a resort inside the core area. Or you can't even have tourism within the core area, which was, Lord, if your lordship goes through any of those forest, Lord, national parks, your lordship will find the people inside, they say that this was detrimental to the animals. Because if the people who went inside, Lord, there would be a sort of, Lord, they would say, Lord, like a, they would see if there is poaching or not. There would have been more surveillance if these tourists had gone in. So now when the tourists don't go in, that's an area which is only covered, Lord, by the forest officials. It's not always that the surveillance is perfect.
But these wild animals, they some affectation of their.
Lord, it's a fascinating, Lord, I don't know how much your lordship is interested in wildlife. It's a fascinating play of field, Lord, if your lordship really gets into how these animals are. Earlier, my lord, it was completely on luck. Now there's a lot of study in it, and people who actually go can tell your lordship, my lord, because tiger is very, very territorial. So if it's a territorial animal, my lord, the persons who actually go every day will know where the tiger actual area is. That is why the naming has come up, my lord, nowadays with tigers. Earlier, this was not there. So now, if your lordship goes to a national park, it's almost certain, my lord, that your lordship will see a tiger. My lord, Mr. Rai, I had the occasion to take him. He saw 3 tigers. Before that, he was, my lord, inside the forest. That was my father.
In all cases, you can view this.
This time, my lord, I tell your lordship, if your lordship goes there for 3 days, at least on 3 to 4 occasions, your lordship will see a tiger. In the last, about my own experience, in about 6 or 7 visits to the national park, my lord, I have seen a tiger every visit. Every visit.
To love and affection. No, that's true. I don't want. Really, if I love them, they will come and you will be able to see them.
Mr. Chatterjee will tell you his experience. You are saying with Mr. Rai.
With Mr. Rai, I'll tell you what happened.
Yes.
So this is what it is. So what is the consideration? It is within ESZ. If it is within ESZ, is there an absolute bar? There is no law in my respectful submission.
Yes, Mr. Chatterjee. Yes, only one thing. Why are you not? Have you taken a decision with regard to NOC?
Kindly come to my.
But now it's not in dispute that his unit is within SSA.
Kindly come my affidavit. I have endorsed all minutes. My affidavit.
That report.
Report, yes. Affidavit in the form of report from the district manager, chairperson.
Yes, yes. Member secretary.
No, chairperson, affidavit.
If
That the member secretary was in a report form of.
yes, yes, yes. Jitendra
Yes,
Tamang.
Yes.
Yes.
Now, my lord, first I will take you lordship at page 7, that is the annexure R3. Page 7.
Yes.
Yes, I'm coming. Yes, I'm coming. I will not hide anything which I written in the surface. How can I, my lord?
Yes.
First, I will show this annexure. Then we will come to annexure page paragraph 7.
Yes.
So the annexure says is the my lord, the monitoring committee meeting of the ES. That is the my lord, the constituted in view of the my lord, the gazette notification of 2020. So my lord, what we have discussed. Discussion and resolution. Presentation by Mr. Kunal Chaudhary. Mr. Kunal Chaudhary, director of Sri Ramdev Agro, representative Sajan sir, he informed the committee that the project has received the consent to establish from the West Bengal Pollution Control Board and other requisite permission. Clarifications by Deputy Field Director, West BTR. The DFD West BTR informed the House that the response
Proposed rice.
proposed rice mill, sorry, Lord, yes, located.
This
within
happens when
outside the
a
correspondence.
photocopy is taken from a marked copy.
This was marked copy.
From a marked copy. That is why.
Yes.
Photocopy taken from a marked copy, it happens.
Yes, currently
outside
Yes.
outside the forest bound.
No, is located within the current notified
ESZ, BTR,
but situated
Yeah,
outside the forest boundary.
So, Milord, this is an admitted position that it is within ESZ and outside the forest. So, outside the forest, if it is outside the forest, no forest department has nothing to do. Nothing to do. Now, this is the reason, Milord, the person who has written, that is he was present in the meeting. DFD, this is the DFD page, who has issued the show cause. Status, the DFD East BTR, he is the member secretary. He is the member secretary. Updated the committee on the revised draft ESJ, submitted to the competent authority, dated 11/11/20, that which I said. For approval in light of the Honorable Supreme Court judgment dated 20.
We need not go into this because this was with regard to the
Now, Milord, this is the draft proposal was prepared. Now, Milord,
we did not go into that because now for the present his unit is within ESZ.
Yes.
So what will happen with the draft according to you? As per the draft, he will be outside. Let us not go into that for the present.
We do not know that
Mr. Chatterjee accepts that he is within ESZ.
Yes.
And according to him, consent to establish was issued in his favor. He can, some restrictions can be imposed, but he cannot be totally barred from operating.
Consent to
What
operate.
is your submission with regard?
Consent to operate nothing to do with the mine.
No.
The Pollution Control Board issued the consent to establish.
Yes.
And
No,
Pollution
whether
Control
my
Board shall issue.
two questions to you. First,
Yes.
is whether such a type of industry
Yes.
can be established within ESZ. If no, say that. If yes, whether any restrictions are to be put in place for establishing.
Pollution
such-
Control Board has done so.
such-
Given
such-
a consent to establish.
No, Mr. Chatterjee, you are saying that they are nobody
Not wrong
out
for the
the
member.
forest.
Yes.
So I'm concerned
No,
with the
Milord,
forest, whether
my-
the forest
my respect
has some restrictions
my,
to be
my,
imposed.
my respectful submission, Milord, because consent to establish was given by the Pollution Control Board despite that it falls within the ESG category. Because the consent to establish was given in 2022.
So now, that is why, let us not go into that. My first question to you.
I have no objection. Well, I said that.
My first question to you is
Well,
whether,
Milk 7.
whether
Yes.
this type of industry can be established In a SC,
Matlab,
SC,
this is with some restriction. If it is orange category,
where is,
regulatory category.
where are those restrictions? So if those restrictions,
Milord,
according to you, it can be set up, then
Milord.
your answer is in the affirmative, it can be set up, but subject to certain restrictions.
my respect to sufficient that at this juncture, Milord, if any establishment fall or industry within the ESJ, then Milord, if it is not the orange category, then it can be established.
If it is not orange, where are those guidelines? Anything
Yes.
to say?
Yeah, I have annexed. I have annexed.
Show me that.
I have annexed.
And this decision has to be taken by whom?
By
Pollution control.
It's nothing to do with that. Because why? This is the reason, Milord. ESJ, sorry, pollution.
Forest.
No, forest nothing to do. Forest has also nothing to do.
No, then why it has been said, why the pollution is saying,
Pollution
take
for
no objection from this
species.
conservator of forest.
Give me 1 minute, sir. I'll just come back. I'll come back.
The pollution control board thought that this establishment falls within the forest land. This is the reason they have asked to obtain an NOC from PCC.
From the consent to establish, the regulations will have already stipulated.
I will come to you. So
So
according to you,
these establishments, very categorical submission. These establishments do not fall within forest. So the PCCF or any forest authority has no role to play in this regard while issuing or granting or stopping.
so no, NOC from you is not necessary.
No.
Have you
From
stated?
forest.
Yes, from forest.
Yes.
So from forest, have you stated anything in the affidavit with regard to this?
No,
That your forest,
my affidavit say,
show me that.
no, that it falls outside. I have annexed the meaning.
No, you have said that it falls outside.
Evidence has not been exchanged.
No, in this report.
In
In
the
this
report,
report, have you
Para
stated
seven.
that forest has nothing to do since
Para
it
seven.
falls outside the forest area, no NOC of the forest is required.
my lord, I have annexed the meeting, resolution of the meeting, which in the ESJ committee meeting, one of the member as in the committee,
Is the pollution?
no, the forest department,
Yes.
he said that establishment falls outside the jurisdiction of forest.
So forest has no NOC of the forest
This
is.
is the reason the ESJ, if it is ESJ, because it fallen within the ESJ, this is the reason, Milord. This is the reason, Milord, the NOC was sought for from ESJ authority, sorry, Milord, the monitoring committee by the pollution control board later on. Initially, they thought it falls within the forest area. PCCF was being asked to obtain, sorry, Milord, petitioner was asked to obtain a NOC from the forest department, PCCF. So nothing to do with the forest department. Then it reaches to the ESJ committee meeting. ESJ committee meeting said.
So what is the difference between this? Please come to your, is located within. Yes, this affidavit of respondent number 4.
Yes.
Jitendra Tamang,
Yes.
please come to page 7.
7, yes.
So
Page 7.
yes, page 7, the minutes which what you are referring to.
Yes.
Point number 2.
Yes.
So it is located within ESZ,
Yes.
but outside forest boundary.
Milord,
What is the effect of this?
I will explain. Milord, I have a.
So ESZ is an area
Yes.
outside the forest as well.
If I may just clarify.
So
There is some-
ESZ is
there
a
is
larger area,
under-
forest is a smaller area.
But boundary, Milord, the forest boundary is determined.
Yes.
So within the forest bound
So forest boundary is determined, ESZ boundary is also determined
by the respective department,
by the notification.
by the respect forest boundary determined by the forest official.
Yes.
So forest boundary is a separate boundary. And the ESZ boundary is a separate boundary in view of the notification of Supreme Court guideline.
Yes. So ESZ is a larger area.
Right.
Yes.
ESZ is a larger area.
Well, it may be 0, it may be 1, it may be 5.
Yes, but
Within that area, the forest area do not fall.
yes, forest area do not fall.
Yes.
So since it's within ESZ,
Yes.
but not within forest.
Yes.
So according to you, forest officials have nothing to do.
Nothing.
So now, any no, so ESZ, who are the ESZ authorities?
Yes, kindly come to my notification. This is a composition of ESZ committee.
Yes.
Committee is number one chairperson of the
So-
respective
so-
district magistrate.
So my question to you is, in a case where a factory or a person wants to set up, let us come from that, not in this case, wants to set up an industry or a factory in an area which is outside the forest, but within ESJ. Outside the forest, but within ESJ.
Then,
Similar to this case. So, whose no objection is to be, whether any,
Definitely, the monitoring committee is NOC.
monitoring committees, NOC. So here in this case, since the petitioner's unit is situated within ESJ, admittedly, but not within forest, so NOC of the ESJ is necessary.
Then we are 2022, when the pollution control board given the right to establishment.
No, I'm not coming to pollution now. So what is the stand?
Industry to be set up by the permission to be given by the pollution control board.
Yes. What is the stand of the ESJ with regard to no objection by the ESJ committee?
I categorically said, madam, in the affidavit that today it falls within ESJ.
Yes.
So I cannot give NOC.
No, you means, let
No,
us
committee.
say,
You
the
means
forest
committee.
cannot give.
Forest, no, forest living. Forest, no picture.
Yes.
Committee, ESJ.
ESJ committee.
Yes, ESJ, one part is Millard, there is a two parts now here. One is of forest, one is ESJ. Forest has nothing to do. Because it do not fall in the forest area. Coming to ESZ area, it falls within the ESZ area in view of the notification of 2020. As on date, the moment the pollution control board has given a permission, no NOC was obtained for the ESZ monitoring committee.
Yes.
So my justifiable submission will out. The pollution control board definitely when has given the NOC.
So according to you, it's a no objection to be obtained from ESJ committee prior to setting up, prior to establishing.
Anything. Here, the case, it has not been obtained.
Whether any guidelines is there, what are the guidelines for issuing this NOC by the ESJ committee?
Kindly take up my report that without affidavit report.
Yes. It's the exhaustive hearing, madam. Your junior said 10 minutes. I was,
10 minutes.
that is, no. That is why I fixed it at 2 p.m. When he said it is to be fixed earlier,
2 p.m. Milord, 2 p.m. your lordship fixed it at 4.
Yes, because he said he will take only 10 minutes.
I took 10 minutes.
That is why I fixed it at 4. Now it seems one entire day is also not sufficient for this.
No, we are almost over.
But kindly come. My sorry, I did not see.
Yes,
Carry on.
Yes.
But kindly come page 21. My report.
Of the report.
That not a non-affidavit report.
Page 21.
That gazette notification, it has been prescribed.
Page 21. Yes. List of activities prohibited ought to be regulated within the ESZ.
Yes, but now, if you lordship chart 20, before the 21, kindly come to 19 statement. That would be better. 19. 19.
Yes, 19. Point number 2.
Point number 19, no, 16. 16.
Yes.
Industrial unit.
Yes.
On or after publication of this notification of the official gazette, no new polluting industry shall be permitted to be set up within eco-sensitive. So, Malad, I'll give up. So, Malad, if this notification industry says.
So not only that hotels and other things. So it's industrial units also.
Table B is a prohibitory. Table A is prohibited activities. And table B is a regulated activity.
So table A and B. Oh yes. Prohibited
Completely covered by this. Table A.
Prohibited activities and
table B is the next page. Next page, after 7.
Regulated activity.
Regulated activity.
Yes.
Now, Milord, kindly come, I'll just define a lot. So, Milord, ask, we honor after publication that no new polluting industry shall be permitted to set up. So, Milord, the notification has come 20. Then 2022, the permission was given. Then or not 2022 pollution control board has given. Now, Milord, now kindly come Roman 2. Only non-polluting industry. Now it is a non-polluting industry shall be allowed within eco-sensitive zone as per the classification of industries in the guidelines issued by the Central Pollution Control Board in February 2016. Unless so specified in this notification and any addition, the non-polluting cottage industry shall be promoted. Now, Milord, list of 4 kindly see after 70 A, B, serial number 4. Don't you got it? No,
Serial
that
number
page.
4, yes.
That page only.
That page, yes.
After 70, protection
Yes.
of hill slope, then is a serial number 4 below.
Yes.
List of activities prohibited or to be regulated within eco-sensitive zone. Now, table, Milord, first table A is a prohibited activities. Not you got it. It do not fall.
I don't fall there.
Not fall. Because the factory do not kindly see there is nothing. Now come to the regulated activity.
There I.
Now, so got it regulated activities?
Yes.
Now, regulated activities.
I fall under 16.
22.
16.
Are 16 or let me, you may refer 16, I am referring 22. Next page, page 21.
Don't know.
Yes, yes.
So this is a, if it is a small scale non-polluting industry, because Milord, as per the clause 16, only non-polluting industries can be set up. Clause 16. So Milord, the clause 22, if it is come, small scale non-polluting industries, then it is said non-polluting industries as per classification of industries issued by the Central Pollution Board in February 16, non-hazardous, small scale and service industry, agriculture, floriculture, horticulture or agro-based industry production products from indigenous materials from the eco-sensitive zone shall be permitted by the competent authority. That is a Milord, the prohibited,
Regulated.
Regulated. Not prohibited.
Not prohibited.
Not prohibited. So now Milord, kindly come. Now it is 5 say monitoring committee. Next page, Milord.
Yes, this is the committee.
Committee which Lordship was looking for that what
Yes.
is the composition. And in this composition, Milord, if you see Lordship, the Milord, all the departments heads are the members of the said Milord, the eco-sensitive zone. In addition to that, Milord, from the expert ecology environment, representative for the state public, everything, all members are the members of the state Milord ESZ committee. And thereafter, Milord, the map and the location, everything in the next page. So, Milord, now the matter reaches to us because the Pollution Control Board had asked the petitioner to approach to obtain a NOC from the ESZ. First, say from forest, we have clarified forest nothing to do. Then the ESZ committee said, as it falls within the ESZ, Milord, these parts, whether the committee considered or not, that I don't know. Committee said that falls within the category of ESZ boundary. You are not allowed. We have revised the draft, send back. The moment it will be published, that fall.
That is not a, that is a different thing altogether.
Yes.
So now,
Yes.
is trying to say that within ESJ, it's not a prohibited activity.
Regulated.
It's not a prohibited activity.
This is the reason why paragraph 7 I said.
Yes.
My affidavit.
So it's a regulated activity.
My
So regulated activity. So you, what is the decision of the committee whether this industry can be?
It doesn't have to, Milord. The Pollution Control Board has already given me that.
No,
Look to 64.
The strategic committee has to take a decision. Kindly come to.
Committee says it's within ESZ, never considered regulation.
That is a different thing, but kindly takes up page 22, point number 6.
terms of reference.
Yes.
Clause 5.
Monitoring committee shall, point number 6.
Yes.
shall
Monitor
monitor the
compliance.
compliance of the provisions of this
Notification.
notification.
Yes.
So point number 3.
Yes.
The activities that are covered in the schedule to this notification in the erstwhile such and such.
And are falling in the inco-sensitive
Yes.
zone. except
Prohibited
for the
activity.
Prohibited activity.
No, not this. Sorry.
Well, if it is not prohibited, nothing to do with the ESJ.
Prohibited.
Prohibited, so then it is not permitted.
No. This is except for the prohibited.
Exactly.
So it's regulated also falls
My lord,
within this.
my lord.
Is
Except for the shall be scrutinized based on the actual site-specific conditions and referred to the central government for prior environmental clearance.
That's
under the
been done.
provisions. Central government.
Yes, Pollution
Ministry-
Control Board has done it.
Ministry of Environment, Forest and
My lord.
Climate Change.
My
Show me
lord.
this clearance obtained from the central government.
The activities that are covered in the schedule to the notification of the Government of India in the erstwhile ministry, such and are falling in the eco-sensitive zone, except for the
Yes,
prohibited
so
activity,
prohibited is excluded. So
As-
regulated falls within this.
shall be scrutinized by the monitoring committee.
Yes, then after that, they will scrutinize
Yes,
based on the actual site-specific conditions and refer to the central government for prior. So they will scrutinize, send to the central government for prior
this
environmental
was,
clearance.
nobody is, there is nothing on record which says that this has not been done.
Show me that it has been done.
The consent
they
to
have to
establish-
say.
They have to tell your
Yes,
lordship.
that this committee.
Committee will tell your lordship.
Yes.
Malad, this is the then Milord, I will back to that. Then Milord, 2022, when the Pollution Control Board has given permission, these are the clearest ought to have taken.
Forget about the
Now,
environment.
Malad, today I cannot do, the ESZ committee cannot do anything. Permission is given already. What is supposed to do by the, this is the reason my chairperson DM said.
Oh, my lord, I'm sorry. My lord, my learned friend is absolutely correct. Kindly turns to that once.
Yes.
It is only when there will be a modification to the activities, it's only then that the central government comes here. The first line, the activities that are covered in the schedule to the notification in the erstwhile ministry dated such and are falling in the eco-sensitive zone, except for the prohibited activities as specified in the table under paragraph 4 thereof, shall be scrutinized. My lord, if they want to now bring in something else, kindly it comes back, say discharge of treated waste, it says, it brings in, my lord,
No. This is the
this is not for
compliance
every-
of these provisions of
Yes,
this
my lord.
notification.
Yes, if they
So,
want
notification
change
is,
the notified table and bring in some other activity, it's only then.
it does not say. this is
Miller,
the
if your
other
lordship
activities.
sees, it's quite clear, I think. Miller, I'm thinking he's
Activities
correct.
that are covered in the schedule.
Exactly.
So this is an activity covered in the, within the regulated, not prohibited.
Exactly.
So it makes clear.
Not for every
it's-
project. This is for the entire thing, not for every project. It's not that, Miller, that my industry cannot be set up before the.
No. It's not that it cannot be set up,
Huh.
but it's subject to the prior environmental clearance under the provisions.
My lord.
That is to be given by the central
That is
government.
when they have
in
to
the
change
Ministry
this
of-
table, when they have to change this table. Not when they have to change the policy and bring in a new activity. That's when, Miller, this 3 comes in.
No, Milord, it is not that. I will say in other way, Milord, kindly put it in other way. Because the moment before giving a consent to establish, these are the parameters ought to have been obtained or complied with.
That is not under challenge.
So the Milord, the person who has given the Milord, the PCB, Pollution Control Board, he is also the member of the ESZ monitoring committee.
Yes.
He is the member. The same person has given the Milord the consent to establish. Same person.
I'll quickly tell
Who is
you.
the member of that?
I'll quickly tell you, Lordship, why I fall.
Without our concurrence.
Kindly turns to, Lord, page 64 once. Turns to 64. I'm sorry, 62.
Yes.
On 17th of August 2022, this is what I am given, the consent to operate, establish. See, number 1. The quality of sewage and trade effluent to the discharge from your factory shall satisfy the permissible limits as prescribed such and or its subsequent amendment and Environment Protection Rules 1986. Suitable measures to treat your effluent shall be adopted by you in order to reduce the pollution load so that the quality of the effluent, the standards mentioned above. You shall have to apply to the board consent to operate and discharge of sewage and trade effluent according to the provisions of water control standards no sewage or trade effluent shall be discharged by you without prior consent of the board.
You are trying to rely upon this page 62.
Yes,
Please come to page 63.
60, below
Three.
62.
3, that tight portion.
Yes, below.
This NOC is valid for 7
7
years
years.
from the date of issue only for obtaining other permissions and establishment,
Buy now.
not for operations.
Bow down.
So this is not for operations.
I am
For
bowing
operations, you have to take other permissions.
With this, I'm going there.
This
What,
says-
may I ask this question to myself? What permission or mode will I take?
Mr. Chatterjee, this
Consent to
document-
operate. Very well. Tell me in what way I've applied before them for consent to operate. What is stopping them from giving the consent to operate?
Yes.
What is stopping? Because in 64, the special conditions are given.
Yes, yes. Yes, what have you done with your the application for consent to operate?
Start from the value. It is admitted fact, right, that consent to establish was granted by the ministry. But our handover also.
What are the preconditions for issuing the consent to establish in a ESZ?
I'll be handing over the copy of the report. Okay.
You have given them a copy.
All right, I will give them a copy. I have 2 copies. I have 2 copies of the report.
How they will get themselves ready?
All
So
right,
that adjourned on the earlier occasion.
I'll give, I'll just read it short. What has been stated in the report itself, from the report, it will be very, very clear. That consent to establish was granted. That is not a disputed fact. Consent to operate was never granted. Consent to operate, they have applied for. Subsequent thereto, what happened? They have been asked to obtain the NOC from the concerned forest department.
Forest department says
Already
you have
operated.
nothing to do.
Now, forest department does not say that on record. That's very peculiar. Forest department, there is no document or record. So that the forest department has specifically written so, stating that we have nothing to do with the NOC. We are not the authority to issue the.
If they say this, any other thing which is
This is
necessary for issuing the consent to operate?
Then, my lord, then I come to.
No, that was the only document you
That was the
wanted
only
from the
document.
forest department.
Yes, NOC from the forest department. Subsequent there, it can, the knowledge of the authority concerned of the pollution control board that it falls within the ESZ. Now, when it falls within the ESZ, the monitoring committee comes into play. Now, the monitoring committee, as your lordship has already gone through the.
Monitoring committee's function starts from when?
Yes, but the monitoring committee.
You are also a member of
functions-
the monitoring committee?
Well, I have a member in the monitoring committee.
Yes.
I have a member, but I am not the sole.
No.
decision-making authority.
You are not the sole, but you have a member in.
I have a member.
Yes.
I do have a member. I cannot deny that, but it takes us the constitution of the monitoring committee, that is at point number 5.
Yes. So you are a,
Well,
you are a
that is headed
member.
by the District magistrate.
Yes,
It is headed by the collector of the district.
yes.
Now, if the collector of the district says, yes, we do not have any objection for this is a non-polluting unit, or this is, as my learned colleague pointed out here, that it is a non-hazardous unit. I would like to refer that this is not so. This is not so. I would like to take my lord to the classification, to the tables concerned.
From where?
But in the notification itself, that is the table A and table B
For
prohibited.
table A and table B. Yes,
Table-
yes,
Table A prohibited activities and table B regulated activities.
yes.
My lord could find in the table of prohibited activities, point number 2. What does it say? Setting of industries causing pollution, water, air, soil, noise, etc. Any industry, that is, new industries and expansion of existing polluting industries in the eco-sensitive zone shall not be permitted, provided that non-polluting industries shall be allowed in eco-sensitive zone as per classification of industries in the guidelines issued by the CPCB in February 2016, unless so specified in the notification, and in addition to the non-polluting cottage industries shall be promoted. Now, my respectful submission is that this particular industry concern, the palm oil rice, falls within this classification, not within the classification as has been described by my learned colleague.
So according to you, it's a prohibited activity.
It's a prohibited activity. It cannot run within the ESZ. It cannot run within the ESZ, eco-sensitive zone. It
But
has
you-
pollutants. Well, see the definition, setting up of industries causing pollution, any type of pollution, water, air, soil or noise. Now, from the consent to establish, my lord will find, my lord, that's page 62.
In the writ petition.
Yes, page 62, the writ petition.
Yes.
Here it is mentioned, they have influence, it is not a non-polluting industry. It has been specified in column, point number 1, quality of sewage and trade effluent to be discharged from your factory shall satisfy the permissible limits as prescribed. So definitely.
Then why have you issued this consent to establish?
Well, this is something which I have to state on a record. This is something, if any has been issued, this consent to establish has been issued, this has been issued wrong. This has been issued wrongly.
What are you saying now?
I have to.
They have invested a substantial sum of
7 to
money.
8 crores, who will pay you? Definitely. But this cannot come at the cost of the environment. Unbelievable. Cannot come at the cost of the environment. The consent.
Have you stated, file an affidavit to that effect that this was issued wrongly? Consent to establish. You have to take this responsibility.
Definitely, I'll
You have to take this responsibility because many things depends upon this.
Definitely, it should not have been. It ought not to have been issued. In
What
the
have
first
you
place,
done? They have invested this.
it ought not
thing.
to have been issued. This comes within the eco-sensitive zone. And what case do they have? They are saying now today they have sought for modification of the entire draft publication. That has not yet been modified. The Ministry of Environment for Government of India has not modified. So it still falls within the eco-sensitive zone.
So
It is not-
I
it is
found
not an
somewhere
industry.
where I think Mr. Chatterjee placed in some document, it falls within the orange category.
Yes.
What is this? What is this orange, red,
May I? I am equipped with that.
orange, red? Yes.
Yes, or I'm
This is-
orange.
This is the Central Pollution Control Board notification.
You have given.
No,
this,
no, I have kept it.
Specific guideline.
Guidelines.
Yes.
In the said guidelines.
Orange
below,
category, whether it is permissible in the
that table,
SEZ.
table B said, table B.
Table B is regulated.
Yes.
But your learned friend is saying it's
I do not-
prohibited.
But I do not know. That's what I say. I do not know. Regulated or prohibited, I do not know. What is there, I say, in the notification. And what is orange category? If it is, then it is a regulated category.
Orange is regulated.
Yes, it is there. In
So if it is regulated, and where Mr. Chatterjee, where it has been said it's orange.
Their own. 114.
Page.
Admitted. 114. 114. And they admit it's orange category. At the caption, you lordship will find.
Mala, take some page number 97. That is the application.
97 also, yes.
It is also there.
Oh, orange category.
Yes.
Category. Orange.
So if it is orange, you are saying it's regulated.
Regulated.
Then how do you say it
That
is
it's wrongly
prohibited? This contradictory submissions you are making from the documents.
79 parboiled rice mills are orange. Parboiled rice is orange.
So orange.
I do not know. Whether orange is
Orange
permitted or red is permitted, I do not know. I said this is the orange and with the
If it
purple.
is orange, it's parboiling this rice meal. Then it's orange, it's regulated. Then how do you say it's prohibited? It will come under 2. This is contradictory. This is not making sense.
Terms itself says, the terms of table A, where goes to the terms.
Then how could you classify this as orange?
Terms itself says.
Then how could you classify as orange?
Why does it say that orange is to be?
Yes, this is
Orange is to be.
no orange. The environment said orange. Where is that? Where is that?
Say, it is orange.
Show me the document of the pollution control board
That it's orange. Yes, yes.
This page 97?
97.
Yes.
It is orange. They have made that.
No, they have
97.
said it's in their
No,
application.
they have.
Have you
it's all-
classified is that as orange? Who has said this is orange?
The pollution control board said orange.
114 is of forest.
My
Mr.
lord.
Ghosh, 114 is of forest, not of pollution.
No.
So show me that the pollution has classified is as orange.
97 kindly look to.
97. This is your application, Mr. Chatterjee.
That's what they asked us.
Yes,
Even in
but so it's the classification made by you.
62. No, their classification.
So show me that they have classified this.
It is the application for which they have filled.
Oh, I think it's that notification which classifies
Yes.
this category
This
of
category as
as
orange.
orange.
As
I think
Even
Mr.
the-
Advocate General
My lord,
Advocate
the small scale non-polluting industries. my lord.
No, you have referred to something, you said parboiling rice.
Parboiling, that is, my lord, parboiling rice, it is CPCB guidelines.
Oh, I think from that you have said
We have applied under that.
This is
under
we have
orange
applied.
category.
so CPCB says this.
We have applied under.
Now the
So-
orange is permitted or not, that I do not know. The notification says
They are
that
saying
the-
it's permitted. Regulated, it's regulated. Orange is regulated. Are
You said that orange is regulated.
I didn't know.
You said orange, it's regulated. You are making, I think you are confusing all these facts.
Then again, in 62, they said regulate.
As of now.
I
How
don't.
can they operate?
I'm not on consent.
I am not
I'm on
operating.
consent to establish. If this type of industry, when they have applied for consent to establish, they must be producing some documents to show what type of industry they will set up and where they will set up. These are the two basic informations they must have disclosed to you for obtaining this consent to establish. So you know they will be setting up an industry within SEZ, and the nature of the industry is parboiling rice mill. So from that you have issued, what prompted you to issue this consent to establish? If according to you, it's a prohibited activity within SEZ. Why did you issue this?
The thing remains that, my lord, I have already stated that the consent to establish ought not to have been issued. Now this consent to operate, it cannot be issued without.
There's no question of issuing consent to operate now. If you say it was wrongly issued,
Wrongly issued.
Have they
It ought
cancelled
not
it?
to have been issued.
Have they cancelled it?
No.
So it stands today. And you can't, but that state authority is saying so. He's not a private authority. He's a state. Milord, when he appears for the state, he has to.
He's a member of your committee.
my lord, my lord, you see, that's why my difficulties is that, my lord. Had
He's a
you-
member of
In
your
all this,
committee.
Milord, who suffers? I.
my
Invest 7 crores, 8 crores into that unit, bring in Milord business to that place, bring in employment to that place. And I am being Milord treated like this by the central government, state government.
my lord, my difficulties, my lord, as I've indicated, my lord, again I am repeating. Had it been the case in 2022, before issuing this such right to establishment, my lord, consent to establish, whatever, then this would have come to our knowledge. We do not know. So how we will be able to answer these queries, my lord? Monitoring committee, because, my lord, he being the one of the member of the monitoring committee, he himself personally, the person who has issued by person, even I'm saying.
Let the, who is the responsible officer of your department who can affirm this?
But also
Who can affirm an affidavit?
Ask him to come be present before your lordship. If this is what is happening, if this is playing around with people's lives, Article 9.
Who has issued this consent to establish? Page
62.
62.
63. Sign. Page 63.
Yes.
Protective. I can say. The property.
Is it your personal perception or
Yes.
is it your?
Are you making these submissions
The
on
instructions
instructions?
that I have. is that-
Who has given these instructions? that
He
it
has a
was
report,
wrongly-
has it said so?
Well, I
He has a report before your lordship. Has he said so?
Take up the report.
Yes, has it been said that it was by mistake or wrongly it was issued?
But it's not stated.
Then how do you make this submission? May I ask this question to myself?
But it has been stated in the third paragraph that this industry cannot be allowed.
That is a different thing.
Without the CPO.
My question to you is, why did you issue this consent to establish?
His instruction is not that.
The,
May have my lord's kind. Fixed at 4:15. Before this is when it's.
yes, Mr. Ghosh.
He will be here.
The petitioner has filed this writ petition praying for according permission for Sir, Ghosh, why have you pray? What is the meaning of prayer? For setting up consent to establish was there, you have already set up, that is your case, and you want to operate. What is the meaning of prayer? So you yourself admit that there is no permission to set up. Permission is required to set up.
Kindly, Milord, pardon, Milord, it's a
What is going on, Mr. Ghosh? It's coming from your Shrestha.
No, Milord, no.
He's now become busy, so busy. Can't see each
What
and
is
every-
this?
No, I mean, Milord, briefed after this was fine. Milord, but that's not the question, Milord. I take the responsibility. A is wrongly drafted. Milord, B probably Milord can look in.
You know? No, praying for according permission, no. Praying for issuance of consent to operate the rice mill at plot number 683-686 within Mauja Nimti, Domohani, in the district of
Alipurduar.
Alipurduar. The Dina, a meeting was held. A meeting of the screening committee papers. Oh, where is,
Monitoring committee.
no, that yes.
This is a monitoring
In-
committee.
In which branch it was?
It was
there?
my Milord, the affidavit.
Your
Jitendra.
affidavit.
Jitendra.
Oh, I was looking at that report.
Yes, Jitendra report. Well,
Yes.
the
I've got that. I was finding so many documents.
No, your
Kibula?
lordship has used the screening committee. That's why I has kept silent. It's a monitoring committee.
Oh, sorry.
Yeah.
Kibula? In the meeting of the monitoring committee of ecosensitive zone within bracket ESZ, capital ESZ, comma, Baksa Tiger Reserve, dated September 17, 2024. Under point number 2, which deals with clarification by Deputy Field Director within bracket DFD West, comma BTR. It was recorded that the DFD within bracket S within bracket West bracket close BTR informed the House that the proposed rice mill is located within the currently notified ESZ of BTR, but is situated outside the forest boundary. First of all, paragraph. Where is that, Mr. Ghosh, where they have said that NOC from the forest is necessary? Which page?
104. 104. Milord, upon my application, Milord, for
consent to operate.
Consent to operate, this is
In
what they
response
have
to the
responded.
application filed by the petitioner for consent to operate,
Yes.
the the West Bengal Pollution Control Board directed the petitioner. It's in the form of a letter.
I think Milord email.
It's a scrutiny details.
How it was communicated?
Ki bollam? This was probably Milord uploaded in the portal because it's an online system.
Pursuant to the in response to the application for consent to operate, the West Bengal Pollution Control Board The West Bengal Pollution Control Board required the petitioner to obtain NOC capital from Principal Chief Conservator of Forest, Government of West Bengal, as per Baksa Tiger Reserve ESJ notification, as the site of the unit falls under ESJ. Paragraph. Mr. Additional Advocate General submits that the site of the unit in question falls outside the forest area.
Forest boundary, not area.
Outside the forest boundary,
Because
and therefore, there is no necessity therefore, there is no requirement for obtaining NOC from the Principal Chief Conservator of Forest, Government of West Bengal. Such submission is, or Mr. Additional Advocate General want an affidavit to be filed by him on this fact. I think it's better.
yes, he will file. But he is a party. Let me see.
He's a party.
Let me see.
Please see, or I can direct him to be implemented.
Yes.
No, party no.
No, SCA member secretary, no, my lord. He's not a party.
It's a committee, my lord, which is the final authority so far as the affairs of.
This NOC is directed from the PCCF.
They are
by-
saying it is required.
Yes.
We are saying that it is only the monitoring committee. Which
Additional Advocate General also says so, but
Yes.
he is saying it has not been communicated, nothing is on record. That is the pollution submission.
Right.
In view thereof, this court feels that the Principal Chief Conservator of Forest, Government of West Bengal, is a necessary party in this petition. First up, on the prayer of Mr. Chatterjee, learned senior advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to implead the Principal Chief Conservator of Forest,
As well as the chief conservator of CCCF.
as well as the Chief Conservator of Forest, Government of West Bengal, as party respondents in this writ petition. First up, since the learned Additional Advocate General has instructions to represent such authorities, there is no necessity to.
No, my lord, it is not because he is not a party. Instruction from the monitoring committee, he being one of the
You
members.
can also represent them.
Yes, I always.
He will be.
Can
Definitely.
represent them. No, I'm only saying no fresh copy be served.
You can.
Service of this writ
Oh,
petition.
yes, that I can.
Only
Because
for that.
My instruction on the basis of.
No,
Yes.
I'm not an instructor.
Service.
Since the learned advocate, learned Additional Advocate General can represent such authorities.
Yes.
No copy of the writ petition be served upon the added respondents. However, the learned advocate on record of the petitioner shall be obliged to serve amended copy of the cost title of the writ petition upon the learned advocates representing the respective respondents. The Principal Chief Conservator of Forest, Government of West Bengal, is directed to file a report in the form of an affidavit disclosing the stand of the forest authorities as to whether any no objection from the forest department is required for the purpose of issuance of consent to operate.
No, my lord, for this particularly the writ petitioner, establishment of this writ petitioner.
Yes, yes. For the purpose of, কি বললাম? Of the unit in question. Paragraph. The learned advocate, Mr. Rahman, learned advocate appears for the appears for which
Respondent number
3,
respondent number
2 and 3. Respondent numbers 2 and 3 submits that the unit in question falls within that notification is in that your report, that table A, table B.
That is in my
That is,
report.
that not in your report, it's in your.
No, sir, it is in the report, my report.
Yes, yes.
report.
কি বললাম? The unit in question falls within prohibited activities as mentioned in table A, clause 2 of the notification dated September 7,
2020.
2020. Full stop. On a query as to why, after knowing the nature of the unit proposed to be set up and the area where the same would be set up, the member secretary West Bengal Pollution Control Board issued the consent to establish by memo dated August 22, 2022, comma, the learned advocate, Mr. Rahman submitted that the same ought not to have been issued by such authority, and the same was issued
in the first place of not to have been.
only that, or wrongly issued. What is your ought not to have been issued in the first place? First of all. Now, in the light of the submissions made by Mr. Rahman, learned advocate, the member secretary, West Bengal Pollution Control Board, he is a party, being the
Respondent number 3.
being the third respondent, is directed to file a report in the form of an affidavit as to who is the member secretary? Who is two? The second respondent to file a report in the form of an affidavit
No, member secretary is 5.
disclosing
5, my lord.
disclosing
The pollution টা কোথায়?
the
So member secretary
শিলিগুড়ি member secretary, service to member secretary, কেন service to member secretary করেছে? এটা লোকাল অফিসের অ্যাডমিনিস্ট্রেটিভ অফিস।
আচ্ছা, এটা হচ্ছে ওখানে সেক্টর।
এখানে member secretary
number 2, my lord, disclosing as to why such, why the consent to establish was issued. If such authority is of the view that the same was rightly issued, the points that were taken into consideration prior to issuance of such consent to establish is to be disclosed in the said report. Full stop. Paragraph. It is the specific case of the petitioners that acting on the certificate of consent to establish, the petitioner has established the unit investing a substantial sum of money amounting to several crores. Have you stated that, Mr. Chatterjee? A substantial sum of money.
There in the application value of the project is already there. It's on record. It's my lord, if your lordship sees.
Amounting to crores.
Yes, yes.
Yes, because I cannot either spell or quantify.
Identify. I'm not opening my mouth.
Mr.
I'm not even saying anything.
Acting on the
Yes, so. কি আছে সেটা বল কালকে কথা বলেছি
কি বলবো হারিয়ে ফেললে investing a substantial sum of money amounting to several crores. First up, paragraph. The member secretary, West Bengal Pollution Control Board shall also specifically state in the said affidavit as to what, as to the reasons for not issuing the consent to operate, the certificate of consent to operate. No certificate. There is a certificate.
Operate is a certificate. It is a
The
certificate.
consent to operate in favor of the petitioner. Full stop. Let the affidavits by the respective officers, the officials, by the respective officials be filed. Tell me.
No, no. I'm waiting, Milord, from.
Come from Calcutta.
Milord, your lordship takes it, Milord, kindly keeps it Pathan. First prayer is kindly keeps it Pathan and takes it to Calcutta. Milord, your lordship has heard, Milord, the entire
No,
thing.
I have
Milord,
recorded
substantial.
what I have heard. Mr. Chatterjee, I have recorded in details. Please.
It becomes
Yes.
very difficult from the next, Milord.
From my end, I leave it to you, Lord.
1 or 2 weeks maximum. 1 week should
Within
be.
2 weeks from can come. You are uploading everything nowadays online. This can come. Only
report was directed in March.
Kyola? But not in these terms, specifying these.
There was a direction when I was directed to file an affidavit in form of report in a form of
But
affidavit.
not on this. I have
No, no, no.
directed you to file only on this specific.
I will write one line.
Yes.
I'll write one line.
I could have proceeded on the basis of your submission,
No,
but I
it's
think
better,
it's better.
It is always better for my.
You know. Within 2 weeks from date, Mr. Parties will be at liberty to.
Lordship considers it. Justice Vishwajit Basu takes every matter, Milord, to Calcutta. His lordship is very benevolent for that. Lord. It's actually good for the blood course not here.
Mention for inclusion of this matter, or after 2 weeks the circuit is there.
Yes,
The
yes.
circuit will start.
21st.
2 weeks will come, Milord, the last week of the circuit. That time.
Then I think it's better to give liberty to mention. Otherwise, fixing a date in the last week may be a difficult.
Lordship keeps it, my lord, we shall mention it before the honorable.
So I'm giving you liberty to mention.
My lord fixes it, otherwise, my lord, the hearing matter, nobody would be.
No, it is not a hearing matter.
It's not appearing in the hearing.
Not appearing at the hearing matter, but.
So now, at last, after all these 3 days, you have
That's exactly why I'm trying.
confessed that it's a hearing matter.
That's exactly why I'm saying, right? That's exactly why I'm trying to say, take it to Calcutta.
Under the heading hearing.
Hearing now.
To mention for inclusion of this after expiry of the period fixed for filing of the reports as directed hearing.
Grateful, my lord.
Grateful, your lordship.
Before my lord says.
Yes, what do you want now?
I filed an application.